list yesterday. My lord, we were for the plaintiff, my learned
What?
junior. Item 25 of your lordship's list yesterday, my lord. My lord, it is my suit. We were for the plaintiff. My learned junior was there, my lord, before your lordship. My lord, it is their application, the defendant's application. I'm mentioning on notice. Defendant's application for amendment of counterclaim. They sought for an adjournment. My lord, we were ready with the matter. Your lordship, as I understand, your lordship did not take it very well with their prayer for adjournment, my lord. That is why, my lord, your lordship has kept the suit in September with the application. My lord, it's my suit, my lord. I am suffering for, my lord, I understand, my lord. My lord, but one thing, my lord.
For the last 1 week, all the
Lord,
suits have been
I have seen, my lord,
brought on the list, but none of the advocates are coming through for the suits.
my lord,
Either advocates fallen ill or change brief or amendment or something else.
I had heard it from your lordship
So
only, my
that's
lord.
why if I
Lord, but
made up in mind, if but you're not interested, I will
my lord,
send
but
the matter
my
after the puja vacation so that the court may be vacant. This court can be utilized to other court.
my lord, just one difference here. The plaintiff is ready even today and yesterday also.
You are not present. You are
My
none
lord,
of
he
the,
was ready. My lord, it was their application.
their
Your lordship.
application from your side. No objection was
No, my
nobody
lord.
has raised any
My lord,
objection.
my learned junior was here. He said
They
he's
have not
appearing
raised
for the.
objection.
Yes, my
They
lord.
kept
That is true.
So
That
what the
is
court
true.
will,
That
what
is,
the court implied? Court
my lord,
implied that you are
yes, my lord.
the other party.
My lord, my lord, this is, my lord, I mean, your lordships and your kindly considers keeps it.
Because I am made
My
up
lord, I
mind. If in
understand.
the suit, if any advocate want the adjournment, I will give the adjournment after vacation so that
My lord,
from the month of July, so this court may be closed.
my lord, I have also reprimanded my junior, my lord, because he did not say anything, my lord. So I do not expect anything from the court side, my lord, in this matter. But my lord, kindly some indulgence, my lord. Their application for amendment of counterclaim any day, if your lordship
Once
keeps,
the suit
if
is
they
being
don't,
come as a discord in inspection, advocate change, advocate fallen ill, party is out of station. That all the stories coming.
that's true. Lord, kindly sometime, anytime, Lord, next week, next to next week, Lord, their application, which is GA3, which is for amendment of their counterclaim. If they don't press, my lord, your lordship will pass necessary orders in their application, Lord. My suit, my lord.
Yes, what is the prayer? For what?
Reading of the application, my lord.
I don't know what is the order pass. Let it be fixed.
Order is
to be mentioned.
Deeply obliged.
May I have your lordship's may I have your lordship's leave?
Mr. Sinha, inform the bar. If the bar is not interested to go with the suit, I will write the letter to the Chief Justice. All the interlocutory application is being disposed of. This court be closed till the puja vacation. Till the puja vacation, because nobody is interested to come in the suit, either framing of issue, discovery in inspection, or witness action. This court had tried to dispose of the matter through the commissioner also. None of the parties going with the commissioner for disposal of the suit. What the court will do?
I'll definitely take it up with the bar, my lord. This cannot be done. If we do not cooperate, my lord, then
that's right.
cannot.
Then I will write to the chief. The chief will forward to the Supreme Court. Calcutta Commercial Division is not required.
One prior day only, the same thing had happened in your lordship.
For the last 3 days, since Monday, I am fixing all the suits and framing of issues. Not a single issue has been framed. Not a single cases the witness has come.
Yes, lordship, lord gives me a week's time, lord. I'll definitely
Please personally to the bar. Otherwise, I have to write.
Yes. That's spring from my lord's leave, my lord, to mention, my lord, for leave, my lord, by filing an application for extension of time to file the written statement, my lord. I spring for leave, my lord.
When 120th days is going to
no, within 1 term, much within 1 term. So, my lord, I spring from the leave, my lord, to file it subject to, my lord, the application.
Leave is granted to submit in the department subject to acceptance.
Lord, I have your lordship's brief. This pertains to the determination of Honorable Justice Auditor Mukherjee. There is some urgency. I'm mentioning upon notice that there's some urgency in my application, but the meeting which I'm challenging is scheduled to be held on 22nd, this Sunday. And by that time, Justice Mukherjee will not come back. If your lordship could list the application tomorrow or day after, any day.
What is urgency?
The urgency is that a notice has been circulated. I'm a member of the Shomstha. Lordship has dealt with this matter earlier, on an earlier occasion. It's the Maintainability Shomstha. A notice has been circulated for holding a meeting on this Sunday. I am challenging some agendas which have been proposed to be discussed on in that meeting. But that is the urgency. The meeting is supposed to be held on this Sunday. If the lordship could list the matter tomorrow or day after.
No notice was given. I am here for item number 1. That's a Milord.
My lord, I am told, my lord,
First, number two, Milord.
Which item number 1?
My lord.
No, he is telling that about Court
No,
of Justice.
he has not given any notice.
my lord, I am told, my lord,
Opposing that.
Now he is mentioning of the Justice Mukherjee's court.
yes, yes, yes.
Coincidentally, I'm here. He has not given any notice.
My lord, I was told that the other side was given notice.
Now, number two, Milord. Thrice the matter was called. Several times the matter has been called by the lordship. They had taken adjournment. Record will speak for itself. Thrice the matter was called before Justice Mukherjee. They have Milord, not even Milord, found it fit to appear before Justice Mukherjee for thrice. Now, Milord, they know Milord. Last year also an AGM was Milord published. Milord recollect. Milord, that AGM Milord had granted stay till 18th of July 2024. Even there Milord thought it not fit Milord to get it extended.
But my learned friend can make these arguments, my lord, if the application could be listed. My learned friend can make these arguments, my lord, at the time of
Okay, you
hearing.
do one thing, Mr. Dasgupta. Your voice is not
Coming properly, yes.
it's not proper. You come to the court tomorrow. We'll see.
Lordships, may I mention, yes, come 70 of 2025. The Lordships, it was last, let's
Senior.
My lord, spring for my lord,
He is
my lord,
maintain
two- my lord,
seniority.
my lord, two matters, my lord, these are my lord, the application by the state, my lord, in company matters, my lord.
Which
Spring not for my lord, this is
company
my lord,
matter?
for my lord, disclaimer,
matter.
for the company matters, my lord, could be listed, my lord, next Wednesday. Two matters. If you do to Ajay,
Was दिन
I'm grateful to
दे
you.
दो देखो.
I
Yeah.
have your lordship's kind leave to mention, my lord, that this is a matter where your lordship had, my lord, directed, my lord, arrest warrant to be issued against, my lord, the judgment debtors. Now, my lord, if your lordship kindly takes your lordship's order of 11th June 2025, the matter is, my lord, made returnable on 26th of June 2025. Now, my lord, I have been now, my lord, instructed, my lord, by the, my lord, judgment debtors, my lord, that, my lord, I would, my lord, be in a position to, my lord, secure the entire principal amount. If your lordship, my lord, in the meantime, my lord, kindly, my lord, directs, my lord, the police not to, my lord, proceed with the matter. But I'll tell your lordship, my lord.
In execution, there's no question of securing. He has to pay, my lord, in the
I'll
execution.
pay, of course. There's no question of, my lord, securing the money. My lord, with regard to the entire principal amount, my lord, it's almost to the tune of, my lord, 1 crore, my lord, 40, 1 crore?
My lord, the decretal dues with
1.45
interest
crores,
is
my lord.
2 crore 8 lakh rupees.
My lord, 1 crore, that is with interest, my lord. I will, my lord, seek, my lord, some, my lord, mercy. But, my lord, be that as it may, my lord, with regard to the principal amount, my lord, the entire principal amount, 1.45 crores, my lord, we are willing to, my lord, pay at a go, my lord. But, my lord, only difficulty is that, my lord, if my learned friend, my lord, provides a bank account, my lord, I would take, my lord, 2 days time, so that if there is, my lord, some default in, my lord, the electronic transfer, I am not made hauled up. So, my lord, I would only beseech 2 days time after I get, my lord, the bank account from my, my lord, learned friend. My lord, your lordship, my lord,
Okay, please.
this is the bank account, my lord, we have.
Fixed tomorrow has to be mentioned.
To be mentioned.
My lord, I shall provide the bank account right away.
You provide in the meantime. You provide it.
Yes, I'll do it right away.
Very well. And I have, my lord, the wakalatam and the affidavit of
Okay, I am
competency.
fixing tomorrow has to be mentioned because please you provide the
But
bank.
in the meantime, my lord, if your lordship, my lord, so directs that the arrest warrant should not be, my lord, executed.
I mean, no, my lord, this unless payment comes, my lord, I cannot. And this is without prejudice to my rights, my lord, because
Okay,
yes,
because if, my lord, they are hauled up, my lord, they would be in an embarrassment. It's not.
Okay.
they have not appeared before. They have chosen for this discomfort, my lord. They've never
Okay,
appeared
if
before the
it
court.
is so, please, Mr. Singh, see that the warrant you
Well,
stay.
we have already perhaps put in this the requisites before the department, my lord, for issuance of warrants. It's beyond our hands now, my lord. Perhaps it's on the way,
This is
or
why-
perhaps it has reached to them. This is why, my lord, they
This
have
is why, my
approached.
lord, after I receive the, my lord,
Okay,
affidavit
come
of-
tomorrow. Come tomorrow.
Very well, my lord.
Very well. Very well.
Yes.
Lordships, may I mention CS come 70 of 2025. My lords, the matter was last listed on 10 June 2025. Last opportunity, my lords, the time was extended to file the oppositions by 16th.
Opposition of GA.
Yes, my lords.
Yeah.
My lords, we are seeking an interim order. My lords, the oppositions have not
My lord,
been
it's,
filed. I'm
it's a
praying.
voluminous application, my lord. We just need, you know, 3 more days time, my lord, till Monday, my lord, to
Which
file.
matter?
My lord, this same,
Yes,
which my lord friend is
of
mentioning.
2020.
When it
This come 70 of
So it's a
2025.
very voluminous application, my lord. So that's why it's taking little time, my lord. But Monday, by Monday, my lord, we are not the principal defendant, my lord. I'm
it is fixed on 23rd June.
My lords.
Okay, in the meantime, you
yes,
find it.
before well before that. Lord,
That you
well,
My lord, may I be permitted to mention a matter, company matter for
May I have my lord's leave to mention, my lord, item number 8 of today's list. My lord, we wanted to take inspection of the court records, my lord, but because the file is here, we couldn't. If my lord kindly grants us leave, I can take inspection
Yes,
right now before my lord's court officer. I'm extremely grateful. Item number 8 to court.
Yes, next.
This is my suit. Both the suit for recovery of money and go on the account of transport. Now both the parties the plaintiff and the defendants are within. Now the plaintiffs have received the work order within. That my lord will find not having it. Yes, my lord will find at paragraph 6, page 3.
Yes.
Now plaintiffs have also issued their invoices within and received by the defendant within paragraph 15.
Yes.
Now there are diverse letters for demand, that is at paragraph 16, both received and issued within. I am seeking leave under order to rule 2 and clause 12 and no starter report has come, non-starter, that is at page 109. I have ventilated I have exhausted my remedy of 12A. And part payments were also made within.
When it was made?
August 2020, 16th August 2022, then 30th August 2022, then lastly till January 9, 2023.
Okay.
That is at page, these three paragraphs are 25, 26, 27. Credit note was issued in 2021. That will find at paragraph 35. TDS certificates were issued and credit note 16 November 2021.
Yes.
Order to rule 2 and clause.
Why order to rule 2? Money suit.
Knows who starts this suit, who gets this done subsequent events.
So and so occurring for the plaintiff. The plaintiff has filed the suit for decree for an amount of rupees 29,26,327 and an amount of rupees 11,90,467 along with interest at the rate of 12% per annum and consequential reliefs. Counsel for the plaintiff submit that the plaintiff is within jurisdiction. Both the parties are within jurisdiction of this court, but part cause of action arose outside.
For order to rule 2 and clause 12 I have to come before your lordship.
Why clause 12?
Clause 12 because part is within, because the delivery was to be made outside in Bangalore.
Arose outside of jurisdiction of this court and part cause of action arose within the jurisdiction of this court. As such, the plaintiff prays for leave under clause 12 of the latest patent. Police counsel for the plaintiff further submit that there may be a future claim which may arise in respect of the same cause of action, and as such he prayed for leave under order to rule 2 of the CPC. But the learned counsel for the plaintiff peruse the materials on record and the pleadings. This court find that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Accordingly, leave under clause 12 of the latest patent is granted. And leave is also granted under order to rule 2 of the CPC. Plaintiff is admitted subject to scrutiny. Good.
For balance price of goods sold and delivered.
Yes.
Non-starter report is at page 1066, volume
106.
1066, volume 8. Your Lordship, I am praying for leave under clause 12, my lord, in the facts stated in paragraphs 36 and 37 of the plaint. Page 15, my lord, is paragraph 36.
Yes. When the last payment was made?
Last payment has been made on February 2025, 5th February 2025. The dues relate to the financial year 2024-25.
So and so appearing for the plaintiff. The plaintiff has filed the present suit, pleading for decree for a sum of rupees 7,26,26,893.81, along with interest at the rate of 9.75%. Full stop. Counsel for the plaintiff submitted the part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Accordingly, the plaintiff prays for leave under clause 12 of the latest patent. But the learned counsel for the plaintiff perused the plaint and the materials on record. This court finds that part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. According to clause leave under clause 12 of the latest patent is granted. Plaintiff is admitted subject to scrutiny.
It's my application seeking judgment upon admission. Millard, I have not served notice. I'll be seeking an injunction.
Seeking an injunction?
Yes, because Millard, entire claim is admitted by issuance of PDC and getting dishonored. And Millard, several Millard section 7 proceedings are pending.
Defendant entered appearance. Defendant
No.
entered appearance.
No, Millard, it's being presented on 2nd of May before your lordship. Then Millard, it was
New
matter. Then Millard, it was into scrutiny. Now Millard, kindly Millard, there were work orders for Millard transport. Kindly Millard, page 28 to 37. The work orders are there. 10 numbers of work orders.
What is the materials?
Millard, I am a transporter. Equipments are to be delivered. Same Millard like item number 1.
Okay.
Now Millard, by Millard 16th March 2022, kindly see Millard the letter at page 52. Work orders are at page 28 to 37.
Page 62.
Page 52. Millard 52.
Yes.
Now Millard sees, please refer to the communication we had on by their letter. We have agreed to make the payment to you against your payable dues as per mutually agreed plan. Accordingly, we are releasing you the post-dated checks. Now Millard, 5 checks issued. Now Millard, the first check, Millard, they have Millard paid by bank transfer. We have returned the check. 15 lakhs gone. The second check, Millard, got dishonored. That Millard will find at page 53. Next page.
Yes.
It got dishonored. Millard, I lodged a proceeding under section 138. Millard, then he paid the amount of 10 lakhs. That Millard will find, Millard, then I withdrawn the complaint before bank shall court. Page 63.
It's also paid.
It's also paid.
Yes.
Now, Millard, remaining 30 lakhs, Millard will find the checks and the dishonor slips. First check, Millard will find at page 65. Dishonor slip at page 67.
65.
65, 67. First check. First check is 65. Dishonor slip 67.
Yes. What is the reason?
Unable to remit.
Okay. Next.
Then Millard second check.
These 3 have been dishonored.
This is my only principal claim.
Yes.
Now Millard, they have not come before
claim 30 lakhs.
30 lakhs is the principal, rest is interest. Now Millard, entire claim is Millard admitted. They can't avoid. Now Millard, my mediation application is at page 72. They have several communications were made by the mediation Millard council. Millard page 83. After that, they have dropped the mediation 83. Now Millard, I apprehend that Millard, the company has no substratum to pay. Millard, I have a Millard bank account. Kindly Millard, protect me to that extent of 30 lakhs Millard principal amount. Prayer B. Then I'll Millard, sir, Millard, there are section 7 proceedings pending. I have also got one of them, the order.
Section 7 against
this defendant.
Where is that order?
Millard, this is the order. Subsequently, they entered into an OTS with Bank of Baroda that got it settled. This is the status report. Just this morning, I could have included this. NCLT portal doesn't work. Millard, I've got the order. Last order. Oh, no, sorry, Millard, I have handed over two copies of the same.
Take this.
Yes. This is, Millard, the last order. So, Millard, they are habitually defaulted. Banks have lost Section 7, ultimately got it settled. I'm only seeing prayer B at this moment. From this account, they have issued the checks which got dishonored. I hope, Millard, there is nothing.
There is any amount in the account.
I hope there is nothing for the satisfaction, Millard, of Millard, kindly grants me prayer B. At least, Millard, if something comes, Millard, that can inure to the benefit of the plaintiff.
Consequence suffering for the plaintiff. The plaintiff has filed the present application.
Order
Praying
12
for
over 6.
judgment upon admission and interim order. At present, the plaintiff is only praying for ad interim injunction. Counsel for the plaintiff submit that the defendant has issued the work order to the plaintiff, and accordingly the plaintiff has executed the work order, and subsequently, as per the invoices raised by the plaintiff, the defendant had issued 5 checks for a total sum of rupees
45 lakhs.
45 lakhs.
No, beshi mona hai na?
45 lakhs by a communication dated 16th
lakh.
March
I'm so
2022
sorry, it must be 55 lakhs.
of South India Bank Limited. Out of the 5 checks,
No, no,
2
10,
checks
25, 45
amounting to
55 lakhs. Total
that's
amount
55
lakhs.
lakhs.
Sorry.
55 lakhs. Out of 5 checks, 2 checks amounting to rupees 15 lakhs and 10 lakhs. And out of the 5 checks, out of the 5, क्या बोला? 5 check, one checks being check number 002486 was
Paid by
initially
bank transfer.
dishonored.
No, 15 lakhs was paid by bank transfer. I returned the check.
With respect of the check number so dated 24th March 2022, the plaintiff and the defendant has transferred the said amount in the account of the plaintiff. Accordingly, plaintiff has returned the said check. As regard the second check dated 30th April 2022, the plaintiff has deposited and presented the same for encashment, but the same was dishonored. Subsequently, when the plaintiff has initiated the case under Section 138 of Negotiable Instrument Act before the appropriate court of law, the defendant has paid the said amount. Now the remaining 3 checks amounting to rupees 10 lakhs each, the plaintiff has presented the said checks for encashment, but the same was dishonored. After the dishonored, plaintiff has informed the defendant for refund of the for payment of the said amount of rupees 30 lakhs along with the interest, but neither the plaintiff has come forward, but the defendant has not paid the said amount. The counsel for the plaintiff submitted the plaintiff has initiated pre-institution mediation process. In spite of the receipt of the notice, the plaintiff has not come forward, defendant has not come forward to settle the issue. Accordingly, the plaintiff has filed the present suit along with the present application. Counsel for the plaintiff submit that it is admitted by the defendant that amount of rupees 30 lakhs, principal amount of rupees 30 lakhs is due to be paid by the defendant to the plaintiff, but in spite of the same, the defendant failed to pay the same. Counsel for the plaintiff further submitted the plaintiff came to know there are several dues are pending against several parties as well as against the bank, and in one of the cases, the Bank of India has also initiated a proceeding against the defendant under Section 7 of the Insolvency and Bankruptcy Act before the London Tribunal.
Code, Millard, bankruptcy code.
Insolvency and Bankruptcy Code 2016, and the same is pending before the
No,
London
it's
Tribunal.
post up, they got it settled by OTS subsequently.
क्या बोला? In one of the claim, Bank of India has initiated a proceeding under Section 7 of the IBC Code, and during the pendency of the said case, the defendant has settled the dispute with the Bank of India. So counsel for the plaintiff submits that there is every chance that the defendant will siphon off the amount, and the defendant has agreed, has admitted the claim of the plaintiff, and if an entry order is not passed, there is every apprehension the defendant will siphon off the amount, and in case in future the plaintiff will get a decree, the same will only on the paper, and the plaintiff will not be in a position to execute the decree. Consider the submission made by the counsel for the plaintiff, peruse the materials on record. As per the record, the defendant has issued work order. Accordingly, the plaintiff has executed the said work order. Upon completion of the work awarded to the plaintiff, the defendant had issued checks out of the total 55 lakhs. Only 25 lakhs have been paid, and remaining 35 lakhs is due. The defendant has issued the checks have been dishonored, but in spite of the repeated request, the defendant has not paid the amount. It is also found that the defendant, the Bank of India has also initiated a case under the IBC, and during the pendency of the said case, the defendant has settled the issue with the Bank of India. Considering the above case, this court finds that the plaintiff has made out a prima facie case and balance of convenience and inconvenience in favor of the plaintiff. This court also finds that if at this stage an identity mode is not passed, the plaintiff will suffer irreparable loss and injury. In view of the above, identity injunction in terms of prayer B is granted till आज कितना तारीख है 18 है ना, till 16th of July 2025. The plaintiff is directed to serve the copy of the plaint, documents from injunction application, and the interlocutory application along with the document to the defendant forthwith, and to file affidavit of service on the returnable date.
The plaint of summons already served. If not, yes.
That is 3A. List the matter on 16, है ना?
Millard, I think last Millard has dictated 35. That will be 30.
30.
Oblige.
Next.
16 July.
My lord, I am
সেদিনই রেখেছে, সেদিনই।
plaintiff petition.
Yes.
My lord, this is just in nutshell. I will refresh the matter which was partly heard by your lordship before. My lord, this is a case where the plaintiff petitioner is a borrower of Lakshmi Vilas Bank, which is now named as DBS Bank, and they have given some security of a company which was wrongly debited and invoked by the bank, for which the plaintiff petitioner made a claim, and a major amount was refunded to his account. In spite of that, amount of more than 2 crore rupees still remained, which the plaintiff claimed from the bank to be credited to his account. In spite of that, it was not credited, though the previous action says that his claim was rightly made, and not crediting this amount, the account was, for shortage of fund, was declared NPA, and the other proceedings started. Now my client have made the claim before your lordship, before this court, honorable court, and have filed the suit for recovery of those wrongly debited amount to his account, and his suit was filed on, my lord, I have brought the case status, my lord, may I hand it over? The case of the plaintiff was filed on 1st April 2020, 1st September 2021, my lord. And my lord will find an order on the next page, my lord, of Justice Ravi Kishan Kapoor, when he said that since this is of the commercial nature, the suit may be filed in the commercial section division, and the amount which has been paid as court fees will be utilized there. So only for the purpose of filing in the commercial division, the suit was returned, and again it was filed in the commercial division. What happened, my lord? The defendant bank, then in the meantime, they have filed a suit in the bank tribunal, OA application. And our proceeding went on, and we were not even aware of that proceeding, and we have filed again, refiled, in fact, refiled this suit in the commercial division. This is the, actually, as your lordship has on the last occasion has said how this suit is maintainable before your lordship. For that point, my lord, I am putting forth my argument, and for the merit, I will come later, my lord, after satisfying your lordship about the maintainability of the case before your lordship. My lord, I will like to hand over the Supreme Court case of 22, my lord, 2022. It is also reported, this is Bank of Rajasthan versus VCK shares, wherein, my lord, my lord, the Honorable Apex Court has held that the suit filed by the borrower is maintainable before the civil court, and it will continue independently, and the filing of this suit will not hamper the suit or application filed by the bank before the debts recovery tribunal, and civil court has every power to try and dispose of this suit independently, my lord. And also the question of transferable power to transfer from the civil court to the DRT, the suit of the borrower, is not there, my lord. And it has been dealt, my lord. Will come to paragraph 45 onwards. May I please, my lord?
Yes.
The crux of our discussion, my lord, my submission is onwards from paragraph 45. We are thus of the view that there is no provision in RDB Act by which the remedy of a civil suit by a defendant in a claim by the bank is ousted. But it is sorry, my lord. But it is the choice, but it is the matter of choice of that defendant. Such a defendant may file a counterclaim or may be desirous of availing the more strenuous procedure established under the code, and that is a choice which he takes with the consequences thereof, my lord. My lord, may I continue? Next paragraphs.
Yes.
We may notice that the RDB Act was amended from time to time, including by amendments made under so and so and so. The anomaly inter alia initially sought to be cured was on account of the non-availability of provisions on counterclaim and set-off. It is to get over such a scenario that amendment through Act 1 of 2000 was made by the legislature itself to cure the problem. The legislature did not at any stage make any further amendment for excluding the jurisdiction of the civil court in respect of a claim of a defendant in such a proceeding being filed along with the suit. The legislature, in its wisdom, has also not considered it appropriate to bring any amendment to enhance the powers of the DRT in this respect. We may also refer to the judgment of court in Transcourt Supra opining that DRT, being a tribunal and a creature of statute, does not have any inherent power which inheres in civil courts, such as section 151 of the code. We now draw our attention to chapter 5 of RDB Act, which deals with recovery of debt determined by the DRT. Section 25 of RDB Act prescribes the mode of recovery of debts, which takes place pursuant to a certificate issued under subsection 7 of section 19 to recover the amount of debt specified in certificate by any of the modes specified therein. The expanse of the reliefs the defendant may claim in the suit proceeding can certainly go beyond mere adjustment to the amounts of the claim for which the DRT would not have any power. Now, turning to the issue of the power of the civil court to transfer an independent proceeding instituted by the defendant to be tried along with a recovery proceeding before the DRT. There is again say that there is no specific power to transfer a suit to the DRT. Plaint can be returned only under the provisions of Order 7, Rule 10 of the Code for the reasons specified therein. In the absence of such reasons, Section 151 of the Code cannot be utilized as a residuary power to achieve the transfer, which is really a consequence of the return of the plaint when the grounds under Order 7, Rule 10 of the Code are not satisfied. The absence of any legislative power cannot give a power by implication to the civil court. We believe that it would not be appropriate to read such power to transfer a suit to DRT under Section 151 of the Code when the DRT is a creature of a statute and that statute does not provide for such eventuality. We must also notice an important aspect that even where a defendant is to invoke the jurisdiction of the DRT by filing a counterclaim, the bank has a right to seek a relegation of that claim to the civil court, and the DRT has empowered to do so, albeit at the final adjudication stage. This is so in view of the summary nature of the remedy provided before the DRT, and thus, if certain inquiries beyond the contours of what DRT does are envisaged, a civil court remedy may be considered as appropriate.
Yes.
Now, my lord.
Yes.
Now, coming to the question whether the consent is required for the transfer, my lord, there is no question of consent, so I'm not going through this paragraph, my lord.
What is your case?
My case is, my lord, the bank has wrongfully debited my account and which they have admitted by their action by refunding a major amount of the amount which was more than 10 crores, and now remaining 2 crores was remaining when the bank has not credited to my account, and in spite of I am liable to get back that amount, my account has been declared NPA and they have proceeded according to the RDB Act. My suit was filed before your lordship, before this court, prior to the bank suit, to recover that amount and which has to be credited to my account.
Prior to the bank suit means?
Bank,
DRT?
yeah, yes, my lord. That prior to the bank which has filed before the DRT. And this suit is that suit where I have in the interregnum, we have received a letter from the bank that they have assigned they have transferred their assets to the asset recovery construction of Omkara, and now they have written a letter that they will not, they are no more involved in the suit and we should deal with Omkara. My lord, for that reason, we have taken out this GA5, my lord, where we have prayed that this Omkara for the liabilities cannot be transferred if they can also even they can transfer the asset, but it is their liability, and which I have prayed in this suit that this amount has to be credited back to credited to my account which they have wrongfully debited. This certain issue cannot be dealt by Omkara because liability cannot be transferred, my lord, and bank itself is responsible to appear and defend its suit before your lordship, whatever point they have to say, but Omkara cannot, in this suit, the bank name cannot be substituted with Omkara, my lord.
So what is your prayer now?
My lord, in this application,
Injunction restraining the respondent, their servant, and giving any effect or further effect to the impugn assignment agreement. Dated 23rd November 2023. When you file the suit?
my lord, it is way back in 2021 September. Then when this matter was pending, they have taken this step and they have now communicated that someone else will appear with the erstwhile advocate on record who had also appeared before your lordship, now they are not appearing, and they have stated that they have handed over the brief, and they said that the bank's letter was also received by us, that they have transferred the assets to the asset reconstruction company. My lord, our case is the liability.
You have to take appropriate step first.
My lord, yes, my lord. Our first prayer is before your lordship, the bank is the defendant, and bank has to appear and contest for the whatever liability they have got towards us. Has to be we have prayed
That's
before your
why,
lordship.
This agreement which you have challenged, that is of 2023. Correct? 23. You filed the suit in 2021. When you filed the suit, the agreement is not on record.
My lord.
Not born.
My lord.
Now you are challenging the agreement. And
My
as
lord.
per the agreement, because the bank has already transferred the liability to the Omkara.
My lord, assets. My lord.
Whatever.
My
it is,
lord.
assets
Our
have been
case is they can only transfer the assets.
Okay, whatever it is, it has been transferred to Omkara.
My lord.
So that's why the bank is not appearing before.
My lord.
Now, if the assets has been transferred to the Omkara should be a party here.
My lord.
You have not made any application for addition of party of Omkara.
My lord.
First thing. Second thing, you have not added or amended the prayer in the plaint with regard to challenging the agreement.
My
If
lord.
the agreement is not under challenge, how in the interlocutory application this court can pass an order of interim order with regard to the agreement?
My lord, I seek leave
These are the
to
two things.
my lord, I seek leave to take necessary steps and come back again before your lordship.
Omkara is not before
My
this
lord,
court.
true,
If this court
true.
pass an order, he will be affected.
My lord, true.
It's not a party. Second thing, the agreement which you want the interim order, that is not the prayer in the main suit.
Main suit.
So how the court can go on?
My lord, I will take necessary steps and come back. For that, leave may be granted.
So suffering for the plaintiff, so suffering for the defendant. Police counsel for the plaintiff, though argued the matter for some time, but prays for time for taking appropriate steps. According cases adjourned. How much time? 4 weeks.
My lord, 4 weeks is minimum necessary, my
Let
lord.
the matter appear on 22nd July. 22nd July.
My lord.
No, none of person. Next.
My lord, I'm for the plaintiff, my lord. This is my judgment of an admission application, my lord. On 7th March 2025, my lord has recorded that the service was completed upon the defendant and the summons was served only on May 16th. But 120 days has not yet expired.
The print is already taken for issuance of writ of summons.
But on 7th of March, the affidavit of service was filed. And my lord, it was been recorded that the service was done upon the defendant. It came back as unclaimed.
The GA. What about the GA?
Yeah, GA was served, my lord.
GA served.
Affidavit of service filed on 7th March. My lord, kindly take 7th March order. It has been recorded there.
7th March order.
7th March 2025.
Yes, and they filed an application on the chapter 13A of the ordinance of the council of press for time to ascertain whether writ of summons or not. Yes, what about the writ of summons?
Yes, my lord, served on 16th May.
16th May.
Yes, my lord.
I will obtain report.
Yes, my lord. Affidavit of service has also been filed.
Affidavit service?
By
This
the
is with regard to that GA.
Yes, my lord. The serif has filed an affidavit of service.
Serif has filed?
Yes. This is the copy.
Serif affidavit filed here.
Not filed.
Okay, Serif filed. तो वकील पे देखो साइन कौन का एफिडेविट किसका एफिडेविट देखा ना वो नहीं छोड़ो मेरे सामने में एफिडेविट
नहीं
no
it
is your affidavit of service which it is this application is written
but it was filed on 7th of March, my lord. I have the copy, my lord.
7th of March.
Yes, my lord.
No. But none of the consumer
In the order also recorded.
send a copy of the application along with the document through email, but none appears on behalf of the defendant.
On
But it
7th
is
March,
not, it is written unserved.
yes,
What is the
unclaimed.
report?
Unclaimed.
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 Okay, unclaimed is okay.
Good service.
Yes, then
Then my lord had directed me to issue the writ of summons. I have done that. My lord, the writ of summons came back, report that
so what about your chapter 3 and 13 application?
they are not appearing the defendant.
So you
Chapter 13 has serviced.
so what is the submission? You
They
will
are not
argue or
appearing, my lord. I cannot say anything, but one more chance, maybe I can serve again, my lord, and come back.
Lord, we'll serve, my lord, one more occasion, and on the next day we shall place our
so and suffering for the plaintiff, none appears on behalf of the defendant. Counsel for the plaintiff submit that the plaintiff is against of the copy of the application being J1 of 2025 to the defendant and will file affidavit service. In view of the submission made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 22nd July.
Deeply obliged, my lord. Deeply obliged.
Next.
My lord, my order 37 suit, my lord, wherein, my lord, they have filed the application for leave to defend, and we are at the amid of the hearing of that application, my lord. Oh, my lord.
ঠিক আছে আমি ঠিক পেছনে বুঝেছিলাম তো My lord, will last order. My lord, my learned junior who was appearing had more or less indicated about the facts and
Only citation is required to.
Yes. I'll just require a few more minutes, my lord. I'll just complete the arguments and also give the judgments. Now, my lord, I have two primary defenses. First one is, my lord, barred by limitation. And my lord, second is that my lord will see this is a suit, commercial suit, my lord, for recovery of money lent and advanced. My lord will take the plaint once. My lord will see that the plaint has named two defendants. Number one is Messrs. Skipper Furnishing Private Limited, and number two is my lord Kamlesh Agarwal.
You are appearing for whom?
I am appearing for both the defendants, my lord. I've applied on behalf of both the defendants. Now, if my lord has the plaint, my lord will kindly turn to my lord. I'll just indicate the page number. My lord will just take the plaint once. Take the plaint once. My lord will come to page number. Paragraph number 4, my lord. Relying upon the representation made by the defendants, defendant number 2 is, my lord, the director of the defendant number 1 company. As aforesaid, and believing the same to be genuine, it was agreed by and between the parties the plaintiff would lend an advance, a sum of rupees 30 lakh to and in favor of the defendant number 1 on certain terms and conditions as agreed and understood by and between the parties. The financial assistance commercial loan amounting to rupees 30 lakh, it should be, did not exceed 60%. My lord will see, they have thereafter pleaded that paragraph 7, in terms of the said letter dated 3rd of June 2014, the plaintiff by way of bank transfer disbursed an agreed commercial loan amounting to the tune of rupees 30 lakh to and in favor of the defendant number 1. Why? What I'm emphasizing is, my lord, the loan was given to defendant number 1, which is a company independent juristic entity. Now, my lord will kindly see the page number 9, the relief sought for in the plaint. The plaintiff prays for leave under clause 12 of the letters patent 1865 and claims a decree for the said sum of rupees 42 lakh as pleaded in paragraph number 15. Interest pendently and interest upon judgment. It does not mention whether it is against defendant number 1 or 2 and whether jointly or severally. Now, I am taking the worst case scenario. My lord, I am humbly submitting that in the way the plaint has been drafted, the suit has been framed, my lord, defendant number 2 can at best be a proper party, my lord. My lord, there cannot be any relief sought for against the defendant number 2 because the defendant number 2 is a director. My lord knows, my lord, Solomon versus Solomon, a company is an independent juristic entity separate from its shareholders and directors. Unlike a firm, my lord, where partners are liable, personally liable for, my lord, the liabilities of the partnership firm, the directors or the shareholders are not liable for the.
What would happen if the decree is passed?
My lord, if the decree is passed, my humble submission is that the decree can, if passed, can only be passed against defendant number 1. Since I have applied.
Okay, if passed, then what would happen to the decree? How the execution?
They will execute the decree. If the decree is against both the defendants, they will execute against both the defendants.
No,
I am
suppose defendant number 2 is one of the director.
my lord.
Okay, there is a separate entity.
Yes, my lord.
And as per the case of the plaintiff, defendant number 1 has been given the amount.
My lord.
And there is no allegation against the defendant number 2.
My lord.
And there is no relationship.
No pleading of indemnification, nothing. No personal liability of defendant number 2.
Okay, no problem. But admittedly, he is the director of the
Yes.
defendant number 1.
Yes.
Correct. Suppose
Yes,
tomorrow, if the decree is passed, not against you, the defendant number, if you have been deleted.
Yes, my lord.
And decree is passed against the company, defendant number 1. So who will be liable to pay the amount?
My lord, the company's properties and assets would be sold off, and if there is no sufficient assets, then the directors would.
Company. Who will affirm the
Who will?
affidavit of company?
My lord, I'm sorry.
Who will affirm the affidavit of company?
Will be affirmed by the director or the principal officer. But what will be the content of that affidavit of assets? Whether it will be, it is my humble submission that even if a director or an authorized person, company secretary files an affidavit on behalf of the company, affidavit of assets, the assets will be that of the company, not the personal assets. I do not want. I am.
Okay. I understand you.
Yes, my lord. My lord. On the, and just one indication, my lord. Opposition doesn't. My lord will kindly take the opposition once to GA number 2. I'm just emphasizing that there is no pleading in the plaint to show that the defendant number 2 is personally liable for the, my lord, loan granted to the defendant number 1. My lord will see.
Markings.
No.
Encash on those markings.
No, I don't want. I mean, now, my lord will kindly take their affidavit in opposition, and my lord will see that they're pleading in respect of, my lord, the defendant number 2. What they have explained in their opposition, my lord.
There are 2 separate.
Defendant 1.
There are 2 separate affidavits.
No, my lord. The plaintiff is
That's
only
right.
one. So there's only one affidavit, my lord.
Who has filed GA2?
GA2 has been filed by the defendants.
Defendant number 2 or both?
Both. My lord, both. It has been filed on behalf of both, my lord. The affirmation part is not so correct, my lord, but I would say that it has been filed on behalf of both. Now, my lord will kindly see subpara G at page 7 of the affidavit in opposition. This is their explanation.
Yes.
Further, the defendant number 2, being the director of the defendant number 1 company, has approached the plaintiff at its erstwhile office for the purpose of availing loan to and in favor of the defendant number 1 company for expansion of business of the defendant number 1 company. Moreover, the defendant number 2 has issued a check bearing number such and such dated October 1, 2019 for repayment of the principal loan of rupees 30 lakh to and in favor of the plaintiff. This check was issued on behalf of the company, my lord. Therefore, the defendant number 2 is a necessary party for the purpose of adjudication of the controversy involved in the present suit. Even in this paragraph, they do not indicate that they have a claim against defendant number 2. So, my lord, if they today say that the claim is only against defendant number 1, then perhaps defendant number 2, no decree will be passed. Defendant number 2 will be protected. But if they say that they have a claim against defendant number 2 also.
Moreover, the defendant number 2 has issued a check.
Yes, my lord. That kindly sees the check, my lord. That is annexed to the plaint. Kindly sees the check, which is at page number
47.
My
lord, page number 47, my lord, kindly comes to.
Yes.
Kindly sees that it's the check of 1st of October 2019, signed by the director, signed in the capacity of a director, my lord, not in its personal capacity. And there is no pleading also, my lord. Will find that the plaintiff is bereft of any pleading that they have, the defendant number 2 has any liability in respect of the loan granted to the, my lord, defendant number 1. Now, in this regard, my lord, I'll just rely on a judgment reported in 2009, volume 49, company cases, page 714. This is, my lord, by a single bench of the Honorable High Court at Delhi. Kindly see 714. Kindly sees, my lord, the second paragraph of that judgment. The question is, under what circumstances and on what pleadings a director of a company can be made liable in an action for recovery of damages alleging breach of contract by the company.
Where from your reading?
My lord, the judgment, second paragraph. The judgment has been delivered by Justice Pradeep Nandrajo.
Yeah, the question is under what?
Yes, the question is under what circumstances and on what pleadings the director of a company can be made liable in action for recovery of damages alleging breach of contract by the company. Here the question was damages in breach of contract, and in our present case it is, my lord, a case for money lent in advance, but nonetheless both are liabilities of the company. My lord will kindly turn to, my lord, the third page of that judgment.
Yes.
In a suit, third last paragraph, in a suit for recovery of money, only such persons can be impleaded as defendants against whom averments are made, which on proof would entitle the plaintiff to a decree, whether jointly or severally, or in the alternative against the said persons named as defendants. The other facet of the aforesaid proposition of law is that there must be a cause of action disclosed against a person impleaded as a defendant. Learned counsel for the petitioner did not dispute that in the plaint there is no assertion against defendant number 2 that he personally undertook or agreed to clear any liability of the defendant outstanding against the plaintiff. No guarantee or indemnification has been pleaded. Same is the case at hand also, my lord. But submission of the learned counsel for the petitioner is that every director acts as the agent of a company, and therefore as an agent, a director would be personally liable if he has acted on behalf of the company. My lord, thereafter kindly comes to the second last paragraph of that judgment. It is settled law that a company is a juristic person, therefore a company has to act through a living human being. Collectively, decisions on behalf of the company are taken by the board of directors of a company. An individual director has no power to act on behalf of a company of which he is a director, unless there is a specific resolution of the board of directors of the company giving specific power to him or her, or where the articles of company confer such a power. Directors of companies have been described as agents, trustees, or representatives of the company because of the fact vis-a-vis the company they act in a fiduciary capacity. They perform acts and duties for the benefit of the company. Thus, directors are the agents of the company to the extent they have been authorized to perform certain acts on behalf of the company. But directors of a company owe no fiduciary or contractual duties. My lord, they have pleaded that there was under a contract they had given us the money. But directors of a company owe no fiduciary or contractual duties or any duty of care to third parties who deal with the company. This distinction has been ignored by the learned counsel for the petitioner. Directors of a company are referred to as agents of the company in the context of their fiduciary duty to the company, and therefore, if they derive any personal benefit while purporting to act on behalf of the company, they will be liable to the company and its shareholders. But the directors cannot be treated as acting as agents of the company in the conventional sense of an agent vis-a-vis third parties. Why not? The plaintiff is a third party. As conventionally understood, a person acts as an agent for a principal and represents the principal before third parties. Such contracts which are concluded by the agent on behalf of the principal with third parties would bind the principal to the third party, which is, my lord, the company. Then the section 230 of the Indian Contracts Act have been set out, my lord. Last two lines, a perusal of section 230 of the Indian Contract Act 1872 shows that unless an agent personally binds himself, an agent is not personally liable for contracts entered into by him on behalf of his principal. I may note an exception. The exception is where an agent has contracted on behalf of a principal who is unnamed and undisclosed, which is not the case here. The company is a disclosed entity. To interpret the law as is sought to be projected by the petitioner would mean negation of the concept of a company being limited by its liability as per the memorandum and articles of association of the company. Other than where directors have made themselves personally liable, that is by way of guarantee or indemnity, etc. Liabilities of directors of a company under the common law are confined to cases of malfeasance and misfeasance, that is, where they have been guilty of tort towards those to whom they owe a duty of care, that is, discharge of fiduciary obligations. Additionally, qua third parties where directors have committed tort, to the third party they may personally liable. Then an example, but my lord, then second last paragraph of that page, but this liability would not flow from a contract, but would flow in an action or tort. The suit which is before my lord is not is for breach of contract, non-payment of money under the contract. The tort being of misrepresentation of inducement and causing injury to third party, having induced a third party to part with the money. So my lord, this is what I'm relying on to say that the defendant number 2 cannot be held liable when admittedly the loan was given to defendant number 1.
Yes.
Now my lord will kindly take their affidavit in opposition, and my lord will see the list of dates, how they have stated that the suit is within the period of limitation. Kindly comes to my lord, page number 6, my lord. Kindly see period of limitation for filing suit 3 years. Defendant issued a check on 30 lakh on 1st of October 2019. Actual period of limitation for filing suit 1st of October 2019 to 30th of September 2022. Exclusion of period as per the order, my lord. Suit filed on next page, page number 7, May 21, 2024. Well, this is an incorrect statement. Serial number 6, suit was filed on 21st of May 2024. My lord, will kindly take up the Code of Civil Procedure once. I'm relying on Order 4, Rule 1, my lord.
So as per you, when the suit is filed?
My lord, as per me, my lord, according to me, the suit was filed on, my lord, 18th of June 2024.
Yes.
My lord will kindly take CPC, Order 4, Rule 1. June. My lord, institution of suits, Order 4, Rule 1. Every suit shall be instituted by presenting a plaint in duplicate to the court or such officer as it appoints in this behalf. So, my lord, as when a plaint is presented, my lord will see that I went through the order sheet, my lord. The plaint was presented on 18th of June. That order is available with my lord's records, my lord.
Yes.
That's an admitted fact.
Yes.
Now, I don't want to go forward with the question of limitation, but I only want to indicate this one thing, my lord. Limitation being a mixed question of fact and law, they have to prove certain facts, because this is not a case where the suit is squarely within the period of limitation. Even, my lord, if one takes into account the order granted by passed by the Honorable Supreme Court. This, my lord, will find from their affidavit in opposition. When was the loan granted?
You have issued the check on 1st of January, 1st of October,
October 2019, my lord.
2019.
Yes,
so,
my lord.
so 3 years starts from there. When it was dishonored.
My lord, even before 1st of October 2019, my lord, that is taken to be an admission of liability. That because I have issued a check, so from there fresh period of limitation will start.
Correct.
That is not when the limitation initially started. Initially it started, my lord, on 3rd of June 2014.
That's correct, but it is continue, and you have accepted that, and you issued the check on 1st of October 2019.
Yes, my lord, that I would have wanted to say something, but it is not mentioned in the affidavit in opposition. The check was given as security, my lord. The amount was blank, the date was blank, it was signed. Now, I can understand that that check is absolutely valid check. I have given it as security. They have within their rights to fill in the, my lord, the amount and the date and put it for it. First of all, this check was never presented for encashment. The check is being used only for the purpose of acknowledgement. It was never presented. It was never dishonored. Now, although that is not mentioned in the affidavit in opposition, I would like to contend that the check was issued at the time when the loan was granted as a security in 2014. Date was not mentioned. It was simply handed over. So, my lord, by putting in a date,
that is not the case you made out.
I'm saying that. I'm saying that. I would have liked to say that it's not in the affidavit in opposition, but I must be candid before my lord that I have not pleaded that in the affidavit in opposition. In my application. In my application, I have stated that, my lord, the check was never presented for encashment, and that's why there is no cause of action.
Okay.
Now, my lord, my last point, my lord, is perhaps my
when you received the last payment.
My lord, I received payment only once, my lord, 30 lakh of rupees on, my lord, June 2014. 4th of June 2014, that is when the loan was granted to me. It was an account transfer. I received the money from the plaintiff in the account of the defendant number 1. That, my lord, will find in the affidavit in opposition itself. My lord will see, my lord, paragraph number F subpara 2. They themselves have stated the plaintiff being, that is at page 4, my lord, of the affidavit in opposition. The plaintiff being NBFC on 3rd June 2014 has lent and advanced a sum of rupees 30 lakh to and in favor of the defendant, which was agreed to be repaid in its entirety by the defendants within 120 days. Now, whatever I had submitted in respect of limitation, I had already indicated. I'm indicating it again, my lord. It's not pleaded in my application. Now, my lord, my last point is that this is my lord, a summary suit under Order 37, a summary suit which is commercial in nature. Now, I have to be strictly following the procedure and the rules mentioned in Order 37. Order 37 provides that 2 times summons will be served upon the defendant. The first time it will be a summons under, my lord, I believe in form number 4, My lord, summons, once I receive the summons, I have to enter appearance. After entry, I have to enter appearance within 10 days. After entering appearance, I'll have to, my lord, inform them that I've entered appearance. Then I file an application, my lord, for leave to defend. If that is dismissed, then they get entitled to take out another summons for judgment. Now, my lord will see in my application, I have pleaded, if my lord kindly comes to page number 7, my lord.
What is your application for?
My lord, my application is for, my lord, leave to defend.
Leave to defend.
Leave be granted to defend, my lord. That prayer, my lord, there is also a prayer for condonation of delay. That I'll indicate later on, my lord. Kindly comes to paragraph number 5 at page number 7 of my application.
Yes.
The defendant has received the writ of summons on 30th September 2024. So I had to enter appearance within 10 days. As soon as the defendant received the same, the defendant directed their advocate on record to take necessary steps in the matter. The advocate on record of the defendant advised the defendant to enter appearance in the suit and file an application for leave to defend within 10 days. Accordingly, the defendant instructed the advocate on record to do the needful immediately. The defendant signed Vakalatnama and affirmed an affidavit of competency on 6th of October 2024. However, the same would not be filed in the department as the filing clerk of the advocate on record was absent on 7th October and 8th October. Thereafter, the High Court at Calcutta was closed on 8th October to 3rd of October. So, my lord, I had to enter appearance, my lord, within 10 days, that is by 10th of October. Now, the High Court closed for, my lord, the puja vacations.
Why 10th of October?
Because 10 days from the date of receipt of summons.
So you received on
I received it on 30th of September 2024, the last day of September. So, my lord, 10th of October, I had time till 10th of October. Now, my lord will see that the court closed for vacation, puja holidays, my lord, after 8th of October 2024. And, my lord, it reopened on 4th. The defendant filed the Vakalatnama in the aforesaid said on 4th of November 2024. So, my lord, immediately after reopening, I filed. There was a delay of 1 day, my lord. I'm saying because it had expired during the vacation. Okay. So, my lord, that's why I have prayed for, my lord, condonation of delay of 1 day. One last aspect, my lord. There is a chance, my lord, subject to my lord's kind consideration, that my application is premature. Because it is my contention that the writ of summons which was supposed to be served on me in accordance with Order 37, my lord, post which I will apply for leave to defend, my lord, was not done in accordance with the provisions contained in Order 37. Kindly takes, my lord, Order 37 once.
It had 11:30. Come on the next day.
My lord, if my lord gives me 5 minutes, my lord, I'll finish.
Next matter is there.
Very.
Princess and suffering for the plaintiff. Princess and suffering for the defendant. The defendant has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear tomorrow. Come tomorrow?
I can come tomorrow, my lord.
Tomorrow.
Yes, next.
Day after.
Before your lordship takes up this matter, I need to inform one thing. That section 106, whether commercial or not, that reference matter, that was appearing as for judgment today, and it was held as commercial. We have not seen the judgment because it has just been delivered now. So your lordship's judgment has possibly been, that portion has been.
Okay.
Not statutory.
Good. Both proviso clauses.
But we have not seen the judgment. It's just been delivered about 20-30 minutes back.
Okay, okay. Thank you.
Section 106 to commercial. Commercial.
May it please, my lord.
Yes.
And I'll begin by dealing with the modification of the contract point that was left in the award. I had to place that from paragraph 20. But before I do so, my lord, we'll take volume 1, the counter statement. 55, page 55, it begins.
57.
Page 55 is the counter statement of the respondent.
Okay.
Now, if my lord comes to page 57, paragraph 11. No, I'm sorry, my lord, page 56 first. Page 56.
Yeah.
Paragraph 7.
Yes.
On 31st December 2006, an agreement was executed between the claimant and respondent with the terms contained therein. A copy of the agreement is enclosed. So they rely on this agreement, they enclose that agreement. Now the point is being taken in desperation that this required registration and your lordships cannot look into it. They themselves rely on this document. Now, if you turn the page, Malad, paragraph 11. What is their case as far as this alleged supplementary agreement is concerned? The respondent states that pursuant to the completion of the said unit, the respondent by a meeting held on 27 September 2012 with the representatives of the claimant, it was agreed upon by the parties that due to certain unavoidable circumstances, the said clauses of the agreement requires to be modified and a fresh supplementary agreement with regard to the said unit is to be entered into. So, my lord, is to be is important in future. So, then it is pertinent to mention here that the representatives not only represented the claimant, but also other purchasers, more fully known as SBP customers. And there are other parties, there are 3 parties, etc., had agreed upon a fresh supplementary agreement would be entered into upon in view of the said clauses being 7, 8 and 9 of the original agreement being modified, and a fresh agreement again would contain new revised rate both on account of consideration for transfer of the units and car parking area as the respondent could not procure a tenant as agreed in the agreement. So they admit their breach and they say that we will enter, it will be entered into, would be entered into, etc. So if I pause here for 1 minute, the meeting on 27 September, besides the fact that none of our directors or employees were there, they admittedly, it was a broker who was representing several others. So my lord, you book a flat, and make an investment, and one day you hear from your broker, the same person, oh, we've changed it, now you don't get any interest, we are giving you a discount and you take this flat. And a fresh agreement has been entered into. So this minutes itself was not signed by us, so it is not an agreement in itself. They say a fresh agreement. Now the next paragraph, very important. It is pertinent to mention here that all the aforesaid 5 unit purchasers, we are not concerned with the others anyway, including the claimant, accordingly made payments towards the consideration at revised rate as agreed upon between the parties and took possession of their respective units. But it was categorically submitted also by my learned friend that they have not taken possession. And possession, as per the agreement, that possession date has no tenant has come. So this is also incorrect. Then apart from the claimant, all purchasers executed supplementary agreement. So they are admitting that we did not execute a supplementary agreement. Apart from the claimant, all purchasers executed a supplementary agreement and had started paying CAM charges, that's common area maintenance charges, as agreed upon in the aforesaid minutes dated so and so. And 3 of the other purchasers have executed registered deeds of conveyance. Supplementary agreements entered upon with the aforesaid 4 purchasers are enclosed herewith. Completely irrelevant. Those agreements are there. Those agreements say that these clauses will no longer apply and the revised rate will be this, and we are handing over possession and the conveyance will be done in meantime. Now, if my lord sees the minutes, where did I write that thing? Page 85, my lord, will come next. So this is their case.
Yes, page.
One more thing, at page 58, I was after 12, 15, just the respondent thereafter in view of the revised terms of the agreement. So they are just assuming now that it has been revised, which was to be entered upon between the parties, requested and demanded a letter 1st October to pay such and such sum. Now this letter there's another letter of 28th September. Yes, Manoj, that's at paragraph 14. Neither the letter nor this invoice of 1st September mentions any revised agreement. It simply was sent to us, and our witness has said whatever was demanded of us, we have paid. So just by insinuating that I have given you a bill for a lesser amount and you've paid it means that you've entered into a categorical contract, and that also there are two limited companies. Whether there can be an oral agreement at all, and that's also not their pleading. Their pleading is we did not enter into it. So so with this background manner and pleading, and this was accepted by all the witnesses, no one's case is different as far as the evidence is concerned. I can show, my lord, even the witnesses, our witnesses, all denied that it was our representative was there. And in any event, it is admitted by them that it was not signed by the director or employee, and the supplementary was never signed. So in this connection, if I may come back to the award, that's at volume 4. I was at paragraph 20 of the yesterday. Paragraph 20. Really, paragraph 20 to 33 deals with this modification. And what the arbitrators have really done, I wanted to place the facts so that the stand is there. The stand was accepted. They have expressed why this is unbelievable, that a hard-nosed businessman will make such a deal. So casually, someone will give away this interest. So a lot of it is that I'm reading it. The sentence is very long. My lord, I was trying to read it. It's one sentence, I think, literally, paragraph 20. But I'm just placing it so I can be complete. The respondent founded a further defense to the claims on a much broader basis by contending that the original paragraph 20 is page 675. Modification and counterclaim. We have 675, volume 4. Sorry, it's a part of the award.
Yes.
Well, there's two bits of the award I haven't placed before. I'll come back to those are the on interest and the rate of interest.
Yes.
But this is the main point, because if they succeeded here, my 7 and 8 and 9 clause would have gone, and I would not be entitled to any interest. Then, so both their main points, one is registration and this, they go to the root. If they succeed on that, I get nothing. But as far as if they don't succeed, they have not challenged the rate of interest. They have not challenged that the terms were unconscionable, etc. We never agreed to pay him this amount. And even the dates, I'll show the charts. They have also given their calculations by charts. I'll show that. And then I'll deal with the cases and I'll complete. 20. The respondent founded a further defense to the claims on a much broader basis by contending that the original agreement stood modified on basis of verbal agreement between the respondent and some other intended purchasers or unit holders at a meeting held on 27 September 12, which, so far as the claimant was concerned, in effect relieved the respondent of its obligations under the original agreement from procuring tenants for the entire booked area at a minimum return of 13.42% on the aggregate booked amount, car parking amount and extra as stated in the main agreement. And the said provision would be treated as deleted in consideration of a commensurate rate per square foot of respective units. In the case of the claimant, the rate would be 1,666 in place of 2,325. And as regards the car parking rate, instead of 13 lakhs instead of 26. This is their contention.
Yes.
In addition, amongst other things, it was also agreed by the respondent at the meeting that since the completion certificate had been obtained, possession of the units for fit-outs would be given with immediate effect, and that the parties have agreed to commence fit-outs, and consequently, the claimant and other unit holders would be liable for common area maintenance charges per square foot with effect from 1st October. The purported modifications were recorded in minute, though not specifically mentioned. The suggested modifications apparently referred to and intended to amend and delete provisions 7 to 9, though not deleted in a clear fashion. So this is the history. What they are saying, these clauses are deleted. I have given you possession. You have to give me CAM charges. The respondent also founded its counterclaim by way of CAM charges. Then 22. On the purported modified agreement. Two things about the modified terms as contended by the respondent must be noted at this stage. First, the meeting held on 27 September was a kind of community meeting between the respondent and representatives of other unit holders, if not all, and it was not a face-to-face meeting with any director of the claimant or respondent. Number one, it was a discussion. Secondly, the minutes of the meeting itself records that a supplementary agreement on the basis of such deliberation would be executed between SBP. And I haven't placed the minutes, but that is their case in their counter statement also. So these two things they note initially. Then, before proceeding to examine the merit of the defense and counterclaim, we must record our appreciation for the consummate skill and ingenuity of which the learned counsel for respondent argued these aspects. So, tongue-in-cheek or actual praise, the good effort was made, and I don't know. But he loses on this point eventually. Before going into the details as to how and to what extent the intended modifications fit into the scheme of the original agreement in terms of compatibility, one or two things may be noted on plausibility of this modified agreement. So he's saying, why would, in the bigger scheme of things, could there be such a modification? Number one. And second, is it plausible? So this compatibility and plausibility. The intended alleged modifications arise at changing the original terms of the agreement and even introducing new terms in a fundamental fashion. It becomes a new agreement altogether. The parties are hard-nosed businessmen. It is extremely unlikely that such a fundamental matter was intended to be dealt with in such a casual fashion, and at any rate, by itself would be inadequate evidence of their intention to create legal relationship. This is the legal point the arbitrators have considered, that a contract, even if you both sign it, if the intention to create legal intention is not there, it's not a contract. So he says there's inadequate evidence of their intention.
Correct.
A prerequisite for entering into a valid contract. The minutes of 27 September, which purports to record the deliberation of the meeting, do not lend much credence to support such deliberation. The document having been signed only by a representative, it should be representative of the respondent, though allegedly there were 5 or 6 representatives of unit holders, including one represented the claimant. Again, Sanjay Bansal, who allegedly represented the claimant at the purported time, was neither a director nor an employee, but a common broker. This is their stand of their witness also, and my learned friends also haven't argued otherwise, that this man had authority or ostensible authority to sign. A mere go-between who negotiated the transactions between the intended purchasers and the respondent, the developers. The developer's case for modification of the terms as contended by the respondent is further weakened by the fact that the minutes of 27th September itself records that a supplementary agreement recording the modifications would be executed in due course, which has not happened. So all the facts they have considered. Hence, the arrangement as it stood was akin to the provision subject to contract, an expression common in agreement for sale and purchase of land, and that the oral agreement was at most a tentative contract, but not intended to take effect until a formal document is duly executed. The whole episode, taking a generous view, may be viewed as the respondent feeling its way towards the agreement, initiating negotiation from an agreement might or might not result. So he's saying, even if I'm generous, this meeting, that so-called meeting, if it was ever held, is an attempt to renegotiate the contract.
Yes.
Which the agreement might or might not result. Even if the new set of terms viewed as a new offer, the same has not been accepted. So it's
So this is a finding.
in detail, it's there.
Yes.
Then, my lord, in further corroboration of such modification, the counsel for respondent referred to the letter dated 12th April, written by his client, meant to be a notice of demand under the Insolvency Act, claiming CAM charges. And until such demand was met, they would, and unless such demand is met, an application under Section 9 would be filed. Significantly, the claimant's reply to such demand in his letter of 24th April, disputing liability on the ground that possession has not been made over in terms of 7 and 8 of the agreement, and claiming the assured sum, in face of the categoric denial on part of the, well, this should be claimant. This is one mistake I concede. On part of the respondent of its liability to pay CAM charges, that has to be claimant. It's my denial that I have to pay. The contention of the respondent's counsel that the receipt on this account forwarded earlier by the respondent with rates mentioned loses much of its force as an acknowledgement of modification. So if I may pause again, my lord, just to explain this part, their case is before my lord is, since I paid the lesser rate, I have shown that I have impliedly accepted the contract. But he says that no, when you made a demand for CAM charges could not be demanded if there was no supplementary agreement. CAM charges could not be demanded if no possession was given. Both of them, they are admitting there was no agreement in writing at least, and there no possession was given. So, and we denied it on this letter of 24th April. If my lord wants the page numbers, paragraph 25 of the volume, page 32 is their letter, 12th April. 34 is 24th April letter. And page 34 is our 24th April letter. Both in volume 1.
Yes.
And in this 12th April letter, I pointed out before, they only refer to 31st December. There's no agreement of supplementary agreement of 27th. So then, coming back to 679, just the last part of the paragraph. Absence of any response of the claimant to such bills may be ascribed in the fuller context of events, and conduct may be ascribed to administrative oversight or inadvertence or even lapse. So he said the fact that I've paid that 1st October bill doesn't mean anything else. It can be due to many reasons. The same ambivalence in the conduct of the claimant to the respondent's intimation of fit out at its request is likewise pales into insignificance. So they said that even if you've requested us to take fit out and I don't respond and I don't take possession, I don't take out the fit out, therefore it weakens his case that there is by conduct you can, first of all, a written agreement cannot be added to or subtracted to without on parole evidence. That's section 91, 92. But there's an exception in 92 that if the parties, if the law doesn't require an agreement to be in writing, and or registered, these are the two exceptions, then any other agreement, even in writing, can be annulled by an oral agreement. That's the proviso to section 92, 92(4). But proviso 4, I think it's. So here, of course, they have not been able to prove that two companies have entered into an oral agreement. That's very difficult because they should be somewhat authorized, etc. No evidence of that has been given. They also admit it was that Bansal, who was not, Dalmia was the director, Bansal was the person who was a broker. Then paragraph 26. So he's saying that these events, the fact that I didn't take possession, didn't pay the CAM charges, etc., weakens their case that we had acknowledged a subsequent agreement. Then the learned counsel for respondent argued with much ingenuity that payments made by the claimants towards the principal sum in particular 2.53 crores, was in conformity with the terms purported modified terms, should be viewed as clinching evidence of acting in terms thereof. Learned counsel for the claimant, however, took the wind out of this agreement that the argument it should be that the respondent would be paid the balance amount of consideration as and when asked to pay like any other demands earlier. So whatever they have demanded, I have paid. If I owe them more under the contract, my interest has accrued. I showed your lordship that clause.
Yes.
I had shown, your lordship will remember clause 11, which says, even just like the supplementary agreement and the minutes, even in our agreement, it envisages that an agreement for sale will be entered into. And an agreement for sale was never entered into. So that, in my argument, I was reading the notes, what they had argued. They said that agreement for sale means conveyance. He's saying that this is your agreement for sale, and that is just changing the words of the agreement.
Okay.
It doesn't say sale deed. And other places they are very aware the deed of conveyance is mentioned. So they know what a deed of conveyance is, and they know what an agreement for sale is. So this they tried to, and the agreement that they have given with the other purchase unit holders, which is annexed, irrelevant for this purpose. They have titled it supplementary agreement for sale, which is very different from my investment agreement also. But in any event, I have not entered into that.
Because you are simple case, you are not the party to that.
Yes. So then lastly, the paragraph 28, the learned arbitrators say how unbelievable this is. Before we examine such evidence, it must be clearly understood to what extent the modifications as contended by the respondent be engrafted in the original context to make a new contract with no loose ends. The modifications as contended by the respondent was sought to be made after long 6 years or so, by which time the agreement of December 31, 2006 had been largely performed by the claimant by making substantial payment on various accounts. And in consequence, the claimant was entitled to receive substantial sums by way of interest and accrued interest. The modified terms as contended by the respondent makes no mention of as to how this would be adjusted, but beyond contending that the relevant clause conferring the right to make claim such interest would be deemed to be deleted, and the accrued interest would be taken into account by reduction in consideration amount. If the modifications took effect apparently on 27 September 18, it would involve refund of interest received, because the amount they have deleted, this is again a finding of the arbitrators, we didn't argue this. He said the amount you have revised the rate is not commensurate with the amount of interest that has accrued. So the last sentence again is important of that paragraph 28. In a commercial transaction, one would expect that such emerging situation would be clearly spelled out, which is clearly not been done. And then it says that I have paid the full amount, and the rest of the thing is nothing to do with this meeting. Then 32, the last finding on this topic. Viewed in totality, the purported meeting, disjointed fragments of proposed modification recorded in 12 September, it should be 27 September, alleged acting upon such proposed amendments spread over a long period, taken together, do not project a picture of a homogeneous whole. The picture is not complete, it looks. It is difficult to imagine how one can redraft an agreement of 31st December as a new workable contract, bearing in mind that the original agreement itself, as at the outset, was abysmally drafted. Whatever happens. So basically, if this modification happens, it's a new contract, and that was never accepted by us. So that argument is also there. And then he rejects the 92(4) argument they had made, and then paragraph 34, he deals with the registration point. Yes. So as far as modification is concerned, my lord, so where's these things once? So just to sum up, in my affidavit opposition and in my rejoinder.
Where is the resolution with regard to the modification?
Yes, page 85. I'll just place that. Page 85. Lordship sees this, and this was, the signature is not of our person. Sanjeev Agarwal. Is it the full? Yes, it's the full. So shall I place it on page 85?
Okay.
Vice President, second person is Sanjeev, director of PS.
My lord will see the persons present. Mr. Rahul Todi, he gave evidence. He admitted we weren't there. Sanjeev Agarwal, who is the director of their company, he is the one who signed this. Sanjeev Agarwal at the bottom. We haven't signed. And they are saying Sandeep Bansal is the representative of SBP customers. So all these units, the 5-6 people. So not only of NR Oil in that sense.
This Sandeep Agarwal was examined?
Sanjeev, no. Sanjeev Agarwal, Sanjeev Bansal, none of them were.
None of them examined. How this
they haven't proved it.
That's why how this resolution is proved.
No, they tried to prove it by saying, I know the signature. Rahul Todi was there. He said, I was present at the meeting. This is the minutes. But they admit that I haven't signed it. And they also admit, that's why I started with their pleading. They can't go beyond that. Because in the long stretch of argument, suddenly they'll start saying revised terms, as if the terms were revised. But it's their case also. This was not done. So their case is by conduct, there is a verbal agreement. By conduct, not even these terms. Another point my learned friends made in argument, if my lord turns over the page, there are some details.
It's not a transfer document. This is also not a transfer.
So the page 86, the last line, that a future document is again envisaged. Based on the calculation, demand invoice will be raised on 1st October. And above all, parties have been requested to clear their dues to enable, this is Bengal Strachi, to execute transfer documents after execution of supplementary agreement. So this is not the supplementary agreement. And then that invoice is also there. What page number?
108.
Page 108.
108.
That a forwarding letter. Yeah. Page 107 is a forwarding letter. They are forwarding us the invoice. No mention of any revised terms. Page 107.
Yes.
They tell us to make this payment and they are saying your flat is ready now. You can take possession if you want. And the page 108 is the detailed invoice. And that is the detailed invoice all the time. My learned friend made a point, see the electricity charges, it's to the Naya Paisa. It is, because that's how the bill used to come and we used to pay. There's no allegation or counterclaim that I owe him more money. There's no counterclaim that there's a difference between 265 of the original price and 253 you have paid. You have to pay us 9 more lakhs.
Yes.
No counterclaim. They want, on the contrary, they want maintenance charges. And there was some different correspondence on that, but that was rejected outright because that is not, I placed the entire agreement, by my lord, there is no provision in this agreement for maintenance charges. More so because possession, admittedly, again it was conceded during argument, was not given to us.
Yes.
So,
it's not
yes, I'll come to that. Now, so just to sum up what we had said in my affidavit opposition, supplementary agreement never existed. Petitioner has not established that it was modified.
Yes.
And our representatives did not attend. And the notices mentions only even the demands they had made for CAM charges, only 31st December.
Correct.
And they don't mention any other things. And then the reasons of the arbitrators I've placed. So this chapter, I think, is done. I only wanted to show now two other things before I deal with the cases. One is in the award, page 671. Actually, I had stopped here. 671 up to paragraph 14, I had placed the limitation point, how it was dealt with. Now, my lord will see our limitation the relevant date is the 21 notice. 6th of, I was thinking about it this morning. I just want to clarify that in my mind. 6th of June 2018, I make a demand that you pay me under clause 7, 8 and 9.
6th of June 2018.
I make a demand that you haven't paid me these assured charges, you pay me these charges. And as of today, it is this. Then on the 5th of June, what was my claim? So my claim was a compound interest, and with compound interest, say it's X.
Yes.
Now my learned friends are saying, no, you can go at the most 3 years behind. And beyond that 3 years, though the right was there, the remedy has been extinguished.
Correct.
So, but I'm not claiming the sum that was due 3 years ago. I'm claiming the sum, and that is what the arbitrators have also said, because the interest plus principal will become the new principal. So there is no question of limitation here.
That you already argued.
And that's the first, time I demanded, I was well within. So that is dealt with. That's up to 14. I'm just saying that between 15 and 19, I did not place it, but I'm just rushing my law through that. The second head of claim, the assured amount. Clause 7, 8 and 9, I placed it, this 13%. Then next page, paragraph 16. They say clause 9 is a sort of guarantee. In case of any shortfall, they will give me the 13%. So the shortfall was like total 100% shortfall because they didn't get a tenant. It was a positive obligation, if I may say so, for them to procure a tenant under clause 7, 8 and 9. And they say that, no, this was contingent. I didn't get a tenant, so I don't have to pay you 13. So then the arbitrators have said, no, we waited. The tentative date was December 2008, but we have claimed from after this 2012. Then coming paragraph 17, coming to the merit of the... No, I'm sorry, Manoj, I just wanted to show paragraph 16.
Clause 9.
Yes, begins with clause 9, that in any event of shortfall, the anticipated return, respondent would be obliged to make up the shortfall. Then, accordingly, the last line I wanted to say, we directed the parties to furnish detailed computation on the footing that the claim is maintainable. So if they can establish, no, my claim is not maintainable, this was not there, both parties were to give charts. Now, for this, I just wanted to bring to my Lord's notice the last volume. 735. Wait. My Lord, volume 5, page 735.
Yes.
It's the minutes of first 34th sitting.
Yeah.
Well, we'll see the last part. Mr. Shamrat Sen, learned senior counsel for respondent, elucidated his notes of calculation against the calculation sheet submitted by the claimant earlier today.
Yes.
So I had handed over the calculation, and on the next page, the 35th sitting, is records Mr. Ghosh for the claimant elucidated his notes of calculation against the reference to the calculation sheet submitted by the respondent earlier. So both of us had given our calculations, which is recorded here in paragraph 16 of the award. These are the minutes. So there's no dispute on that. Because one of the grounds my learned friend took is that, oh, they've given these calculations and not proved it. Both of us were asked to recalculate, because my earlier claim, there was a little overlap between the 11% and 13%. So I reduced it. I had claimed a bit more in my statement of claim. Then, if my lord comes to page 7:30. No, 7:37. This is our advocate writing to the arbitrators. This is the day we please find enclosed the date, the calculation of the claimant's claim. So I have given them my claim. Now 7:38 onwards is our explanation of the claim. I'm not. I don't think it's fully. Your Lordship need not go into the nitty-gritties of it because the arbitrators have considered it. That is my point. So it was completely given. It was there. They were given the copy. They also made their submissions to my claim, as I showed from the 34th sitting. Then the actual maths is worked out from 7:42 onwards. And then now my Lord will come to 7:46. This is my learned friend's advocate on record writing to the arbitrators. We are enclosing here with calculation chart on behalf of respondent as directed. And this is their calculation at 7:48. And they say this claim is barred by limitation. They give a calculation, but they say it's barred by limitation because you have to go to 2007 to start. And completely ignoring the fact that it's accruing day to day. As soon as the interest gets added, it accrues. So, and under the agreement, I was entitled to this return on investment upon demand. So when I demanded it, that was the thing. Then my right accrued, and if I didn't demand, that interest that had accrued, they were to adjust against my principal. So
but that's why they have taken that time is the different. This time is the different. That is the limitation period which you are not covered under that.
Yes, he's saying that your first year you 100 rupees accrued. That is barred by limitation.
Barred by limitation, you not claim
But
that.
in the second year, my principal, he say if assuming the second year was within my 3-year period, that would include that 100 rupees. I'm not. I need not go back so far. That's my theory. Unless they somehow said that this is no longer valid, this is stopped, you are no longer entitled to interest. Nowhere have they said that. Now, just to complete, my lord, the cases. My lord, will it be your lordship's pleasure that I take my lord through the evidence? You can take it, my lord, that the evidence is what the arbitrators have said. My learned friends have only said there are so many letters that were a chart has been given to my lord. Your lordship will see the chart though.
Chart of?
I was told that day I wasn't present.
Yes. Chart by the plaintiff.
By Mr. Sen, I think. It looks something like this, that whether document was considered. Yes, that one. Page, page number.
The document they have mentioned it.
They have mentioned these, so my lord will see what these documents are. I think they've all been somehow dealt with. Minutes of the meeting of 27 September, it has been dealt with. Then these two, item 2 and 3, this predates the contract. There was no need. It might be on record. It doesn't change the game. It predates the contract. It's then December 2006. Then supplementary agreement of other purchasers. They have referred, definitely. They have said that other unit holders have entered.
That's why they have given the list. What are the document which the arbitrator
The
has not
arbitrators
considered?
have not specifically mentioned.
Not considered.
But I'm saying that the supplementary agreement with other purchasers has been considered, but the fact is not with me. That's how it is dealt with. Then he doesn't have to go into the details of that supplement. So none of these documents, then my lord will see the other documents. This is the letter of 1st October, for example, the invoice. I just showed my lord these two letters. That those invoices do not speak of any revised agreement. These are just the evidence on record. No one's denied these invoices. I've paid them. Then the checks issued by me, there's no dispute on how much I've paid. So each, as an arbitrator, my lord, he doesn't have to go through each and every document. If they showed a document, it's so perverse that if your lordship had seen this document, this award could not have been passed. If there was an admission by me, I have waived all my rights and I will take a discount, etc. Then it would have been. But none of these documents, my lord, are so crucial that the award will fall because none of these were considered. It's easy to say that these were not considered, therefore it is perverse, but it has to affect the decision. Then otherwise, every judgment your lordship will have to refer to all the documents. So now so now finally the cases. Cases, my lord. I'll deal with my learned friends' cases. The first case they cited 1969. These, my lord, has copies. 1969, 1 SCC 479. 497, sorry, 497.
1969.
Yes. 69, 1 SCC 497. Completely irrelevant. We just place the first part of the head note.
Yes.
It was paragraph 2 and paragraph 4, I think. The document in question was required to be registered under section 54 of the Transfer of Property Act, and in the absence of such registration, it cannot be received as evidence of any transaction affecting the property. So this was to do with a mortgage deed, and they said there is another letter which changes the mortgage deed, and that was the real transfer. So obviously that document required registration, and since it didn't have, that's in paragraph 2 is referred. Now, if my lord comes to page 500, one of the third page of that judgment.
Yes.
So that I don't have to place it separately. Registration Act section 17 and section 49 is set out. I'll just very quickly read it. My submission is I don't come under 17. It doesn't require registration, nor does it require registration under the Transfer of Property Act. So this judgment really says there was a bit of a change. There was an amendment in the law.
Yes.
So I'm just, for your lordship, I'm just placing that. If my lord comes to Placetum D, section 17,
yes.
The following document.
Yes, yes.
No, my lord, if I may start at Placetum B. Section 4 of the Transfer of Property Act says the chapters and sections of this act which relate to contract shall be taken as a part of the Registration Act. And the sections are 54, etc., 107, 123 shall be read as supplemental to the Registration Act. Then section 17, the following documents shall be registered if the property to which they relate is situated in the district and if they have been executed on or before of this act comes into force. Namely, instruments of gift of immovable property, this is not that. Other non-testamentary instruments which purport to create, assign, etc., any right, title or interest, whether vested or contingent, of the value of 100 rupees upwards. Now, here I'm saying that this document has given me no right in the property. All they've relied on is a question. They asked question 92 to my witness, number 2, and he said, yes, I have an interest in the property. That's the layman's understanding. That doesn't make it. And every clause I have taken through, my lord, I've taken through all the clauses. None of them create a right in the property as such, because the whole intention, the interpretation of the contract is that it is an investment agreement which does not require registration. Then, the different types of leases, etc.
That are different.
Then 49 says, this is the change in law in 49, Malad. First, initially it used to read, no document required by section 17 to be registered shall affect any movable property, etc., be received as evidence of any transaction. Now, this was amended in 1929. No document required by section 17 or by any provision of Transfer of Property Act. So 54 also comes in. And then it says there's a proviso which says it can be looked into for a collateral purpose. But I'm not looking into this document for a collateral purpose. I'm looking at all the terms straight away. It's an investment. And the only thing it decides is what is the rate of interest that I'm to get return on my investment. Then So my submission is that the last 4 lines of this judgment says that even if it's under TPA or under section 17, those documents, if they are required to be registered, not registered, you cannot look into them. So this is absolutely not
What
applicable.
what was the prayer in the claim petition here?
In my money prayer, just money, only money, 18 crores. No specific performance. In fact, we've reserved our right. We said we have made it abundantly clear. It is restricted to a money claim, and we are not
That's
claiming.
I wanted to see.
Yes, that is there in my SOC.
Okay.
And the sum I've paid for the flat, 2 crores 53, I still haven't taken it. I haven't asked for it here. I have asked for, when I get the flat, I'll get the flat. Otherwise, again, the interest will accrue on that.
Okay.
So the last 3 lines of this not of paragraph 3, we accordingly are of the opinion exhibit A26 being unregistered is not admissible in evidence. In our opinion, Mr. Sinha is unable to make good his application. So this exhibit A6 is referred to above. It was a letter corroborating the mortgage deed. So factually, this is completely not required. And all it does, this judgment, is to reiterate what is section 17, what is section 49. Only thing is that
how the document is
the amendment of 1929 is explained, which is irrelevant. Then next, 1989, 4 SCC, page 39. Paragraph 7 and 8 were relied on. Again, this is a
1989.
For SCC 39.
Yes.
A document of lease was inadmissible. A registered lease more than 21 years old was required to be registered. It was not registered. It was inadmissible, even to look at the terms. So 7, again, my lord, it is completely, I'm just reading the last 4 lines of paragraph 8. If a document is inadmissible for non-registration, all its terms are inadmissible, including the ones dealing with the landlord's permission given to the tenant to sublet. It follows that the appellant cannot, in the present circumstances, be allowed to rely upon a clause in an unregistered lease deed. Completely, factually, completely different. Then 2008, 8 SCC, page 564. Paragraph 2008, 8 SCC, 564.
Yes.
I'd given Mr. Gupta the cases that I'll cite. Page 577, the principles are set out in paragraph 34. This was relied on by my learned friends.
Yes.
It's all known, these principles, not applicable on the facts. From the principles laid in various decisions of this court, it is evident that a document required to be registered, if unregistered, is not admissible in evidence under section 49. Paragraph 34. That's subparagraph 1 and subparagraph 5. If a document is inadmissible in evidence for want of registration, none of its terms can be admitted in evidence, and that the use of a document for the purpose of proving an important clause would not be using it as collateral purpose. And my learned friends themselves have annexed this agreement and they've relied on this agreement. And knowing fully well it is not required to be registered. So, the paragraph 35, just after that, in our view, the particular clause in the lease agreement in question cannot be called a collateral purpose. As noted earlier, it is the case of the appellant that the suit premises was let out only to a particularly named officer. Accordingly, after the same was vacated by the officer, the respondent is not entitled to allot it to the other employee and was therefore liable to be evicted. In our view, was an important term forming the part of the agreement. So if it was a term of the lease, you can't rely on it, saying that indirectly it was there. Again, facts completely distinguishable and nothing to do with the facts of our case. Finally, 2014, finally as on registration, 1 SCC, page 618. 2014, 1 SCC, page 618.
Stamp that.
Yes.
Yeah. So this was on the Stamp Act, a suit for specific performance.
Yes.
For transfer of immovable property. So obviously it was required to be stamped and registered. Well, paragraph 15, they was cited. I wanted to show. Yes. 15 to 18 was cited.
Yes.
That is really a part when a document is required to be stamped. 18, I wanted to cite. Yes. 18, if my lord comes to put the record straight, the correctness of the impugned judgment, Lakshmi Narayan and Om Prakash, came up for consideration before the division bench. And the same was overruled by the judgment. The High Court observed, if my lord turns over the page, a document would be admissible on the basis of the recitals made in the document and not on the basis of pleadings raised by the party. I think this is the important part of this case. Even in our case, on the basis of what is written in the agreement is important and not what is pleaded. They have pleaded that an agreement for sale is a conveyance. That is not correct, or that is argued at least.
Document has to be gone into.
The document has to be looked into whether it is required, it concerns a transfer of interest in immovable property, which it does not. So these are the cases that he cited.
Yes.
And one more case is there, Manoj. I didn't bring the copy. 1952 1 SCC 564. I'd made a note of it, but unfortunately I didn't bring the copy. But again, this says it related to a mortgage. And since the right in immovable property was affected, it was required to be registered. I think paragraph 14 to 17, my learned friends placed.
1952.
1 SCC.
Yes, 173.
No, it's 173. Yes, 173.
173.
I've written it wrong.
14, 15 years relied upon.
Yes. So there also the document related to
Same, the section 49.
Yes.
The next question is whether the document can be used in evidence under the proviso of section 149 of the Registration Act. We are clear it cannot. This cannot be. This is not a suit for specific performance, not any question of part performance. 53A. It remains then to be seen whether.
And it also says one of the registered document can only be altered by a registered document. I think that proposition is also there because not very required. Then, as far as limitation is concerned,
yes, that is a transaction not required to be evidenced by the registered document.
2024 6 SCC or the case.
2020.
No, 2024 6 SCC page 357. There. Paragraph 35, I think.
What is the name? Delhi Metro?
That judgment I have not got, unfortunately.
Yes.
That's it. Is that not NN Global?
2020.
Well, I'll come back to that. I haven't got that.
2024 is the Delhi Metro.
No, 6 SCC.
That's no, the yes, the SCC online. Yes.
Oh,
online version. That's why.
No, Delhi Metro. No, yes.
Delhi Metro.
No, yes, yes. So I think paragraph. Oh, this is that. Yes.
2, 8,
paragraph 35.
2, 8, 10, 11, 13, 15, 16. They are relied upon.
These are on the principles of section 34. This is another. So on this one, I'll come back to that. I'm sure it says exactly what the principles are, my lord. So I wanted to rely on 3 decisions, just the latest ones, or as far as section 34 is concerned, saying the same thing, that the interpretation of the contract is well within the domain of the arbitrators. If they are right or wrong, even if they're right or wrong, it doesn't matter if they have considered that interpretation. So that interpretation is basically that this is an investment agreement and therefore it is not a, it was not required registration. The stamp point which was taken in that application and it was kept in abeyance. That application, your lordship, they had made.
That is
Now, only
after
other
the
thing is,
evidence is led.
after evidence is led, it was not technically a section 16 application. It couldn't have been, because you have to make that before the submission of your defense.
Correct.
So that goes, and in fact, my learned friends did not place it at all.
No, because that
And
is
most
also, there is also law. If you are not raised the objection, if you admitted subsequently, you cannot raise the objection with regard to the registration. With regard to the registration.
No, that is with regard to stamp. Section 35.
Section 30.
Stamp. With stamp, that if they didn't take that point, now they can't do it. But the stamp point, my learned friend clearly said that we are not arguing the stamp point anymore. The registration stand in its own footing. So registration 17 and 49, they were allowed to take. So that, as for those, even a case was cited on section 35 and 36. I'm not going into that because that's no longer required. And one, just the decisions, if I may give them.
How much time will take? Because my other matters are
three decisions. 15, 20.
I will fix
half an hour, my lord will give. Then I'll come with my note. I don't know if my learned friends will also
They will
give
give
a
the
note.
reply.
They'll give a reply, then I'll give a reply. But those three cases, I'll give my learned friend the citation.
Give the citation so that they can give reply
come.
according.
But only since it's there, can it be done tomorrow also? I can do it.
Tomorrow can have date which come.
Your lordship has given me a lot of time. Next
Census
week.
Suffering for the petitioner, census and suffering for the respondent. Counsel for the respondent has argued the matter at length, but due to paucity of time, hearing could not be completed. कब है कुछ 11:30 12:30 कोई नहीं है कल परसों.
Well, if it is in the list from Monday, because I've got that examination in chief 11:30 for 3 days. I hope I'll finish before the third day. Then I can just finish it.
अच्छा.
I can inform or keep it on Wednesday. Just read the list.
Time fix
So I can finish mine, and I'm sure then Mr. Sen will take. I don't know what.
Time to time.
दो तीन कुछ भी नहीं. कब है लास्ट? जून में नहीं है. जुलाई हाँ फ्राइडे. Let it remain in the list on 26 at the top.
26. I'll come.
26 at the top, huh?
Yes.
June. At the top. Let they complete, then we'll see to it.
Grateful.
26 top. Next.
Item number 4.
I am for the plaintiff, your lordship. The witness is here.
I am for the defendant.
Repeat after.
Okay, no problem.
First time.
First time.
I
I
solemnly
affirm that
in whatever I will depose by way of evidence in this suit I shall speak the truth and no part of it shall be false and I shall not conceal anything. Your name, sir?
Lalit Agarwal,
L.A.
LITAGRAWAL.
Father's name?
Father late Fateh Chand Agarwal.
F.A.
TEH
Yes.
Chand THND Agarwal.
Okay.
AGRA.
Age?
66.
Occupation?
Business.
Residential address?
4B Gitanjali.
4B
Gitanjali. Merlin States.
Merlin
States.
State.
25/8 Diamond Harbour Road.
Calcutta 700008. No problem.
Yes.
Continue. Mr. Agarwal, I'm showing you a document. Can you tell this honorable court what is this document about?
This is an affidavit of evidence prepared by my advocate under my instructions.
Are the contents of this affidavit true and correct?
Yes. Yes.
Kindly come to page 54 of this affidavit. You find any signature on this document?
Yes. The first signature is mine.
Continue.
And the second signature is of the commissioner, Mr. Indranil Chandra Chaudhary.
Is this the original document?
Yes.
I'm tendering your lordship the affidavit and evidence may be accepted, your lordship. Yes. Mr. Agarwal, I'm showing you a document which is a part of the affidavit of competency filed before this honorable court. Can you say what is this document about?
This is extract of the board resolution adopted by the board of the company.
Yes.
Authorizing me to execute terms of settlement or enter into negotiation in connection with the dispute with United India Insurance Company Limited.
Are the contents of this document true and correct?
Yes.
Do you find any signature on this document?
Yes.
Can you indicate?
It's signed by Mr. Nikhil Agarwal, another director of the company.
Do you know the signature of Mr. Nikhil Agarwal?
Yes, it is known to me in the usual course of business.
Is this the original document?
Yes.
Shiva, I'm exhibiting your lordship. I'm tendering this document.
Exhibit A.
First. Mr. Agarwal, I'm showing you a document. Can you tell this honorable court what is this document about?
This is again a certified copy of the resolution passed by the board of the company, authorizing me to adduce evidences in respect to the case against United India Insurance Company Limited.
Are the contents of this document true and correct?
Yes.
Do you find any signatures on this document?
Yes.
Can you indicate?
Yes. The first signature belongs to Mr. Nikhil Agarwal. He is another director.
Yes.
And the second signature belongs to Niyati Saksaria, another director.
How do you know the signatures of these persons?
These are known to me in the usual course of business.
Is this the original document?
Yes.
Shiva, I'm tendering this document.
Exhibit B.
Mr. Agarwal, how you are connected with the plaintiff company?
I am a director of the company.
Are you authorized to adduce evidence on behalf of the plaintiff?
Yes.
Are you aware of the facts and circumstances of the case?
Yes.
Mr. Agarwal, I'm showing you a document, a copy whereof is appearing at pages 15 to 30 of the judge's brief of documents. Can you
tell this honorable court what is this document about?
This is standard fire and special peril policy issued by United India Insurance Company Limited, valid up to 3rd August 2020, in favor of Austin Private Limited.
Is this the original document?
Yes.
How Austin Private Limited is connected with the plaintiff?
That time I was also a director in Austin Private Limited, and their business of this division where the damage happened have been transferred by business transfer agreement to the plaintiff company.
Lordship, I am tendering this document.
C.
Exhibit C.
Exhibit
C. Mr. Agarwal, I am showing you documents, copies whereof are appearing at pages 94 and 95, 94, 95 and 96 of the judge's brief of documents. Can you tell this honorable court what are these documents about? Just tell him one by one.
The first email, this is an email written by me, dated 26th May 2020 at 13:47 hours to our broker regarding the damage happened due to Amphan cyclone. Then the second email dated 26th May 2020 at 19:17 hours, written by the broker, forwarding the mail and copy marking to me regarding the intimation of the damage.
Are the contents of these emails are true and correct?
Yes.
Is this the original printout?
Yes, it is original printout.
Mr. Agarwal, I'm showing you a document, a copy whereof is appearing at pages 857 to 860 of the judge's brief of documents. Can you tell this honorable court what is this document about?
This is a certificate under Section 65B of the Indian Evidence Act 1872 for the electronic documents.
Yes, yes.
Slow code.
No. Continue.
Kindly see the internal page 3 of this document. Do you find any signature on this document?
Yes, it is signed by me and then signed by the commissioner.
Are the contents of this document true and correct?
Yes.
Is this the original affidavit?
Yes.
So I'm tendering the document as well as 65B. It is for also one by one, I'll ask.
The document marked as Exhibit D.
পেজ নাম্বারটা বলে দিন তাহলে সুবিধা হবে একটা হচ্ছে 94 95 96
94 95 96 exhibit D না
আর আরেকটা হচ্ছে আপনার 857
that will not be exhibit that is the affidavit.
Yes. পরে দাও নেই Mr. Agarwal, I'm showing you a document, a copy whereof is appearing at page 31 of the judge's brief of documents. Can you say what is this document about?
This is an email written by me to the insurance company dated 4th June 2020, informing them that the surveyor has not still visited the site for the surveying.
Are the contents of this document true and correct?
Yes.
Is this the original document?
Yes.
Have you given any certificate under section 65B in connection with this document?
Yes.
Lordship, I'm attending the huge number of documents here, Lordship, are inter-party, but as your Lordship, I have to do one by one.
Yes, that is to F.
Exhibit E.
E.
It 31, page number 31 of the.
In the affidavit of admission and denial is given. Whether they have admitted, then it can be examined.
I have seen, your Lordship, this affidavit and evidence. They have not dealt with these particular documents.
Affidavit admission
Yes,
and
because
denial.
these are the emails exchanged between us. So they should not have actually disputed regarding, because for
That's why after the inspection, they have denied this document.
no, but they have given the affidavit of admission and denial, but they have not specifically dealt with these particular emails.
Okay.
Otherwise, your Lordship, the problem will be sorted out.
That's
All emails between us. Whether
Well, we have, I'm sorry,
bolun
we
na.
have already made out our points. Why we have objected to
No,
this?
that's why.
The existence of the emails, that cannot be denied, but the contents thereof, that is objected.
No problem.
Then you have to prove.
Yes. So one line question contains true and correct. Page 13. तुमको लिखे नहीं ठीक है Mr. Agarwal, I'm showing you a document, a copy whereof is appearing at page 34 of the judge's brief of documents. Can you say what is this document about?
This is an email dated 4th June 2020 at 17:30 hours, written by our insurance broker to Mr. Vijay Kothari, who is appointed as the surveyor, intimating that you have still to visit the site of the damage.
Are the contents of this document true and correct?
Yes.
Is this an original document?
It's a printout of the email.
Have you given any certificate under section 65B of this in connection with this document?
Yes.
Lordship, I am 10 minutes.
Exhibit F. Page 34 of the JVD.
Mr. Agarwal, I am showing you a document, a copy whereof is appearing at page 35 of the judge's brief of documents. Can you say what is this document about?
This is an email dated 9th June 2020, written by me to United India Insurance Company Limited, informing that one Mr. Vijay Kothari, along with Mr. KG Baldeva, visited our factory site, and we have shown them the videos of the floods caused by the super cyclone. During the visit, he asked us to write an email that we have not done anything with respect to the machine, which was contrary to our earlier email written to them, and we expressed our inability to write what he stated to us. Therefore, after that, he got furious and walked out of our office, stating that he is not satisfied with our claim.
Are the contents of this document true and correct?
Yes.
Is this the original printout?
Yes.
Have you given any certificate under section 65B in connection with this document?
Yes.
Exhibit
G. Mr. Agarwal, I'm showing you a document, a copy whereof is appearing at page 36 of the judge's brief of documents. What is this document about?
This is an email dated 11 June 2020, written by Mr. S.C. Bakshi, BAKSI, to me, asking for certain details.
Is this the original printout?
Yes.
Have you given any certificate under section 65B of the Evidence Act 1872 in connection with this document?
Yes.
Exhibit H. I'm showing you a document, a copy whereof is appearing at pages 38 to 40. 38 to 40 of the judge's brief of documents. Can you indicate what are these documents about?
The first page is an email dated 15 June 2020 at 11:04 hours, written by Mr. Sardindu Chakravarti, Sardindu, Sardindu, Sardindu Chakravarti, Chakravarty, to Mr. Bharat of Prevision World, Japan, Privision, Prevision World, Japan, informing about the damage in the machines. Prevision is the service agent of the original equipment manufacturer from Japan. Against that email, Mr. Bharat replied by email dated 15 June 2020 at 12:45 p.m. that due to pandemic COVID-19 and travel restrictions, we are unable to visit your factory, your premises at present, and they were ready to provide service support through web by video calling to our team.
Do you accept the statements and contents of these documents true and correct?
Yes. Yes.
Are these original printouts?
Yes.
Have you given any certificate under section 65B of the Evidence Act 1872 in connection with these documents?
Yes.
দুটো document আছে একসাথে by one করে দেব collectively series করে দেব
Collectively.
exhibit I collectively. So Agarwal, I'm showing you a document, copies whereof are appearing at pages 41 to 46 of the judge's brief of documents. What is this document about?
This is email dated 17 June 2020, written by me to Kothari Insurance Surveyors, providing them certain details as desired by them during the visit.
Are the contents of this document true and correct?
Yes.
Is this the original document?
Yes.
Have you given any certificate under Section 65B of the Indian Evidence Act 1872 for this document?
Yes.
Exhibit J.
I'm showing you a document, copies whereof are appearing at pages, appearing at pages 53 and 54. 53 and 54 and 55 to 59 of the judge's brief of documents. What are these documents about? Initially, there are 2 pages, and thereafter there's a bunch.
The first page is an email dated 22nd June 2020 at 11:17 hours by Kothari Insurance Surveyors to me, stating that pursuant to their visit to the factory on 16 June 2020, we have not submitted the various information desired by them. Enclosing therewith their mail of 11th June and in reply to that, I have written by an email dated 22nd June at 14:08 hours, stating that your email of 11th June has been duly replied on 17th June, immediately after the visit of your senior engineer, along with Mr. Vijay Kothari. And I also informed that we had sent you videos and still photographs to your office in a pen drive and asked for the confirmation of the same. And I further informed that the repairing process of the machine is in progress and we are taking help of the machine suppliers in this regard.
Are the contents of your email true and correct? Your email ta korbe na.
Yes.
Are these original printouts?
Yes.
Have you given any certificate under Section 65B of Indian Evidence Act in connection with this document?
Yes.
Exhibit K.
K collectively.
2023. Mr. Agarwal, I'm showing you a document, a copy whereof is appearing at page 47 of the judge's brief of documents. Can you tell what is this document about?
This is an email dated 25th June 2020 informing Kothari Insurance Surveyors that we wish to initiate process of segregation of the damaged stock from the sound stock, and that it will be started on 29 June, asking them to be present for this process. And we also informed that due to space constraint, we will have to shift the affected or damaged stock to a different site.
Are the contents of this document true and correct?
Yes.
Is this the original document?
Yes.
Have you given any certificate under Section 65B of the Indian Evidence Act in connection with this document?
Yes.
Exhibit L. I'm showing you a document, a copy whereof is appearing at pages 48 and 49 of the judge's brief of documents. Can you indicate what is this document about?
This is an email dated 1st July 2020 written to Kothari Insurance Surveyors informing that we have started the segregation process of the damaged stock and same will be completed by 4th July. And asking them to inspect the damaged stock anytime as per their convenience with prior intimation. Then in the second page, there's an email dated 15th July 2020, again requesting Kothari Insurance Surveyor to inspect the segregated goods at any time as per their convenience.
Are the contents of your email true and correct? Your emails true and correct?
Yes.
Are these the original printouts?
Yes.
Have you given any certificate under Section 65B of the Indian Evidence Act in connection?
Yes.
Exhibit M. Collective. I'm showing you documents appearing at pages 50 to 52 of the judge's brief of documents. What are these documents about?
The first page is an email written by Ideal Insurance, that is broker of the insurance, dated 22nd July 2020, informing Kothari Insurance Surveyors, asking them to update with respect to inspection / visit for the segregated goods.
Are the contents of your emails true and correct?
Yes.
Are these original printouts?
Yes.
Have you given any certificate under Section 65B of the Evidence Act in connection with these documents?
Yes.
Exhibit N collectively.
मेन यही, बाकी सब repeat email, trail mails.
Trail mails. Only one is the collectively.
Collectively.
I'm showing you a document, a copy whereof is appearing at page 60 of the judge's brief of document. What is this document about?
This is an email written by one Mr. S.C. Bakshi of Kothari Insurance Surveyors, written to me, stating that we will proceed further with respect to the damaged stock only after submission of the loss statement in respect of stock and plant and machinery. That's all.
Is this the original document?
Yes.
Have you given any certificate under Section 65B of the Evidence Act in connection with this document?
Yes.
Exhibit O. One. $75. I'm showing you a document, a copy whereof is appearing at pages 61 to 75 of the judge's brief of documents. What are these documents about?
This is an email dated 27th July 2020, written by me to Kothari Insurance Surveyors, submitting various details as desired by them.
Are the contents of this document true and correct?
Yes.
Is this the original document?
Yes.
Have you given any certificate under Section 65B of the Indian Evidence Act in connection with this document?
Yes.
Exhibit P.
Collectively.
Collectively. 76. I'm showing you a document, a copy whereof is appearing at pages 76 and 77 of the judge's brief of documents. What is this document about?
This is an email dated 30th December 2020, written by one Mr. Bakshi to me, asking certain details.
Is this the original printout?
Yes.
Have you given any certificate under Section 65B of this of the Indian Evidence Act in
Yes.
connection with this document?
Yes.
Exhibit Q. Also. I'm showing you a document, a copy whereof is appearing at page 78 of the judge's brief of documents. What is this document about?
This is an email dated 31st December 2020, written by me to Kothari Insurance Surveyors, informing that we are working on compiling the figures for the losses and stating that the delay has been mainly because of response from the JSW injection supplier and procurement of spares to freeze the claim amount. And we'll be very soon submitting all the documents to them.
Are the contents of this document true and correct?
Yes.
Is this the original printout?
Yes.
Have you given any certificate under Section 65B of the Evidence Act in connection with this document?
Yes.
Exhibit R. I'm showing you a document, a copy whereof is appearing at page 79 of this document. Can you indicate what is this document about?
This is a letter dated 13th January 2021, written to Kothari Insurance Surveyors, submitting claim for rupees 83,68,054, and in the claim file comprised of 485 pages in two sets, one for the insurance company and one for the surveyor.
Are the contents of this document true and correct?
Yes.
Do you find any signature on this document?
Yes.
Can you indicate the name?
This signature is mine.
Do you find any seal of receipt on this document?
Yes. It is acknowledging receipt of the documents dated 20th January 2021 at 1:50 p.m. 20th January 2021 at 1:50 p.m.
Can you indicate the name of the person who has received this document?
There is nothing mentioned about the name, only the company stamp is there.
Can you indicate the name of the company?
Kothari Insurance Surveyors and Loss Assessors Investigators Private Limited.
Is this the original document?
Yes.
I'm exhibiting it.
Exhibit S.
Mr. Agarwal, I'm showing you a document, a copy whereof is appearing at page 80 of the judge's brief of documents. Can you indicate what is this document about?
This is the claim bill dated 13th January 2021 from Austin Private Limited, made out to United India Insurance Company Limited for an amount of 83,68,054, duly signed by me.
Are the contents of this document true and correct?
Yes.
You find any signature on this document?
Yes. This is signed by me.
Was this document a part of your letter dated 13th January 2021?
Yes, it is a part of the letter dated 13th January 2021 and part of the claim file.
Is this the original document?
Yes.
No, original office copy.
Original office copy. One document gone to them, and
I'm tendering this document.
Exhibit T.
I'm showing you a copy, showing you a document, a copy whereof is appearing at pages 81 and 82 of the judge's brief of documents. Can you indicate what is this document about?
this is a claim form for fire insurance claim submitted to United India Insurance Company Limited in the claim file.
Are the contents of this document true and correct?
Yes.
Kindly see the next page of this document. Do you find any signature on this document?
Yes, it is signed by me.
Is this document a part of your letter dated 13th January 2021?
Yes.
Is this the office copy of this document?
Yes, it's an office copy of the original document.
Sure, I'm tendering this document.
Exhibit U.
Can I see the document once?
Yes. We have already given the inspection, Your Lordship.
No, it's all right.
Claim document.
Yes, next.
I'm showing you a document, a copy whereof is appearing at page 83 of the judge's brief of documents. What is this document about?
This is a summary of claims submitted in the claim file, amounting to rupees 83,68,054.
Is this document a part of your letter dated 13th of January 2021?
Yes.
Have you given any certificate in connection with this certificate certificate under section 65 of B of this of the Evidence Act in connection with this document?
Yes.
Is this the original printout?
Yes.
Exhibit V.
Huh?
V.
84 to I'm showing you a document, a copy whereof.
My lord, this document, that the claim form. Exhibit V, my lord.
Exhibit
V.
V, just one.
V, yes.
This
This is
one.
object.
Object.
This is the claim form, I think.
No, claim form.
Not this one, not this one.
Then
Summary claim.
Previous one.
the previous.
Previous one.
The objective.
Yes. Why object, sir?
My lord, the copy of the JBD does not contain the signature.
This is a copy, and I have given you Lordship the original one.
My lord, if this is a copy,
But
then
but at the time of inspection, you have not all.
Yes, yes.
You raised the objection. Then signature.
We have objected in our admission and denial.
Admission and denial. Have you taken this stand in the affidavit of the admission and denial?
Denied execution of
এখানে তো নেই জিবিডি তে তো সাইন করতে নেই এটা কত নম্বর এখানে তো ক্লেম ফর্মে কোনো ডেট আছে
No, dependent ka.
Internal page 4, I think, your Lordship, they have.
PD?
এটাকে detail deal করেছেন কোথায়? করেন PD 23 of the judge's brief of documents. কোথায়? PD 23 দেখি।
PD 23 এইটাই তো
PD 22, I'm sorry, your Lordship.
inspection that was there.
আবার তোমার admission দিলে কিছু বলেছো?
Claim form.
ডিনাইড এটা কোথায় গেল 27 তো 27 তো
হ্যাঁ edit part.
We have denied the execution of the document in mail.
Claim bill.
Yes, that is admission and denial on our part, my lord.
Part
It's
of the input
paragraph
of
4.
Part of
Where?
in January.
Claim form.
In our admission and denial, page 4, column 4. This is a part of the document. My lord, in execution of documents paragraph, we have said the execution of the document in mail not supported by any set and the undated and unreceipted claim form and summary of claim.
Copy of
13th
email.
January.
No, this is an email.
That is an email.
The email.
This is PD.
Your Lordship kindly sees page number 11 of their admission denial. Clause number 32. That
Claim
is
form.
claim.
That's why I'm going.
এইটা হচ্ছে
Issued by the plaintiff. Copy lying with the plaintiff.
আপনি তো কিছু লেখেন
Paragraph 11 of the admission and denial.
32.
Deny.
We have denied it in 32 claim form in page 11, my lord.
Correct.
We have denied it.
Denied. No averment. Existence of the document.
Simply
Yes.
it's a denial.
Denied.
It was anyway. It
The
was
insurance
not
company-
no. Please
Without-
don't
with-
make,
no, no.
make things
No,
like
no,
that.
sir.
Insurance
Without-
company
without-
is not
without-
that we are also a government company. We are defending our client.
Okay, no.
This is a claim form. Without accepting claim form,
No,
how
my
can
lord.
you repudiated my claim?
What I am on that the copy that has been with us in the JBD, it does not contain the signature. That should have been a replica of the original where the signature is
That's
there.
why I'm asking whether you have not taken that ground in the affidavit of admission and denial.
That, my lord, there are, but these are the denials because it makes a heavy bulk of denial then.
Okay.
My lord, one indulgence, my lord.
না করবো
I'm there.
11:30 tomorrow.
Only on day after tomorrow, if your lordships, I ask for one indulgence, if can be shifted to Monday.
No, your Lordship. He has come from outside, your Lordship.
No,
only
that
for this matter.
Monday there is no date in my diary. That's why fixed content.
No,
What is the
I'm
problem?
just praying for it. I'm not.
Your other party, if you not the other, your colleague is there, no problem. And court is here.
I'm grateful, your Lordship.
My lord, before your Lordship rises, my lord, item 9.
Sense offering for the plaintiff. Sense offering for the defendant. Plaintiff has filed the judge's brief of document and affidavit under section 65 of the 65B of the Evidence Act. Let the same be kept with the record. The plaintiff witness is examined in part. During this examination, documents were exhibited, being exhibit A to exhibit V. Full stop. The examination, due to paucity of time, examination chief of the plaintiff witness could not be completed. Accordingly, chief is deferred. The matter is already fixed tomorrow at 12, na? 11:30. Yes.
Item 9, affidavits are complete. I had to file the affidavit in reply to the supplementary
Which for the other
affidavit.
side?
My learned friend is appearing. The only thing is, the interim order is there till today.
Lordship, if your Lordship is extending the interim order today, may I pray that the matter be fixed on next Wednesday? I will have some difficulty for the next 2 to 3 days.
Next Wednesday, I don't. It will go to the July or August.
So that will be
July.
difficult because I'm suffering the
That I
interim order.
We did to nahi hoga. Huh? But the remain in the list. Okay. Record an order. You file the reply.
Yes.
So
To the supplementary affidavit.
Suffering for the plaintiff. Suffering for the defendant. Plaintiff has filed affidavit in reply to the supplementary affidavit after serving the learned counsel for the defendant. Let the same be kept with the record. Counsel for the plaintiff prays for extension of the interim order. Counsel for the defendant submit that the matter is to be heard as early as possible, as the defendant is suffering with the interim order. In view of the submission made by the counsel for the respective parties, let the matter appear. Twenty 27th under the heading adjourn motion. Adjourn motion at the
Lordship,
top.
I'm extremely sorry, but 27th, Lordship, is Rath Yatra and I have a puja at my house. Only 20th. I'm sorry.
Then when can we do?
26th, 25th, or any day thereafter or before.
26th.
26th. I'm extremely
grateful.
Interim order is extended till 27th of or until further order.
I'm extremely obliged.
report. Now, if your lordships kindly turns to page number of yes. Lord, kindly turns to page number 12. Lord, these are the three Lord, items as per your lordship's order.
Yes.
Lord, number 1, PRI power plant. Lord, the publication was made on 8th and 9th May 2025 in the Times of India, English and Doinik Bhaskar, both Jharkhand edition along with Sangbad Pratidin in West Bengal edition. E-auction conducted on 11 June 2025. Reserve price was 199 crore 54 lakhs. Number of bidders participated 2, but number of bidders, my lord, 1649. 1649 number of bidders. My lord, I am extremely sorry, my lord. I put my by mistake and number of bids. Then highest offer, my lord, we have received 523 crores 24 lakhs. And my lord, the EMD we have received 170 crores 71 lakhs 80,000. Now the second, my lord, the solar plant, that is, my lord, publication was made, but in this case,
nobody
my lord,
has
no bid was received.
None has
But third one, my lord, kindly see landed property at village Anjora, POPS, publication made so and so, and my lord, the bid was received 23 and to highest bid was received 82 lakhs 2,000.
82, 6 bid.
Yes.
Yes.
And my lord, the EMD received, my lord, 6 lakhs 80,000.
Yes.
Now, my lord, if your lord please kindly see, my lord, I have asked for prayed for paragraph 22, my lord, page 15, paragraph 22. If your lordships kindly, this is my prayer before your lordships. For confirmation of the sale of assets of DRI power plant, including 92.20 crores of freehold land, village so and so, amounting to rupees 523 crores, for which e-auction held on 11 June 2025 upon payment of the balance consideration as per terms and condition of sale. And another piece of freehold land measuring about so and so area, Rajasthan Chhattisgarh, in favor of Nisha Jaiswal of rupees 82 lakhs, for which e-auction held on 13 June 2025. And the last matter, the leave may be granted to the official liquidator to expend necessary cost and expenses which have been made on account of the advertisement, security, valuation, and any other expenses consequential in liquidation proceedings of the said 3 units in preserving, realizing, or getting in the properties of the company in liquidation as per the provisions of Rule 338 of the Companies Code Rules 1959. And one of the last prayer is liberty may be granted to the official liquidator to carry out a joint meeting with the members of the consortium lenders in respect of the solar plant of Rajasthan. That is, my lord, item number 2, which has no bid was received. And file a report for the outcome of the decision being taken with regard to the valuation of the said property. My lord, these are the 4 prayers.
Yes.
My lord, the secured creditors are there.
Yes.
My lord, I appear on behalf of Bank of Maharashtra. My lord, we have no objection. My lord, your sale is confirmed. My lord, we have taken written instruction. My lord, I can submit the written instruction.
The all details are there. And my lord, both the offerers, my lord, they have paid their 25% bid amount with the official liquidator as of today. But I have also annexed the, my lord, the bidding, my lord, that is, it starts from page 27. Auction report, my lord.
Yes. You will not come.
No, my lord, we are getting, my lord.
But he was supposed to
Yes.
make an application seeking, my lord, the cancellation of the sale
For 74.
for 74.
54, yes, my lord.
Enhanced 84.
Right.
So what is your dues? 153.
My lord, the actual dues, my lord, is
1.5.
about, yes, my lord. So we are getting that.
So you will get that.
Yes.
So other will get.
No, let them file, my lord, their claim before the official liquidator. That will be adjudicated. Yes.
They have to.
So
Yes,
now,
that
my lord, in this case, my lord, your lordship kindly, my lord, one submission, but because my lord, two bidders, they have been selected as highest bidder. Whether your lordship will say as a confirming purchaser or provisional confirming purchaser, my lord, that your lordship kindly, because until and unless the entire amount is being paid.
Unless that's why the confirm cannot be.
Yes.
So now it is. So I am passing an order with regard to the prayer 1 to 4.
Right.
And after the all formality is over, then I will pass appropriate order by confirming this.
Very good. My lord, your lordship kindly direct the official liquidator to file a report.
After I am accepting this.
Very well, my lord, liberty to mention, because the office has been transferred. So, my lord, most of the papers are in haphazard way. Anyhow, my lord, as your lordship feel free.
Can secret creditors maybe they may have the copy of the application.
What application?
The report.
Report it is mentioned that you have received the report.
No, no, my lord.
Who are you? Who are you?
Bank of India, my lord. I am a lead bank in consortium and in solar.
Give the copy. Give the copy.
Very well. Solar.
Huh?
I have not received any instructions about.
My lord, so far in respect of the Bank of India, their my lord, has not yet been sold.
Yes, their property is still not sold.
Sold, not sold.
Item number 2 is not sold.
Yes.
Which property? Which property?
DRI partner.
DRI is the Maharashtra.
But I'm a part secured
Acha,
creditor.
part
My
secured.
stake is near about 22.02%.
Maharashtra is a part of.
So what is your claim?
Lordship, we are agreeable to the sale. We have no problem.
Now what is your claim further? No further claim.
Otherwise, due, we will.
Yes.
CFMARC, my lord, we have also not served with the copy of the.
What you will do with the copy? What you do with the copy? When the case was taken up, nobody has come. When the sale has been occurred, no publication has been made, and the person has come. Now you all are coming forward. So and so appearing for the official liquidator. So and so appearing for the Bank of Maharashtra. You are appearing for?
Bank of India.
So and so appearing for the Bank of India. So and so appearing for the CMFRG. So and so appearing for the UCO Bank. Counsel for the Bank of India, CMFRG and Bank UCO Bank submitted. They have not received the copy of the report submitted by the official liquidator. The official liquidator is directed to serve the copy to the counsel for the respective parties. Police. The official liquidator has submitted the report informing that after the publication made in the paper, after the publication in terms of the order passed by this court dated 23rd of April 2025 with respect of the sale of asset of DRI power plant including 92.20 acres of freehold land, village Totalwadi police station, Kasrawan district, Sri Lekha, Jharkhand. The highest bidder has quoted an amount of rupees 523, 24, 00, 000 and has paid the EMD, has submitted the EMD, deposited the EMD for an amount of rupees 1, 70, 71, 80, 000. As regard the property of solar plant, village Nokha, Tehsil Pokhran, district Jaisalmer, Rajasthan, none has come forward to offer their bid with respect to the said property. As regard the landed property at village Anjora, PO and PS Ranjan Dogaon, district Ranjan Dogaon, Chhattisgarh, the highest bid amount is offered to the tune of rupees 82,02,000 and submitted an EMD for a sum of rupees 6,80,400. Peruse the report.
But your lordships kindly mention the name of the the highest bidders. As per paragraph 22, my lord.
It is fine that the highest bidder with regard to DRI power plant is
Rungta Sons Private Limited.
One Rungta Sons Private Limited, and the another property that is landed property at village Anjora.
Nisha Jaiswal.
Anjora. One Sirimati or Siri?
Nisha Jaiswal, my lord.
One Nisha Jaiswal.
Miss Nisha
Miss Nisha Jaiswal is the highest bidder. We'll consider the report and the document annexed thereto, and the submission made by the council for the respective parties, comma, this court for the present provisionally accepted the bid amount with respect of DRI plant as well, and the landed property of village Anjora, and the official liquidator accepted, na? Accepted so and so. But in para 1, you have stated that for confirmation. Confirm I.
My lord, that I have read, my lord, but in my opinion, my lord, it should not be confirmation.
That's why I propose.
Yes.
Provisionally
accepted.
Provisionally accepted. Yeah, bid amount. Full stop. The official liquidator is also given liberty to expend necessary cost and expenses which have been made on account of the advertisement, security, valuation, and any other expenses consequence of the liquidation proceedings of the above three property in terms of the order dated 23rd of April 2025. Full stop. The official liquidator is also given liberty to carry out a joint meeting with the members of the consortium lenders in respect of the solar plant of the Rajasthan. Full stop. The official liquidator is directed to complete the other formalities with the bidders and to file report along with the report of the joint meeting, if any, with the members of the consortium lenders in respect of the solar plant of the Rajasthan within a period of 8 weeks.
8 weeks.
Within a period of
4 weeks,
4 weeks. 4 weeks. Let the matter appear on 24th July.
24th July. I'm deeply blessed.
No, 23rd July.
23rd.
Wednesday.
At 2 p.m. fix meeting.
Yes, 2 p.m. Company matter is 2 p.m.
Next.
Company matter 39.
But I'm for the official.
Yes.
Yes.
This is that home buyers matter, my lord. We wanted to resolve without prejudice to our rights and contentions, because parallel proceedings are going on before the National Company Law Tribunal.
Yes.
Now, your lordships would kindly takes up your lordships last order, once. Yes, my lord. And your lordships would see But we placed on record, well, I am for the resolution professional, we placed on record the notification, the amendment made to the Insolvency and Bankruptcy Code when it comes to home buyers, your Lordship's order of 7th May 2025.
For E.
Yes, correct. Lordship would kindly have a look at the order, and then I'll make my submissions accordingly.
Yes, what has happened now?
Now, we convened a meeting of the Committee of Creditors. But before all my learned friends starts asking for a copy of the COC minutes, this is confidential document I can only share with the court. Your Lordship knows, because COC minutes under the code is confidential.
Unless it is published.
Yeah. Let's kindly sees, this is the minutes, this COC had convened a meeting. Your Lordship would kindly come to internal page 12 of this document. Item number A8.
Item number
A8.
Yes.
Your Lordship has got it?
Yes.
To approve handing over possession and execution of the registration of deed of conveyance. Now, in the pending winding up of the corporate data before the Honorable High Court at Calcutta, several home buyers have preferred an application for handing over of flat units in the completed projects and registration of the same by the RP. In the last hearing held on 7/5/2025, it was submitted by the Council appearing for the RP that Rule 4E of the Insolvency Bankruptcy Code was inserted. Then, in view of the aforesaid amendment, it was submitted before the High Court at Calcutta that the RP is required to submit proposal with regard to the request of the home buyers before the Committee of Creditors who have preferred application before the Honorable High Court for handing over possession and registration of sale deed. Hence, this Honorable Court was pleased to direct holding of a meeting of the COC within a period of 10 days from so-and-so. Now, turns the page, COC's views and discussions are there. Finally, ultimately, if your Lordship straight away comes to page 19, the resolution of the Committee of Creditors is there. Please see first, approved, internal page 19, the e-voting result.
Yes.
Lordship sees the first resolution, to approved handing over possession and execution of the registration of deed of conveyance. Resolve that the Committee of Creditors of so-and-so hereby approves the handing over of possession and registration of respective flat units before the concerns are in favor of the home buyers listed in serial number 1 to 9 of Annexure D annexed to the agenda. Now, your Lordships would see two things, First, and kindly see the second resolution. Resolve that subject to the receipt of payment of the respective home buyers listed at serial number 10 to 29 of Annexure D annexed to the agenda, Committee of Creditors of Avni so-and-so hereby approves handing over possession and registration. So, there are two classes now. One who has made the entire payment.
Already payment. They will
already payment.
They will give the possession and
registration.
And
approach
the second,
the RP. Second is from whom dues are pending. Of course, they have to pay the dues, and thereafter only deed of conveyance can be registered. Kindly see the next page. The list is given. Now, what I can do is for my learned friends, on the that's what. Wait. Now, what I have done is, this is the list, and your Lordships can give it. I am giving all my learned friends a copy. Whosoever, একটা করে নাও বাবা, আমার কাছে সবার তো হবে না, আমার একটাই আছে। হ্যাঁ, ব্যাস। This is a report card. Yes. Yes. This is
no result out.
Already হয়ে গেছে। তোমার অ্যাডভোকেট এখনই দিয়েছে। Very well. আর কি?
Now you have to choose which college you will get the admission.
Yes.
Unfortunately, in the right college.
Unfortunately, I have failed. My name is not even there only. Everyone. But I don't know how many people. I mean,
It's the only 29, but the total how many?
Yes.
83.
No. Now the problem is this, your Lordships would appreciate. Now the suspended board has gone away. He's run away. They're not cooperating. They're not doing anything. These are the details which the RP has now on his own has got from all these. Rest of the details, how much is due and payable, nothing proof. The home buyers have to approach the resolution professional and give them the details. because these are the details available in the books of the company right now, which the RP has access to. That's the problem. And your lordship would appreciate, we are doing this, my lord, to bring a quietus to this without prejudice to arise that everything has to be done by NCLT, because even as per the notification, it is NCLT who has to pass the orders. Because, my lord, we do not want to, it's not the intention of the RP that, my lord, the RP will, my lord, unnecessarily not object, my lord, and do this. So we are doing this, we have carried this particular, my lord, exercise. Now, my lord, your lordships would note in the order. My lord, if your lordship sees the cost title from the last order also, I can, for example, indicate from the cost title. For example, my lord, CA 6 of 2019, I don't know whether he is here or not. CA 6.
Yes,
My lord, payment is done, it can be registered in his name.
CA6 is there.
CA6 is there, my lord. CA6 is there, my lord. I am told CA6 is there.
CA6
in the list, my lord.
Not in the list.
Very well, my lord. I'll just check, because, my lord, here it is. Oh, I'm sorry. I'm sorry. I'm sorry. Due. Payment is due.
Hearing as item number 25 in the list.
Payment is due. So for him, my lord, for example, my lord, he has to, my lord, approach, my lord, he has to make the payment and he has to get it done. Similarly, CA7, your lordship sees. CA7, if someone is there for CS, but entire thing paid, it can be registered in his name.
No, so now we go. This is the list which you
Correct, my
you
lord.
are given.
Correct.
This is total 29.
Correct. But 9 and 29 part payments are yet to be received from 29 home buyers. 9 home buyers.
No, 1 to 10 is it is clear.
1 to 9 is clear.
1 to 9 is clear.
Yes.
1 to 9 is clear. One is the 62.
One is, yes, 62.
Who is CS 62? He is not here. Who is in 46? Divya Jyoti.
CA 46.
CA 46.
Yes, sir.
You are there. And what about the CA 47? You are the same. Then
60.
60, my lord, I am there.
You are there. CA 55.
Mine, my lord.
You.
I am okay.
CA 54.
Same, my lord.
CA 66.
Also,
CA 7.
yes, my lord.
CA 81. CA 81, nobody is there. So 1 and 9 are not there.
Yes.
And with regard to the other, CA 10, CA 71.
My lord, 71, 72, and 73, I am there, my lord.
You are there.
But they have to make payment.
My lord, we will make the payment, but there are some disputes. My lord, what is happening? The RP, whenever the liquidator, I'm sorry, whenever he is
RP.
issuing a mail, we are telling him kindly intimate us the dues. I can show your lordship 3 or 4 mails where there is a variation in the amount.
Okay, so you are not having any agreement.
No, we are having an agreement.
As per the agreement, my lord.
So as per the agreement, as per the acknowledgement,
Now,
what
my
you
lord,
are paid.
my lord, that this is the final quantification that is being done.
So it is there.
Yes.
Outstanding is there. 43.
Now, my lord, if they dispute this, then, my lord, it has to go to, my lord, NCLT and
4,39,402. If you are
Yes.
agreeable, then the court will
Correct.
pass an order.
Correct,
You
my lord.
deposit that, then thereafter
Yes.
it can be. So 4,39,000 is the due.
Yes, my lord.
Correct. Like 11.
CA 73 is 7,13,718.
CA 33, 72.
73.
No, 72.
72 is 4 lakh.
You are pairing.
But I'm for 71, 72, and 73. That is serial number 10, 11.
73, 7 lakh is there.
My lord.
So what is your submission now? What you will do now?
My lord, we'll make the payment subject to confirmation from our client, my lord.
No, so I will keep the to come with the next date. Next date, you confirm with your your client.
We will sit up with our client, my lord. They'll reconcile the figure, and my lord,
Correct.
We'll
You sit with your client and come on the next date. If you are ready that it is to be paid, then you inform the one when you paid the amount. Then I will accordingly the court will direct.
My lord.
Correct.
74 turning.
Then for CA 48.
RP ke approach korte hobe kya? I'm sorry, my lord.
CA 48.
48. If anyone is there.
Nobody is there.
48. 48.
Mine, my lord.
You.
Yes.
So what is your 14 lakhs?
Yes, my lord. So I'll have to go back and sit with the client.
Okay.
And then only I can.
Okay, then
So these are, that's what I'm saying, my lord. These 29, my lord, we have done our this thing. They ought to have, my lord, if they would have paid the payment, their name would have been there.
No, that's what I'm
Yes,
telling.
correct.
But why I am calling this?
Yes.
If all the advocates are there,
Yes.
then I'll pass a
Common
order.
Lordship pleases.
That they come with the report,
Lordship
come with
pleases.
their proposal,
Lordship
if they
pleases.
are accepting this,
Lordship pleases.
then this court will fix a
Lordship
date.
pleases. Lordship pleases.
When they, when how much time they want
Lordship
the payment
pleases.
of the amount.
Lordship pleases.
So 61, CA 61,
61.
10,000 only. Then 65.
65 is my mind. Some discrepancy, I will take instruction.
Okay, take instruction. I am only asking whether appearing or not. CA 68.
68, 69, 70 and 75, madam, I am appearing.
68, 69,
Yes, madam, 69, 71.
73 you are appearing. Okay. And 75?
75.
75 also? Okay. Then 77?
Mine.
Okay. 78?
My lord, 78 I am there.
79?
79 and 80 is my application.
Okay. So you will consult with your client. 81?
My lord, 81, I appear, my lord. I'll consult with my client, but the only thing is that in 81, if your lordship just takes my application one page, they have confirmed that entire amount has been paid.
Okay, you
In
sit your
18,000 is the
See,
amount.
you might
Yes,
have been
yes.
having the agreement.
Yes, yes.
And you might have been having the
Payment
transaction
receipts.
payment
Absolutely.
acknowledgement.
Lord, stick with the RP, my lord, and we'll sort that out.
Yes.
That's not a problem. I'm not.
Is that then it will be
But I'm
sent.
carrying
And
out
it
this
is,
exercise.
and
It's
it
not an
is,
adversarial thing.
even otherwise, it's 18,702. I've
Yes,
taken
yes.
instructions. Perhaps this will be done by the next.
This is not less than your fee.
No, that I would have hoped that.
I'm sure about it, my lord.
Ah.
Mr. Varun.
So CS6.
And in CA6, we would also write to RP. We have made the payment. We will reconcile
Confirm,
it with
confirm, confirm.
40,000. This thing.
CS67.
Yes, mine.
Okay. CA11. CA11 new. What is that? CA11. Nobody is there. CA63. Nobody is there.
That's substantial payment, my lord. CA 63 is substantial payment.
CS63 22 lakhs. And CS52. Nobody. These three are not there. 3 and number 1. 62 is also nobody is there.
No, my lord.
Okay.
Now, my lord, there may be one or two more whose information, my lord, the RP does not have at all. Let them, my lord, approach the RP, sit with the RP, and my lord,
No,
for those home
how
buyers.
many cases are in the list, sir?
How many cases are there in the list?
One instance I can tell, which is not
74 perhaps.
the list,
But not in the list of the IFP.
CA9 of
CA number 9 of 2019.
But I appear in that matter, my lord, CA9. I appear in the matter. My lord, my name is not appearing in the list.
CA9.
Yes.
9 of 19.
CA9 and 19.
You are appearing.
We have made all payments, my lord.
Your name is not there.
No.
So you do one thing.
My lord.
Whose names are there, I am passing this two orders.
Yes.
One is with regard to the confirm the sale.
Lordship pleases.
And with regard to the 10 to 29, I will direct the learned advocates for the parties to consult with the clients and to file the submit a supplementary affidavit here, whether they or you go to the IRP and
Well, meet the IRP in person, my lord. Your lordships will meet the IRP in person, give them. Well, this kindly appreciate, and I think everyone should appreciate this. We did this, carried out this exercise. Well,
and it is better that everybody goes there, because why? Otherwise, it will be only back and
but
forth
it's
before
not an
the last
adversarial litigation, because otherwise the rest I will ask for transfer to NCLT.
how much time you will take? How much time you will go to the IRP?
7 days.
1 week.
Yes.
Not only
And
one.
with regard to this, the payment is already made. How much time you will take for registration? And
Would your lordships will make it forthwith, but make it because registration is not in my hands also. They will convince. But I don't know whether it has to be. Kindly makes it 4 weeks.
Okay.
Not only one indulgence, Lord, in with regard to CA number 9 and 74, but I tell you, Lordship, Lord, I am the subsequent purchaser from Mr. Rupak Ghosh's client.
Oh my God.
Now, Lord, what happens is I have paid the entire amount that is there in the application. He now says, after transferring the possession, after 5 years, there is some payment left. So perhaps this exercise, Lord, perhaps Lord, would not be possible for the.
Not IRP.
Not NCLT can do that. That's the civil court has to do
Now,
that.
now the difficulty is
Neither this court.
now the difficulty is now the
then you have to
now the
come with the
now the difficulty is he is trying to create the dispute. He has to establish a right But my sale may be confirmed subject. He has filed a suit.
And once
But
there is
just-
a dispute, neither
May I
that's
just-
telling.
may I just-
If you
may I
parties
just-
are raising dispute,
May I
neither
just not-
dispute nor
May I
NCLT.
just say for 2 minutes only? May I just say for 2 minutes only? What he has done is, he has filed a suit. Now he took money, he executed the agreement, he given me the possession. Now,
I've taken the degree on consent.
Lord, now, after I have approached your lordships, he got to know, he filed an application saying that he has not received the entire payment. Now, vis-a-vis this, despite pendency of his application, he has approached the civil court. Now, he has prayed for, Lord, in the civil court, he has made a prayer that, Lord, the agreement that he has executed, that should be declared as null and void. So that civil suit will take, Lord, 10 years time. He wants me to hold. He wants to hold me till that. I was making a submission, Lord, subject to lordship's kind sanction, Lord. He has to, Lord, make out a case before the civil court. Now the thing is, what I was saying, since I say that I have made the entire payment, since he is disputing it, the sale may be confirmed subject to the result of the suit. Because if he now, Lord, if he fails in the suit after 10 years,
Why the NCLT will take the risk?
Lord, if he fails, Mr. Banerjee will speak. No, I'll just finish. Lord, if he fails in the suit after 10 years, if his suit fails,
Show us the damage.
then, Lord, what will happen is the registration will be, Lord, stalled for 10 years without getting an injunction. He did not get an injunction. There is no embargo today on the NCLT or this court or the COC to confirm the sale.
Okay, if he is ready to pay the amount, let he pay the amount.
Yes, let him deposit the entire amount.
Yes,
Yes, he has to show.
go into
Lord,
that.
He cannot, Lord, stall my registration by this.
Kindly do not entertain these two applications then, because I'll tell your lordships what, I'm sorry to say this, Mr. Chakraborty is coming here for the first time. At least I am here, I know for this matter, but for the last 2-3 hearings. If they would have said about it, we are frantically searching that what is the registration, where is the document. Now they are saying that they've purchased inter se among themselves. Why come to the company? Couldn't be the company.
Not inter se.
Got it all wrong.
You got it all wrong.
Amount has been paid.
Lord, the amount has been paid to the company. Lord, I tell you, Lord, sir, Mr. Rupak Ghosh, Mr. Banerjee is misunderstanding it. Mr. Rupak Ghosh is the original allottee. There is no payment.
You can only refer to me as Mr.
Very well. I didn't know, Lord. I didn't check for Lord here. So what Mr. Ghosh is saying, Lord, he got the initial agreement. He paid the entire amount to the company. Company doesn't have anything left to be paid. There's no due. Now what Mr. Ghosh says that I did not discharge my liability towards him. So that is
Not decide. That you
so-
get the civil court,
Lord,
the specific
no, Lord,
payments, whatever.
so the company, because he's telling me.
But
Lord,
what this court will do?
Lord, I have paid the company. Let the company register it in my name.
This court
Lord, there is no due to the company. Lord, there is no due to the company. Then we will come back, Lord, on the next.
Whose favor I will register then?
We'll come back on the next date. Lord, let this exercise be over.
9 and 7. No, this exercise 9 and 74. Then, Lord, I
Lord,
cannot
we'll argue.
adjudicate the title between
Lord,
them.
we will argue on the next day. We'll argue. Yes, তোর তো কোনো
No,
টাকা
that is
বাকি নেই।
separate. That না সেটাও আমি বলতে পারবো।
তুই তো টাকা নিয়ে বসে আছিস ভাই। তোর তো
এটা
কোনো
আমাকে
টাকা বাকি নেই।
দিতে হবে। So, এটা নেই।
47 of 2020.
হ্যাঁ, তোর কোনো পেমেন্ট বাকি নেই।
But would your lordships just before, I'm sorry, because now that what 9 and 74, your lordships would direct the concerned applicants to approach the RP to application all
Today
details.
only I am passing the order with respect of the list which
And
you
next day will come.
very
Next
well.
day will come.
which list you provide.
Very well.
Subsequently, next date,
I'm so grateful.
my office will segregate.
I'm so grateful.
this will
So
be-
grateful, my lord.
That
So
will be better,
grateful.
my lord. That will
So
be
grateful.
Our application will record some consideration. Let this be get over.
47, 60, 23, 55 of 23, 54 of 23, 66 of 23, CS 7 of 2019, 81 of 2019, 2000. ठीक है? So and so offering for the petitioner. Preparing for the purchaser. Purchaser oblique applicant. Oblique applicant. And so and so appearing for the RP. Who is appearing for the resolution?
I appear for the resolution profession.
Official liquidator, you are appearing. And so and so appearing for the official liquidator. In terms of the order passed by this court dated
Item 1
dated 7th May 2025. 2025.
ওর কোনো টাকা বাকি নেই, you are gainer always.
This resolution professional
You have been enriched.
has submitted the
Now he
report.
is now taking a dispute.
Submitted the report. It is find that where in item number 8, the following
তোমার কি
agenda
বাবা? তুমি কারো এসছো?
was taken into the meeting. Following agenda was considered in the meeting held on 19th May 2020.
This also, you know, I need to convince them and then
ওকে ডিসাইড করতে পারবে সিওসি আমার ডিসপিউটটা ফেরত পাঠাবে।
আমি কি আরপি ডিসাইড করব?
অনলি দ্য কোর্ট ক্যান ডিসাইড। কোর্ট
ওটাও
কি
করিয়ে
বলতে
দিই
পারে?
আমাকে,
এক সেকেন্ড।
ঠিক আছে।
ও গিয়ে বলেছে আমি সিভিল স্যুট ফাইল করছি। টিল দ্য স্যুট ডিসাইড subject to the result of the suit, that will be the order. Just by raising a dispute you cannot stall it. You only take
In the meeting,
that money.
following decision has been taken. Where is the decision? Which page?
But I'm sorry, of the COC, right? Your lordships would kindly see the voting is at page 19.
The 19. Following decision has been taken. In the said meeting, the following decision has been taken. Okay. Page number 19. Number 19. यहाँ से लेकर के
ठीक है जी, यहाँ
तक ठीक है. It's fine that the in the meeting the resolution professional has taken has considered the case of 29 purchasers, and out of the 29 purchasers it was found that 9 purchasers who are the applicant in CA 62 of 2023, CA 46 of 2023, CA 47 of 2023. Purchaser who are the applicant, who are the purchaser of the applicant in the above matter, have paid the total sale price of the concerned flat. In view of the above,
এটা সবকটা একটা সিএতে দেয়া আছে সবকটা
4 weeks.
I'm sorry,
4 weeks
for registration. Your lordship will see within 4 to 6 weeks.
In view of the above, you will do that. RP is,
but they will have to do that. RP will have to just sign.
So how much time you will come and give the?
No, you guys have to do the deed and everything.
In view of the above, the
registration
purchasers are directed, purchaseless applicants are directed to submit their draft deed. Submit their deed to the resolution.
Your lordships will just record that the purchasers the home buyers will take steps for registration. RP will cooperate and sign out the registration.
Purchaser will be direct purchaser home buyers. Home buyers are directed to take appropriate steps for registration of their respective conveyance deed with respect of their flats within a period of 6 weeks from date, and when the all formalities has been completed, the same may be informed to the resolution professional.
But if the RP may be directed to supply a model draft, because for all the flats it would be the same thing. So if he supplies a model draft, then there will be a less chance of confusion. And secondly, my lord, what is happening in the registration office now, my lord, before the commissioning used to happen where the registrar used to go to the concerned person's residence. But now this has become very difficult. So my lord, the RP needs to come physically to the registry office.
So that's why I will direct. He has to register, then they will, if they make the arrangement, that will be. So you will provide the draft deed.
The RP will cooperate, my lord.
No, draft
deed.
Model draft deed. Because
my lord, I'll ask them if there is any deed for these similar projects which are available with the RP.
In my application,
that sounds logical.
all draft deeds.
So
if he can take anything one for the consideration.
So if he is saying that the draft deeds very well,
do one thing, whatever it is, you.
My lord, what draft deeds are they will give it, my lord, accordingly will be taken care of.
Very well.
Let them do it, my lord, we'll take.
I have a signed deed annexed in my application in relation to the same.
So she is
not
different. He is different.
Different, but
Yes,
same premises.
Not the home buyer.
Just a different unit. Not in this, the draft can be used. The premises is the same.
All the formalities completed shall inform
সব ব্যানার্জি বানিয়ে নেবে।
inform to the resolution professional, and once the resolution professional will get an information from the home buyers with respect of completion of all formalities and for registration of the deed, comma, the resolution professional shall take appropriate steps for registration for execution of the deed in favor of the home buyers before the competent authority.
Yes, Malad.
For the competent authority within a period of 2 weeks thereafter.
Malad, one sentence to protect me, because I know it was your lordship knows how vehemently Malad this thing. This is without prejudice to the rights and contentions of the RP. It is there in a previous order, but one more thing, because otherwise they would say you again agreed to this, so you waived your consented.
This court appreciates that the counsel for the IRP has taken pain to resolve the issue of the home buyers, and as such, whatever the decision taken by the RP in their meeting is without prejudice to the rights and contentions.
The matter to be transferred to it. But
Please, you give the number.
Your
Whatever
lordship told the
my
officer to
office has, my office has searched all the application. What to have find? Because after taking my determination, I directed my staff
on the first day, Malad, when I took this issue up, your lordship directed your lordship's court officer to said everything.
Now that's why if anything is left, you mention, give the mention, give the case number. My office will search. Serve to the RP also, serve and mention here, then we'll see.
And RP will examine that also. If it's paid,
Yes,
it's paid.
You make a
It's paid. No need to trouble your lordships for that.
Okay, within 2 weeks thereafter.
Malad, one thing, Malad, interim order has to be extended. That Malad, which in Miss Dalmia's.
So I am keeping. So this all the disposed of?
No. Till item 39.
No, with regard to the 129.
129, your lordship said. Now, Malad.
Or I am keeping pending for submission of a report.
No, 10 to 29.
Submission of report. Let the matter appear. After 6 weeks, होगा ना? आज कितना तारीख है?
But 6 weeks ends on 29 to
I'll tell your lordships 10 to 29. Your lordships can keep it next week for them to come and confirm.
Now first this I am passing on order. 8 weeks है ना? 8 मैंने 2 महीना हो गया ना? 18 से 18 जुलाई, 18 अगस्त.
6 weeks ends on 29th of July.
27th of August 2025 for report for submission of deed, if any, registered before this.
1 to 9.
1 to 9.
Yeah, Malad, now 10 to 29.
Now, CA number 71, 72, 73, 48, 61, 71, 72, 73 ना 24 होगा. 24 होगा. 24, 48, 23, 61, 23, 65, 23, 68, 24, 69, 24, 70, 24, 75, 24, 77, 24, 78, 24, 79, 24, 80, 24, 81, 24, 6, 2019, 67, 2024, 11, 2019, within bracket new, CA 63, 23, CA 52, 23. Full stop. As per the report of the IRP, it is found that amounts are due to be paid by the home buyers. Accordingly, the counsel appearing for the home buyers submit that they will take appropriate instructions and will report and will make appropriate representation to the RP within a period of 10 days, 2 weeks. 2 weeks. Within a period of 2 weeks. Full stop. If any representation is received from the home buyers with respect of the above referred matters, with regard to the remaining payment, comma, the IRP shall consider and will pass appropriate order within a period of 2 weeks thereafter. Full stop. Let the matter appear before this court on 23rd of July 2025.
My lord, if my lord can make an observation that these amounts are not still admitted by the.
I am not stated anything. You make
Okay.
your representation to the IRP. That's why this court has not taken any all things.
So your lordship is keeping the first 9 on 27th August.
August.
27th August, and malad the remaining on your
23rd of July.
23rd of
These are
July.
4 weeks.
Great.
23rd of July.
Lord,
Malad, what the,
Other items, item 10 onward. Suppose the problem has been solved or it has been.
So that's why I kept pending here.
Then that should be given to the IRP to place a deeds in favor of the person.
You make representation. That's why if you're ready to pay the amount, you make the
It will be
representation,
done.
then automatically it will be done. There is an order. If
One observation you should get.
एक record करो. If the home buyers, the second matter, if the home buyers are ready to pay the amount, comma, the RP shall take RC shall pass appropriate order for approval of registration of the deed.
I'm so grateful. But again, the same sentence here without prejudice.
That's already there.
Very well. Now, malad, coming.
All the actions of the IRP is without prejudice, right and contention of.
Grateful, malad. Now, malad, coming to the most. Malad, there are two. Yes, malad. Now, I think my learned friends can.
Lord, then with regard to our applications, this may come up, Lord, after this is over, or next day when your lordship keeps it.
It will come.
Next.
Now my officers will segregated this.
Yes.
Then whatever that has not been
74, your lordship can direct it to come after 4 weeks after this.
Yes.
No, that because it has all combined.
No. Actually, those matters are.
It is, I believe, our joint reference that your lordship can keep these
After 4 weeks. After 4 weeks.
Lord, I would say, my lord, these two applications should be kept on a different day because these are, my lord.
Correct. See.
So after this dispute is over, then
The 1 to 9 and 23 will be already 8 weeks and
Yes,
4
yes,
weeks.
yes,
The other application will come on the next week.
very well.
Correct.
Next Wednesday. Lord, I'm so grateful to you, lordship.
Now, malad,
Now
which, what? No. Yeah, colony of item.
40.
Amateur
40, 40.
Yes, 40 and 41.
42.
40 is my application.
42 ta abar katal.
40.
40 is my application, my lord.
Yes.
Wherein an order had been passed,
Hmm.
to which Mr. Banerjee has actually filed another application. That is item number
83.
41. That is CA 83. Seeking to recall the order. My lord, this is the basic crux of the matter. Now, my lord, who am I? I am not a home buyer. The company under liquidation had sold me 4 units of flat in that particular premises much prior to the liquidation proceedings was even initiated. Unfortunately, my lord, what has happened, me as a party also went through a process of CIRP proceeding. Now, my lord, the water is actually now, I'm in still waters. Now there is a complete management. And recently, when I was trying to inquire about statuses of the properties, which is there in my name, by way of registered title deeds, which were executed much prior to the winding up proceedings being initiated against this company under liquidation today, that is Mr. Banerjee's, no, not Mr. Banerjee's, because Mr. Banerjee is representing the art. But then it was ascertained that these particular 4 units stands in mind. My lord, I went to Mr. Banerjee's.
When you purchased?
My lord, I had purchased these properties in 2015.
2015.
My lord, the liquidation started somewhere in 2017.
No, malad, let's not disturb your lordships. If she doesn't want to file a reply opposition, which she was directed to do so, because it's been 2-3 months that she has not filed an opposition. If she does not, if you're ready to argue the matter, then I'm ready to argue the matter. But later she can't say that she doesn't want to use a opposition. She wants to use an opposition and this thing.
My lord, in that case, I would want to use it.
Item number 41.
In item number 41, CA.
Then malad, the interim order passed.
And
malad, by this court.
82.
82, my lord, the pleadings are complete.
83.
Both are
No,
things have to be-
82. She filed it against the official liquidity.
Against you.
No, so now, malad, I asked for
So
recall.
both the application is to be taken
Where
together.
the interim order has to be extended because there was an order passed that malad, the interim order passed that in the meantime no possession will be handed up because my registered office is there.
No, my lord, actually the order was a direction on the official liquidator who had consented that yes, the office premise, I have the symbolic possession of the premises and I'm ready and willing to hand over the premises to my client. There was an order. What the official liquidator did for complete transparency, he also made a communication to Mr. Banerjee's client. Then he came up with this CA 83, and in that he has sought for recall of the order. And my lord, when this matter was,
How Mr. Banerjee came into the possession?
my lord, my lord, that is the question
No,
which my
no.
lord has to decide whether
So-
Mr. is in possession.
My lord, that matter is, my lord,
I'll tell you,
tomorrow, my lord, the division bench also dealing with this matter. Not this matter, but whether my lord, the liquidation matter will transfer to the NCLT or not.
Not in Apni.
No, not this matter, but other matters, my lord.
Lord.
That principle of, my lord, that
Lord, I am not.
no, this is part hard, my lord. That is my lord, the duty. Yes, tomorrow this matter will be taken up. Some of the matters.
Okay, no.
Taking
Lord,
the
I'll tell you, Lordship.
Now, see, want to file the affidavit. Let
Yes,
file
yes.
Yeah, but
definitely.
interim orders should stand extended, my lord.
Yes.
My lord, let this IA, my lord, then come up on 25th. Next Wednesday?
25th.
Next Wednesday, your day?
Yes, you will file. You will complete the
I'll
period.
file.
Then they have to file the reply.
But I have to file a reply there.
Then second.
2nd July.
Second.
40 and 41. 41 you are for the applicant.
Yes.
Both you are applicant.
83. C83, I'm the applicant.
41.
Yes, C83.
C83, 82, 41. So and so appearing for the applicant. So and so appearing for the respondent. You are also appearing in both the matters.
Yes.
And so and so appearing for the official
And
liquidator.
42, my lord, it is possibly for the application filed by the security guard, my lord.
Achha, security
Guard.
Later, that is later.
That is item 42.
Yeah.
40, 41.
No.
Then so it is submitted by the land council for the parties that the pleadings have been completed and matter is ready for hearing. In which the interim order is there?
Item 43. The order was directed to in item 40. In 41, CA 83.
It's ready for hearing.
If your lordships kindly takes up the interim order passed by Malajari Shubhata Majumdar.
Appear on 2nd July 20.
Day of the order, Malad.
Record order 41. So and so appearing for the
CA 92 टका दे.
ना वो 40 का है. अभी 40 का था.
83 तो
41. So and so appearing for the petitioner. So and so appearing for the RP. So and so appearing for the official counsel for the applicant. There is but time to file affidavit in opposition. Affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply if any is there to be filed within a week thereafter. List the matter on 2nd July.
Not happen.
Second.
Then, my lord, it will go to
2 weeks, 3 weeks.
9 July.
Let the matter happen. Both matter को 9 July कर. 9 July. Interim order is extended till 18th till 16th of July 2025 or until further order, whichever it is.
Okay.
Item 14.
My lord, I am for the official liquidator.
For the applicant, my lord. This is an application, my lord, filed by the security agency appointed by the official liquidator in terms of the order of this honorable court, my lord. When the last occasion, my lord, that order was not there in the record, my lord. So, my lord, yes, my lord, my lord has granted a leave to file a supplementary affidavit, my lord, enclosing that order, my lord.
76.
The order is at page 4, my lord.
Yes.
This is the order, my lord, in pursuance of which, my lord, the official liquidator has appointed the security agency for protecting the asset of the company, my lord. Subsequently, my lord, no payment has been made, my lord, and in very recent time, my lord, by a letter, the security guard has been withdrawn from the place where they were deployed, my lord. My lord, as on date, a sum of rupees 39 lakhs was lying due on account of security expenses, my lord. My lord, repeated occasion, my lord, we have submitted the bill and intimated the office of the official for releasing of the payment. My lord, no steps
My lord,
has been taken.
I am extremely sorry, my lord, in this matter. I am disputing something, my lord. Your lordships kindly keep this 4 weeks because it is a symbolic position. If the symbolic position is there, then how the security guard can be appointed?
That's why I am reading it.
Yes, my lord, your lordships kindly keep this 4 weeks.
Order of appointment is there, my lord, for application.
By which order? This order, the symbolic position is with the official liquidator.
My lord, kindly come to page 13 of my application, my lord. That is my order of appointment, my lord. My lord, my lord, that is up to them, my lord, but I have
Page
been
13.
Page 13 of my application, annexure B, my lord.
1-3.
Yes, my lord. Annexure B.
Yes.
My lord, that is the appointment letter, my lord. to the proprietor Shiva Shakti Security
Deputy
Services.
official
Please be
executor,
informed.
2008.
Hmm.
2008.
Please be informed that order
Eight or
for
eight,
Bond of by
18,
virtue of
18.
binding of
My lord, the third paragraph. In this context, your agency is being engaged to deploy the security guards in the aforesaid place as may be decided for such and such. So, my lord, I have been appointed by them. They cannot challenge my appointment. That means they have to deny their letter, my lord.
Kindly,
He filed affidavit.
no, my lord, no affidavit.
File the affidavit because there is a letter from your side only.
Yes, my lord, that I have
That is an
seen, my lord,
admitted document.
but I am feeling embarrassed, my lord, for making any submissions that is symbolic position. If it is symbolic position, then how security guard can be appointed? Yes, that I have seen, my lord. I have also asked the official liquidator. He is saying that he was not there at that point of time.
Deputy official liquidator, High Court, Calcutta.
My lord, that is there, my lord. But here also it is mentioned that in pursuance of the order passed by the Honorable Justice Arindam Mukherjee dated 14th December 2008.
That's why on the last occasion I want this. Now he has brought this order. It might be it is your symbolic position for the purpose of
Safety and security, my lord, they have appointed, my lord. My lord, moreover, I have a letter, my lord. They have withdrawn the security guard with effect from December 2024, my lord.
December 2024. And when appointed? 2008.
2008, my lord. But huge payment of the workers, my lord, that
To whom you submitted the bill?
My lord, to the official liquidator, my lord, all the bills are lying here, my lord.
And
My lord, from page 14 onwards.
If they dispute the bill, then what can be done? Then you have to prove your case.
My lord, now they are denying their own document, my lord. They are
My lord, let me check. Yes, I am filing, but because order says that actual physical possession, but officially it is very well.
Dealing with this document, what he is relying upon. So and so suffering for the applicant. So and so suffering for the official liquidator. The counsel for the applicant has filed supplementary affidavit disclosing the order dated 14th of December 2018. Let the same be kept with the record. The counsel for the official liquidator prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks. Reply, if any, thereto be filed within a week.
This is the document by which, my lord, I have been withdrawn from the service, my lord.
Within a week thereafter. Please the matter on 2 weeks, 3 weeks, on 9th of July 2025.
And I'm deeply blessed.
Yes.
3 815 of 2017. This is my application seeking.
Yeah.
But CA 15 of 2017.
15 is not there. It's 14.
I am for the official liquidator in this matter.
CA 14, 43 is CA 14.
Look, there are two CAs. 14 has been filed in the year 25.
That is the only. That is only in the list.
No, Milod, then Milod, I have an application which is CA 17, Milod. CA 15 of 2017, Milod, seeking to disclaim a property, Milod, which was let out to the company in liquidation.
Where is that?
No, Milod, it has been filed, Milod. It was heard on a lot of occasions. Orders have been passed by this honorable tribunal, honorable court, Milod, coordinate bench of this honorable court, Milod, on several occasions. However, Milod, today it is not appearing, Milod. I have been told, Milod. Then this.
Show me any order.
Milod, I'll indicate the order.
CA 14 of 17.
May I submit the report, my lord? Because this property was put up for sale as per your lordship's order. My lord, if your lordships kindly take page 6, that is your lordship's order passed on 16th April 2025.
Only movable property, furniture, fiction are there, and the total cost of so copy is night. Report. So what has happened now?
Now, my lord, your lordship kindly turns to paragraph 2, 3, 4. My lord, sale could not be taken place.
Despite of the above newspaper order, it was learned that neither any earnest money deposit nor any offer was received. Retail contribution. Nobody is coming forward.
My lord?
Nobody is coming forward.
Nobody is coming forward. So that's a reason for paragraph 5, my lord. If you lordship say I am seeking now, because valuation is required to be reduced.
What is the value? 46,000 only.
Yes, but no offer has been received. But if your lordship say that on again, I shall, my lord, not published by, but by way of email.
What is there? Furniture. What are the furnitures?
Furnitures in my
furnitures and
furniture is lying in my property. That is the second valuation report. The paragraph three,
property.
yes, paragraph 3 of this
So
application.
they are not claiming the property.
No,
No.
they're not.
They are
Therefore, I'm
claiming
seeking disclaimer, my lords, for the
disclaimer.
image.
So
This is only in
you
respect
do
of
one
the
thing, you
movable
pay,
assets.
you pay 46,000, you take the
Because
furniture.
I don't
and
want the movables,
Right.
my lord.
That would be fair, my lord. That would be
you
fair.
take-
Otherwise,
you give the 46,000, or you consult your client how much amount you will pay. I will accept that and I will pass.
Lord, I'll take instruction in this regard.
That
If
is
I
better.
can take, my lords. I can
that
take
is
instruction.
better. That would be better.
I can, definitely. My lords, if your lordship will kindly take the order dated 18 July, I've handed over, my lords. My application was heard. The official liquidator came and said that they will disclaim the property.
Correct. On the last occasion also, they are not claiming your property.
Very well. My lords, I'll take instructions whether we want to buy those movables or not.
If you take the buy,
Try to. We'll try to.
try.
We'll try.
There are two flats, my lord. Your lordships kindly see paragraph 5, my lord. There are two flats. For which, my lord, I am seeking, my lord, the valuation. Kindly see, my lord.
Revati apartment, Mauza, so and so, so and so.
Yes.
Another is. Acha. One is the statutory Lenin.
Yes.
Which property you are claiming?
Plus 156A Lenin Sarani. Paragraph
is
3,
one.
my lords. That is not.
The second property you are not concerned.
That is also not the subject matter of
That is not the subject of my application.
So what do you want? The second property?
My lord, the fresh valuation.
Second property valuation not there earlier?
No, earlier there was the valuation report, but this valuation report, my lord, kindly see in view of that fresh valuation required through empanel valuer of the assets situated as so and room number so and so 13 and property, my lord, as detailed in the sale notice before any other attempt of sale of assets and
No,
property.
last occasion when this court has passed an order, that is only with regard
That
to
is
the
only with regard to the
furnitures.
Yes,
Fixture and furnitures.
Yes. Now I am seeking, my lord, the valuation in respect of the two several properties.
Two several property, but one property is of him.
Yes. Now your lordship
So you are not
kindly
claiming.
Yes.
Apart from the two flats.
Yes, your lordship kindly see your lordship's order, page 6, paragraph 2.
Property shown is 74,60,000 and
Yes,
the value of the item
yes,
available
yes,
in so and so,
yes,
so and so.
yes.
So this 74,60,000 of which property? Both
That is
property
in
two-
respect of the two properties, my lord. That is 502A, 5th floor,
No.
Kolkata. No, sorry.
That is only one.
Poddar Road. only
502
Poddar-
is my
Howrah.
property, my lords.
Howrah, my lord. That is in that is
Property he is referring to Shakti.
Revati apartment at Mauja, my lord, Podra, my lord, page 5. Jail number 38, RS Dak number 460, RS Kotian number 92. So and so.
Yes, page number 8 is there, no?
Yes.
You publish that.
Page 5 and yes.
No, page 8 is a publication.
Yes, page 8
statement.
is the publication.
So you want the further publication of the property?
No, fresh valuation, my lord.
Fresh valuation. So how
And
it can-
publication in the portal. Portal to immovable property.
Howrah. Podra district, Howrah.
Yes, only in respect of the valuation of the immovable property.
So and so applying for the applicant. So and so applying for the official liquidator. Official liquidator has filed the report. Let the same be kept with the record. He submits that in terms of the order passed by this court, dated 16th April 2015 and 2025, the official liquidator has published the notice of auction in respect of unit number 1 and unit number 2, but none has come forward to purchase the said property. Accordingly, counsel for the official liquidator prays for an order for revaluation of the both revaluation of
No,
both.
but the
not
Revati apartment at Mauja.
No, that's a Revati appointment and this furniture.
Yes, yes.
Furniture also.
No, furniture, my lord, if my lord,
They will-
my
they will
lord,
take
agree,
instruction.
then my lord.
Revaluation of the property being Revati apartment at Mauza, Podra, JL number 38, RS Dag number 460, RS Khetian number 92, LR Dag number 604, LR Khetan number 2780 near Andul Road and Podra Road crossing PS Sankrail, near Podra, District Howrah. Police stop. Counsel for the applicant submit that another application being CA
15, my lord.
15 of 2017. And it's CS 7 of 2017 within bracket. Old CS 15 of 2017 is also pending, and that the matter is to be listed today. Is to be listed before this court. Police stop. Concerning the submission made by the counsel for the respective parties, the official liquidator is given liberty to reevaluate, to obtain revaluation report of the above mentioned property within a period of 2 weeks.
2 weeks, 3 weeks, man.
Within a period of 4 weeks.
4 weeks.
Within a period of 4 weeks. 4 weeks, and to submit the report before this court. Let the matter appear on 23rd of July 2020.
23rd of July. Deeply blessed.
Along with CA 7 of 2017 within bracket old CA 15 of 2017.
Your lordship, kindly ask them to take instruction with
I
regard
take
to
instruction. In the meantime, the counsel for the applicant is also directed to take instruction whether the applicant is ready to purchase the furniture and fixtures available in
Property which I'm seeking to disclaim, my lord.
property in which the applicant is seeking disclaimer.
Deeply blessed.
You take your order. Next. Not today.
But I am for the official liquidator.
Yes.
But possibly this is an application filed by the ex-director. Last occasion they did appear.
Ex-director appeared on the last occasion.
Yes, but they did
Santosh
appear.
Sengupta, counsel for the officer, praise for time. Have you report?
No, my lord, there was no direction for filing in.
Counsel for the official liquidator, praise for time to file report.
Oh, I'm sorry, my lord. Then, my lord, kindly keep it next week.
None appears on behalf of the ex-director. Influences offering for the official liquidator. Counsel for the official liquidator, praise for extension of time to file report. Let the report be filed within 3 weeks. Within 3 weeks. List the matter on 16th of July.
16th. I'm deeply.
Next.
Lordship, regarding item number 46, it's a complaint matter, your lordship. Here the service has been, summons has been issued upon the directors and statement of affairs has been filed or submitted only by the accused number 3. But the others have not submitted. So your lordship, the warrant of arrest can be, direction can be given on that respect.
Where is the report? Service has been affected.
Lordship, the statement affairs of accused number 3 is there on the record. It's,
But with regard to the others?
other service, your lordship's a transferred brief, lordship, the service.
As the report is not there, how the warrant can be?
Then I have
Then
to serve.
tomorrow you have to face the consequence before the appellate court.
Then your lordship, I have to serve again.
So and so appearing for the complainant / official liquidator. None appears on behalf of the accused persons. Counsel for the official liquidator prays for time to take appropriate steps for issuance of notice upon the accused persons. Let
46.
the petition is direct, the complaint is directed to take appropriate steps for
Point the order.
within 4 weeks. List the matter on 16th July.
16th July.
Yes, 47.
Lordship, regarding article number 47, your lordship. Here, your lordship, we are praying for the fixing of a sale
date for sale, as well as let the notices be served by handbill, because the funds are very meager, your lordship. We cannot go for the advertisement and all procedures. So that is the reason, your lordship, in the summons for direction, your lordship, we have sought for the direction.
What is your prayer?
We can also publish it over the website of our website, your lordship. That is also possible. But apart from this, your lordship, the fund is
CA10.
CA10. Lordship, prayer C can be allowed, as well as prayer D. Prayer D was already allowed. Prayer D was, your lordship, already allowed, your lordship. What
We given to the officer to refund the pay order of intending purchasers, Suman Enterprises, of 1,60,000.
We have opened the valuation, your lordship, and the reserve price has been fixed as 1,37,000 and all.
Earnest money 4,05,500. And Sri Mahabir Enterprise 1,55,000 in second position. Deposited sum of 20 as earnest money to conduct a fresh sale. So what about whether they have come forward?
Lordship,
Suman
regarding
Enterprises and the Mahabir International, the amount is to be refunded first.
refund.
That is the prayer.
Lordship, the Lordship CA10. Refund ka sir?
CA10. Kindly come to the prayer B.
Refund we have done. So far as my
Where is
instruction.
the auto report?
Lordship, then to that effect, we have to give a report.
If it is done, then I will pass an order for a press.
Lordship, we have refunded, but whether to that effect, your lordship, it has been intimated before the honorable court, your lordship. That is to be looked into.
You do one thing. I am fixing next week. You submit a small report. Then I will allow the prayer B, C and D.
Lordship.
In the meantime, we refund the EMD.
What? That's I'm telling you. Refund. If you already refunded, you file a one-page report here.
1 week will suffice.
Because unless and until the report is not there against sale, then it will be difficult.
Lordship, in that effect, 2 weeks, your lordship.
So and so appearing for the official liquidator. Police. The counsel for the official liquidator submit that the EMD has already been returned to the highest bidder, namely Suman Enterprises as well as Sri Mahabir International. In view of the above, the petitioner, the official liquidator is directed to submit the report within 2 weeks from date. Let the matter appear.
16 July, your lordship.
16 July 2020. Next.
Lordship, this is an application. Here, your lordship, we are seeking for the withdrawal of the security guards. But the only difficulty is, since the sale proceeds has not yet been completed, this application cannot be moved at this juncture, your lordship. Lordship, I'm praying for the adjournment for this particular application at least for 6 weeks. Until and unless the sale proceeds are complete, your lordship, we cannot get the money out of it. We cannot pay the security guards also.
As per the prayer made by the counsel for the official liquidator, as per the prayer made by the counsel for the official liquidator, the case is adjourned. Let the matter appear on 16th.
Lordship, matter is returnable.
16 July.
16 July. Lordship, if it can be in this particular application, if it can be adjourned a bit further, your lordship.
2nd for July. 2nd July.
2nd?
July.
Then 16 July, it's okay, your lordship.
कोई ऑर्डर है इसमें? कुछ ऑर्डर नहीं हुआ? कोई ऑर्डर नहीं है? विश्वनाथ समोदर सबके पास और ऑर्डर नहीं। Yeah, this is disposed of. Record an order. By an order dated 4th February 2016, this court already disposed of the present application. Accordingly, the department is directed to take appropriate steps to delete the case from the cause list.
My lord, I appear for Securities Exchange Board of India. My lord, on 9th April, my lord has asked for a report, my lord, on the present status sale, my lord. My lord, this is the report in the seal cover.
None appears, none appears. Earlier wala na? None appears.
Appears.
Yes.
Counsel,
The
kindly keep
advocate
my
appearing
report.
SEBI press for time to bring on record with regard to the status of the company.
That I have already handed over the report.
আরে এখানে আছে তো।
The second paragraph is immaterial because it has been filed but not yet moved.
2018.
2018. It's pending, my lord. There is no order subsisting right now. But
So why you are not mentioning the matter before the appropriate court and get it dismissed?
my lord, it's the action of the depositors. They are not taking it up, my lord. We are doing it on our statutory rights, my lord. We are selling the properties. This is what lying with me, my lord, for the time being. And regarding one other property, there was a recent auction, my lord. There is a dispute pending in the form of a writ petition.
Yes. The matter is also pending before the
Matter is pending before court number 14.
So what can be done now?
Right now, my lord, this is the available money that I have. I can go on with the auction because there are various other properties which are there.
You can go on, but the one is the pending before the high on the in the writ petition.
Writ petition is pending before the division bench.
This court can.
I can periodically file the report. That's
That
what.
is only. I am keeping this report and I am fixing the after 8 weeks.
Very well. Grateful.
So suffering for the SEBI, CBI. Yeah? In terms of the order dated 9th April 2025, an advocate appearing for the SEBI has filed the report. Let the same be kept with the record. This is the matter on 27th August.
Obliged.
Now, cover में रख के रख दो, बाबू. रिपोर्ट कवरी में रख के इसमें रख देना. आज का डेट था. Next.
Lordship, item number 51. This is the application for dissolution.
None appears for the parties. Who has filed? Who has filed this application?
CA 13 is the application for dissolution.
PA?
No, 51. 51.
51. CA1. Where is the CA1, Dadu?
Lordship, CA1 is the complaint matter. Here, your Lordship, CA1 is the complaint matter. Lordship, here, though we have served notice upon the ex-directors, but they are not appearing. Lordship, upon instruction, your Lordship, while submitting, let this complaint be dropped, your Lordship, because we are not getting any fruitful result. The matter may not yield something fruitful. Apart from this, we have filed an application for dissolution, which is also appearing in your Lordship's list.
No, this is something else. Kindly given the officer appoint the valuer from the panel of the advocate and the leave may granted the officer liquidator to invite the claim of the creditors. So file the report, then I will close it. File the report. How much time? 2 weeks.
16 July, your Lordship, let this matter also come up.
So appearing for the officer liquidator. Counsel for the officer liquidator, prays for time to file report. Let the report be filed within 3 weeks. List the matter on 16th of July.
Lordship, 52 is the complaint matter.
Yes.
Lordship, here, your Lordship, we have served notices
Suman
on the
Bhattacharya,
ex-directors.
Supriya Ghoshal, Sunil Ganguly, 2007.
But your Lordship, upon instruction I'm submitting, if this can be my humble submission, is that we don't want to proceed with this complaint matter.
File an application. Complaint case, otherwise, tomorrow the lawyer change, then you will be in difficulty.
Lordship, we have also filed a dissolution application because this complaint matter might not give any positive result because the notices what we have served, your Lordship, they have not come up with proper service also, with the proper remarks. That is the difficulty. So simply by lingering this complaint matter, the main company could not be dissolved, may not be dissolved, your Lordship. That is the predicament.
Come with an application, I will dispose of that on taking that ground. Since appearing for the officer liquidator. As per the submission made by the counsel for the officer liquidator, the case is adjourned. Let the matter appear on 16th. Next. Same.
53, your Lordship, it's an application for dissolution.
That will not happen unless this will happen.
So, Lordship, this can be adjourned.
Same order, madam. This also.
In this matter, Lordship,
For the petitioner, madam.
And for the official liquidator, Lordship, pursuant to your Lordship's
Lord.
direction, we have filed a requisite before the department for issuance of fresh summons.
My lord, upon receiving of the summons, we had filed an application. At present, this is an application for extension of time for filing of the written statement, my lord. In the meantime, my lord,
written statement.
Written statement.
In this matter, Lordship, I'm representing Mr. Arup Chatterjee and Baby Chatterjee, Lordship. Over telephone, he has instructed me to take 1 week time. They have received the summons, Lordship, but due to ailment, they are in Delhi, Lordship. So, Lordship, this matter,
Let the warrant be issued, they will come free of cost.
they will come, Lordship.
From
Some-
Delhi to Calcutta, they will come free of cost.
Some operation is undergoing as per my instruction, Lordship.
And if they will come here, then I will send to the proper place the free of cost of that operation, also the free of cost. You are appearing for whom?
No, it's a different
lord,
matter, I
as
think.
my
So
matter
altogether
was
different matter.
commercial matter, my lord. This is non-commercial matter. I'm sorry.
Commercial suit.
Yes, madam.
No, it's a company suit.
I beg my apologies, madam. My apologies, madam.
So appearing for the official liquidator. So appearing for the accused persons. Counsel for the accused persons submits that the accused persons have received the summon, but at present they are in Delhi for medical treatment and placed for what time? When they will appear before this court?
Next week, any day, by your Lordship.
Within a week. In view of the submission made by the counsel for the petitioner. Counsel for the accused persons, let the matter appear on 2nd July 2020 for appearance of the accused persons. Huh? Yes. Yeah, Rochigi. None of person of the body nor any adjournment. Officer liquidator.
Keep on next week. Next week, keep on next week.
No steps. Have you taken steps for issuance of notice upon the accused persons, summons upon the accused persons?
I will check them.
As per the officer liquidator appearing in person and he prays for time. In view of the submission made by the officer liquidator, case is adjourned. Let the matter appear on 9th July. Next. Not today. Not today. Not today.
My lord, I'm there. My lord, item number 54. 58, my lord, 58.
Yes.
I'm there, 50. My lord, all those new central matters, my lord, I'm there. I'm being led by my senior, my lord, Advocate Sushanto Datto. We are for the operational creditor, my lord, the creditors, my lord. So,
This is
the
a
official
complaint
record.
matter. 20 is a complaint matter, Lordship. We have
Then
filed a requisite for issuance of summons, Lordship.
Yeah, this is the accused person. Have you received the notice?
No, they are the petition.
I am the
Who are
I am the petitioner created a petition created in the original CP, my lord.
original CP.
Yes.
You taken due to some difficulty. Yes. Taken steps.
Lordship, we have filed a requisite into the
Any reporters come? Number 5 dead.
Dead.
There is a report of the sheriff. Number 5 dead, police report and death certificate is here.
Mahesh Singh.
Mahesh Singh. In comparison, so. Copy of the death certificate. Yes, death certificate is there. Four and 5. What about the 1 and 2?
Others have received, Lordship.
This undelivered packet, date and dispatch. Others, there is no report.
Audit matter.
Mahesh Singh, there is a report. Sipai Ram, not served, written unserved, left. And with regard to the other word, what about the others? Others report has not come. Any other report is there? No. Alok Palit and Ashok Dev. So what about the Mahesh? There's a death certificate and report is there of the police authority. Bajbaj PS. And he died on 2017. When you filed this complaint? 2020.
Yes.
Against the
We
dead
were
person.
not aware.
Against the dead person. So appearing for the official liquidator. Deputy Sheriff of Calcutta has filed the report. Number 4. Yes, MHS. Died on 28 January 2017. As regards the service upon the Sipai the official liquidator / complainant raise for time to take appropriate steps. Let the matter appear on 23rd July 2025. In the meantime, the official liquidator is directed to take appropriate steps for service of notice upon the accused persons. Next.
Another matter is Lordship for that security expenses by the secured creditors. Lordship, pursuant to your Lordship's directions, I have served upon the securities.
My lord, in this matter also, I am appearing for the petitioning creditor. My lord.
You are appearing for?
But I'm for the security agency, my lord. My application is the next, very next item, my lord. This is an application.
This matter.
Yes, my lord.
In this matter, you are appearing?
Yes, my lord. I am for the security agency, my lord. I am not a party, my lord. I have filed a separate application, my lord. That is the next item, my lord.
Okay.
With the self cause of action.
In this matter, what is the where is the application?
Lordship, if the secured creditors are not paying, so how can we pay the security expenses, Lordship? It's a huge expenses is pending, Lordship. Despite the order of this honorable court, and we have served upon them, but they are not appearing, Lordship. There are 4 secured creditors, and if your Lordships kindly come my report, Lordship, at page 18, page 17 and 18, Lordship, which I have filed before your Lordship, that your Lordships will find a huge security expenses is due. Which I have filed on.
Total security expenses 4 lakh.
No,
4 crore.
Yes.
Amount paid 1 crore. Pending 2 crore 96.
Yes.
So, yes, you are appearing for whom?
No. He is for petitioning creditor, Lordship.
I am for the petitioning creditor in all these 3 matters, my lord. 58, 59, and 60.
But again, I have to, if your Lordships kindly give a direction. This is a last ultimatum to them. If they don't pay, we can't bear the cost of the security expenses, Lordship. It's a huge
They are not
property.
appearing.
Lordship, last time I think that RCL appeared. Thereafter, I do not know. They are not appearing, Lordship.
Respondent number 2. Who are they? Asset Reconstruction Company, Industrial Financial Corporation. And notice been issued.
Yes, Lordship. I have filed a affidavit of service, Lordship. Intentionally, I think they are not appearing, Lordship. Despite of several opportunities.
That's the affidavit. The report. This is a report. Affidavit of service. Served to all.
Yes, Lordship. Earlier, we have served to all.
This time on hold. Not
Lordship, there are 4 secured creditors: IDBI, Asset Reconstructions, and Industrial Financial Corporation, and Indian Bank. Now,
five. Shalimar also.
Shalimar also.
Shalimar Industries also.
no, Shalimar is not a secured.
Five.
No, there are 4 secured creditors.
Shalimar Industries also.
In your application, you have made a party them. Kindly see. Shalimar also.
Shalimar is a petitioning creditor.
But you have mentioned as a respondent. Kindly come to your application.
My application, Lordship?
Report also. And
no, report is a petitioning creditor I have mentioned, Lordship.
No, kindly. Applicant, respondent, CA. You have a copy of the CA 13?
Yes, Lordship.
Kindly see the cost data.
In the matter of Shalimar Industries, a company, it's a petitioning creditor.
Where? But here. You have mentioned in the petition creditor and you have made the respondent also. Respondent number 5 also.
It's a mistake. Department. Oh.
So, what do you want?
No, now main crux of the matter regarding these applications is we want some money from the sick.
That's why for that let you give this affidavit, the service you filed, that is not that is on hold. It is not served. Kindly come to the one is delivered. Another is on hold.
Then again, I have to serve, Lordship, give us very short date.
To deliver, 2 is on hold. To deliver, 2 on hold. Where is the postal this speed post receipt? How you can tally to whom it was served? How you can tally the number?
17. Item delivered, out for delivery, on hold, all looked, intimation served.
Delivered to Indian Bank. So you take steps, file affidavit service.
But in respect to the next application, my lord, we
Suffering for
again, I
the
have to
officer
serve.
liquidator.
My lord, may kindly record my presence, my lord, in all these 3 matters.
Suffering for the petitioning creditor. The officer liquidator has filed the affidavit service. Would find that the service has not been affected. According counsel for the officer liquidator, prays for time for taking appropriate steps for issuance of fresh notice upon the respondents. The officer liquidator is directed to take appropriate steps for issuance of notice upon the respondent within 3 weeks from date. This is the matter on 23rd of July 2020.
Na mailটা দেয়নি সবকটা
my lord, item 60 is my application, my lord. I am for the security service provider, my lord. This is my
They are
application.
not having any amount. They are telling that they are not having.
Duty of the, my lord,
You bring that the respondents.
my lord, we have also served, my lord. They have.
I will require that.
My lord, we have also served, my lord. Apart from Indian Bank, everybody has received, my lord.
সবাইকে দিয়েছি mail?
This is affidavit service, my lord.
Where is the affidavit service?
Lordship, we have sent them a mail also.
File again. You send the mail.
Yes.
Along with this copy and file the report. If it is served, then we'll see to that next date. If they will not appear, then
yes, Lordship.
What is to be done? The court will see. What about this amount? Have you filed affidavit?
Lord, they are also filing an application for seeking the release of my payment, my lord. So, my lord, that application is related to each other, my
So
lord.
let this application. This may be come along with the other application.
Yes, my lord.
Suffering for the official
The main
liquidator.
problem is that we don't have any funds. If the secured creditors
That's
do
why
not
let them
release the
bring.
funds,
Issue notice that they will not come. Then the court will see how they have to bring before this court.
Much obliged.
Suffering for the official liquidator. Police counsel for the official liquidator. Press for time. Accordingly, case adjourned. Let the matter appear on 23rd July. Next.
Grateful, man.
next day.
23rd July. Yes. Nobody. Official liquidator. Yes, what is the prayer? Appoint a chartered accountant out of the panel of the liquidator.
She goes and company.
Huh?
In panel chartered accountant we appoint.
For what?
For audit of the accounts of the company prior to the liquidation. This has been given to the council, but he has not appeared today.
What can be done? Next date?
Next date.
As per the prayer made by the official liquidator, the case is adjourned. Let the matter appear on 9th July. Next.
Item number 62, we have filed an application, taken up an application for dissolution. And accordingly, the auditor's report has also been submitted, Your Lordship. Now the rest is pending is the direction for dissolution. Because the fund position is also here very meager.
What the report says?
But the report has been submitted before the registrar. Right? Auditor's report is not with me.
Neither found any assets for disposal or any payback to the creditor, nor receive any auctionable claim. So what will do?
Lordship, the company can be dissolved. Prayer B can be allowed, Your Lordship, as per our summons for
During
direction.
the course of proceeding, the officer legal directed so status report be filed. An application resolution of the company was filed before this court.
We can allow.
Where is the application for resolution?
CA 3, Your Lordship, the summons for direction, Your Lordship. Paragraph 10 of our application. Final account. That the auditor's report हो गया है. Fund position यहाँ पे लिखा नहीं है, वो auditor's report में होगा.
15,000 rupees. Now it is 16,893 as on 31st of March 2023. What you will do this amount?
Lordship, it will be refunded. Lordship, prayer D of our
Transfer to Reserve Bank of
Reserve
India
Bank.
under section
Where is your application?
455, 455,
555.
555.
Prayer B.
So suffering for the official liquidator. Official liquidator has filed report. Filed audit report, wherein it reveals that as on 31st of March 2023, an amount of rupees 16,893 is lying in the account of the respondent. Consider the submission made by the council the office council for the official liquidator placing an order
Here comes
for dissolution of the company. Resolution of the company. Consider the submission made by the council for the petitioner, peruse the report. Prayer A.
Prayer B, Your Lordship.
Prayer A and B. Dissolution.
And B.
A and B.
After deducting the necessary expenditures, Your Lordship, the rest of the amount may be transferred.
A and B. But you are not prayed for.
Lordship, in that fashion, that has not been drafted, but Your Lordship, the prayer is.
Prayer A and B is allowed. But 16,000, what will remain? Prayer A is allowed.
Lordship, the necessary expenditures.
Prayer A is allowed, and the official liquidator is at liberty to recover the expenditure made in the process, and if any amount due, the official liquidator shall deposit the same in the public account of the Reserve Bank of India as per the provisions of section 555 of the Companies Act.
After deducting the necessary expenditures, Your Lordship, rest of the amount will be transferred.
The CA number, so what is the number? CA number 3 of 2023 along with CP number 602. Oh, no, you have to file the application on your report, no? After
We can file the status report.
After the dissolution, the official liquidator is directed to file the report within 4 weeks.
16 July.
Within 4 weeks, leaves the matter on 16 July. By 16, not 4, by 16 July, correct? By 16 July. Next. Not today.
Lordship, item number 64, Your Lordship, I'm praying for 2 weeks' time because, Your Lordship, this is an application for dissolution. And there are other applications also. So these all the applications are required to be looked into. Lordship, I'm just praying for a week's time to get proper instruction in this matter.
This is as per the prayer made by the council for the official liquidator. The case is adjourned. Let the matter appear on 16 July. 16 July. Next. Not today.
64 is report.
Not today.
Item number 66, I'm filing the report, Your Lordship. Here, Your Lordship, on the earlier occasion, my lord has been pleased to direct to file. We have sought for to file the auditor's report. That has been filed, Your Lordship, along with the status report, Your Lordship. So, Lordship, the auditor has also submitted his professional bill amounting to rupees 74,000. So, necessary direction can be passed to your Lordship for disbursement of that amount.
Closing balance is rupees. So much amount is there. Closing balance 292 and professional bill is 74,000. So where from you will pay?
Lordship.
Please to official legal professional fee. Where from you will pay?
Necessarily, we will pay the payment from official funds.
From the establishment fund. But this is also with
Dissolution.
Lordship, this is an application for dissolution, and your Lordship, there will be very meager amount, your Lordship. So the company can be dissolved, but the amounts for required for necessary expenditures, your Lordship, that we have to take from the establishment fund.
Expenses and suffering for the official liquidator. Official liquidator has filed the report wherein it revealed that the official liquidator has appointed an auditor to account the audit of the company within bracket in liquidation, namely Messrs. C. Ghosh and Company, chartered accountant. And after the audit, the report has been submitted wherein it reveals that the closing balance is rupees 292.62 as on 31st of March 2020. The counsel for the liquidator submitted. The auditor also submitted the professional fee of rupees 74,045, including GST. For the printed submitted, the petition, the official liquidator has filed the present application, praying for dissolution of the company in liquidation.
Dissolution.
The learned counsel for the petitioner and the official liquidator produced the report and the audit produced the report submitted by the official liquidator along with the audit report. This court find that the closing balance of the company who is in liquidation is having only credit balance, is having the closing balance of rupees 292.62 as on 31st of March 2024. In view of the above, prayer A, prayer 2 of the summons for direction is allowed. The official liquidator shall pay the professional fee of the auditor from the general account. From where you will pay the amount of from the establishment account within a period of 2 weeks. 2 weeks. The official liquidator is directed that after the dissolution of the company in liquidation shall file the report within 3 weeks. List the matter on 16 July. Next.
67 and 68 are arising out of the same matter. CA7, that's item number 68.
CA6 is an application for dissolution, but yes, you see that we have
CA7 is my application and CA6 has been taken out by the liquidator. On the last occasion, learned friend had taken time to evaluate the papers that we have submitted claiming our heirship right. Surplus amount is left for disbursal upon the heirs of the shareholders.
Lordship, CA7 is their application. We have filed an opposition also to that effect. Lordship, their claim may be settled after the papers has not yet been settled in that manner. The claim has not yet been settled. So, your Lordship, 3 weeks time may be granted. We can.
Have you received the affidavit?
No, the affidavit I have received.
3 weeks time because
We have filed a reply also, not the last.
reply has been filed, your lordship, but this regarding the settlement of claim, your lordship.
So what? How much time?
Lordship,
Settle
3
it.
weeks. Because there's a dispute between the heirs also. The papers, all the documents are
But
required.
there
to
are
be
no
produced.
disputes. There are no disputes. They want us to not bring records. Not we shall furnish not whatever documents are required. One
You
day is
do
required
one
to
thing. I
answer.
am passing a direction upon the petitioner to whatever the document we place before
Absolutely.
you within 2 weeks from date, and after receipt of the you dispose of the you settle the claim within 2 weeks thereafter, and to file the report before this.
Absolutely.
That will be
Keep it
better.
pending.
I am keeping the
Great.
pen.
Great.
Then after the report, then I will
Great.
dispose. So offering for the petitioner. So offering for the official liquidator. Full stop. Counsel for the official liquidator prays for time to settle the settle the amount, settle the funds. How many, what is the fund?
It's about their admission as per their affidavit, 2 crores 4 lakhs
4 lakhs.
58,990.
Settle the funds available with the official liquidator. Full stop. Counsel for the official liquidator submitted there is a dispute, and as such it requires 3 weeks time. Full stop. This court find that to settle the issue between the parties, comma, the petitioners are directed to submit all their claim paper, all their relevant claim paper before the official liquidator, all their claim paper and connected documents with the official liquidator within 2 weeks from date. Full stop. On receipt of all the documents from the petitioners, comma, the official liquidator shall settle the claim of the petitioner within a period of 2 weeks thereafter, and to file the report before this court a week thereafter. List the matter on 30th July 2030.
Obliged.
For filing report by the official liquidator.
Obliged.
Next.
So this company is also this application for dissolution of the company. There are several companies. Application is filed for several companies for dissolution. This is the one company.
Report
So
has
kind-
come.
Yes, lordship.
There is no report.
Yes, lordship. Keep on some other date because all the companies we kept similar date.
Which companies?
Other 17 companies, lordship.
It is listed today, no?
No, not listed.
As per the prayer made by the council, as per the prayer made by the office.
Payment has already been made. That is my instruction.
Okay, come with the report. As per the prayer made by the official liquidator, the case is adjourned. Let the matter appear on 16 July.
16 July.
Next.
For the petitioner, my lord, in this matter, on the last occasion, your lordship had granted time to file our opposition. Your lordship, I seek extension of time.
I
to
am
file-
for the state of Bihar in this. We had filed our opposition. Your Lordship, I have also instructions that against some DM Rohtas, also an application has been filed. That copy has not been served, if that could be served.
You are appearing for whom?
I'm for the petitioner. My lord.
Petitioner.
Petitioner.
RS Sasaram
Yes,
Light
my lord.
Railway.
Yes.
On
You are
20
appearing for?
State of Bihar, 26th February 2025, a direction was passed to file
The
the
reply, my lord.
reply.
My lord, may
Lordship.
kindly
We had
extend
filed
the
our
time.
opposition.
February, now we are in June.
My lord, may grant us very short time, my lord.
Or? Counter reply.
Reply, my lord.
Reply to the CA 13?
Yes, my lord.
CA 13?
Yes, my lord.
CA 13 filed by you, madam.
Your Lordship, they had filed it. We had filed our opposition.
For reply to
yes.
this. Where is the opposition? Opposition is there. Opposition on behalf of the state of Bihar. What about the who is appearing for the other respondent? Kedarnath? Have you served?
My lord, I have not been properly instructed, my lord. Perhaps, my lord, I'll not be able
Who is
to.
Kedarnath?
He's the liquidator, my lord.
Liquidator?
Kedarnath, yes, my lord, liquidator of the company.
Have you served the copy?
My lord, I'll have to take instructions on that, my lord. But perhaps it has been served, my lord.
Perhaps it been served, then how the matter can be heard unless the copy is not served to them? They are the state of Bihar. They are not the party, but they were intervening in this.
They are not.
Lordship, because before that directions were passed that if we don't appear, then directions will be passed against us ex parte. In the order dated, it was recorded before
When they have been added.
My lord, I'm a new entrant, my lord, in this matter. My lord, I have not been instructed. I have only been
Copy of the
instructed.
application along with the order dated census present thought upon the Chief Secretary, Government of Bihar. As well as, so you are appearing for the Government of Bihar, State of Bihar.
Your Lordship. On 9th January, an order was passed that if we don't appear,
So appearing for the petitioner company. So appearing for the State of Bihar. Counsel for the petitioner press for extension of time to file affidavit in reply to the affidavit in opposition filed by the State of Bihar. Let affidavit in reply be filed within 1 week.
10 days, my lord.
Within 2 weeks. After serving the copy to the Learned Counsel for the State of Bihar, release the matter on 9th of July.
Grateful.
Obliged.
Item number 71, I'm for the respondent. The applicant was supposed to file their reply because there's a piece of parcel of land which the petitioner is seeking registration, and that
File the affidavit in opposition.
we have filed an opposition. Since this particular property was not included in assets, we have filed an opposition. Reply is yet to be filed. Lordship, matter may be taken up next week, your lordship.
Have you served?
Lordship, that has been
Affidavit in
served.
opposition है क्या? File में है?
They were supposed to file the reply today. The copy has not been served.
It is not filed.
Opposition has been filed, your lordship, on the.
No opposition is there.
Lordship, kindly fix the matter next week. I'll come up with the opposition if it has not been filed.
None appears on behalf of the petitioner. None appears on behalf of the petitioner. Consistency appearing for the official liquidator. Counsel for the official liquidator pays for time to take instruction. In view of the above, the case is adjourned. Let the matter appear on 2nd July.
Attorney. Second.
Next.
This is my application, my lord. My lord, my property was taken over by the liquidator and has been sold off, my lord. It's really in the nature of disclaimer, my lord, and correction of a deed of conveyance executed in favor of the second respondent, my lord. I have, my lord, my affidavit in reply ready, my lord. I will serve, my lord. A date may be fixed for hearing of my application. It's ready otherwise for hearing now, my lord.
What is the prayer now?
The prayer is, my lord, for correction of a deed of conveyance, my lord, where a portion was, a larger chunk of land was in possession of the company in liquidation. The liquidator took possession of the entire property and sold it off. A portion of it was my property, which I had rented out to the company, the documents on record. So they cannot show ownership of the company. It's my property and I've lost it, my lord, because the entire land has been sold off to the...
Sense appearing for the petitioner. Petitioners.
Yes, my lord. Petitioner. Applicants rather.
Applicants. Applicants have filed affidavit in reply. It is found that readings have been complete.
Affidavit in reply to the opposition filed by respondent number 1 and 2, my lord.
The affidavit
I have
opposition
received.
filed by the respondent number 1 and 2. Let the same be kept. You are appearing for?
Official liquidator.
Public then, Swens appearing for the official liquidator. Let the matter appear. When? 23rd July?
Yes, my lord.
23rd July for hearing.
23rd July.
On people.
For hearing, huh?
73, my lord. Initially, my lord, we had filed an application for stay of the winding up under section 466 of the old act. My lord, we had paid the entire amount of 1.45 CR, 1.45 crore, and the winding up proceeding was stayed. Stay of the winding up. Kindly see the order of 12th February 2025.
12th February 2025.
May I-
This court state.
No, by the coordinate bench.
That's why.
May I hand over a copy of the 12th February order?
Official record shall not proceed with the instant winding up proceeding any further until the further order.
And
On
kindly
disbursement
see,
of full amount to the ex-worker, the report shall be submitted. Yes.
now only two things, my lord. Kindly see this order on disbursement of the full amount to the
Correct.
ex-worker. Report will be submitted.
Yes.
I don't know whether they have
But I
submitted.
don't, since the winding up order has been stayed, my learned friends has got nothing to do.
No, two
This is with regard to the court and not the official.
Where is
liquidator.
the report?
No, I've
Yes,
got
my
one
lord.
more thing to do.
Because-
I'm so sorry, sir. It's just one thing, man, I've got to do. Kindly see, my lord, these two letters we have written to them on April and May. We are asking them because now the company has come out of winding up. Kindly give us inspection and give us the records, the statutory records of the company should now be given to us, which they are not giving any reply. Kindly see the letter of April and May. Unless we get the records of the company.
How only the winding up has been stayed. The court has not passed an order to return back all the things.
No, my lord, once the winding up order is stayed,
Ah.
the official liquidator is no longer there. The company cannot be in limbo. Then
Kindly see the orders.
Yes.
Therefore, official liquidator shall not proceed with the instant binding proceeding. That's all.
Yes,
The court
any
has not set aside or not directed the give back to you.
My lord, winding up once the winding up order has been kept in abeyance, it is stayed, and they will not proceed. There should be
That let the report come. Then you could go.
contributories are there. My lord, somebody has to take care of the company. Company cannot be in limbo. Now, once we have paid the entire due, there is not a single rupee claim left. Everybody we have
Okay,
paid.
let the report come. Let the report come.
And also they must give us inspection and records also, my lord.
Let the first report come. What is the contention of the
The my difficulty is only thing, my lord, it is a company, my lord, the 1985. And the workers, my lord, whatever available, my lord, address we have, my lord, we have tried to serve them. But most of them, my lord, are my lord, returning back.
The report, what
Yes.
have you disburse? You disburse what?
Only workers are left. Other security creditors were paid.
Everything we have paid. Only for
Only
workers they
are
are
because
supposed to pay.
Okay, whatever you submit the report,
Very
then
well.
we'll see to that.
If they have any
Kindly-
surplus amount, they will indicate.
Kindly
And
give us,
also
my
give
lord,
us
4 weeks
inspection.
time, my lord. 4 weeks time.
And also kindly please direct to give us inspection of the records at least. So that we can take steps with the register of companies in the meantime.
Very well, my
Inspection
lord.
to they- Kindly kindly provide that.
Sessions opening for the petitioners. Sessions opening for the petitioner applicant. Sessions opening for the official liquidator. Counsel for the applicant submitted. Applicant has made 2 representation to the official liquidator for inspection of the document, but no reply has been given. By an order dated 12th of February 2025, this court, while staying the proceeding of the winding up, directed the official liquidator to for disbursement of the full amount to the ex-workers and to file report before this court. Counsel for the official liquidator pressed for time to file a report. In view of the submission made by the counsel for the respective parties, the official liquidator is directed to file the report by on or before 23rd of July 2025.
23rd July.
After serving the copy to the learned counsel for the applicant.
But so far in respect of the inspection is concerned, my lord, I shall intimate to them because the office has totally been transferred.
Official liquidator is directed to allow the petitioner to inspect the record of the company after due intimation.
Lordship is keeping it on
23rd
23rd July.
I'm deeply blessed.
Grateful.
Next.
My lord, in this regard, I am for the official liquidator. May I submit my report, my lord? My lord, here, my lord, the property.
Yes, your
only-
report is ready. Filed.
Yes, my lord, report, my lord.
Who is appearing for the secured creditor?
My lord,
Nobody.
all secured creditors were paid.
Paid.
Only thing left, my lord, the security guards. My lord, page 9, if your lordships kindly see, I have prayed for leave may be please be granted to the official liquidator to pay the security charges of rupees, my lord, 31,84,000 to Modern Safeguard Private Limited out of the sale proceeds. My lord, that is my prayer.
So
And
what is
others,
the
my
amount
lord,
of what is the amount of the sale proceeding?
my lord, if your lordships kindly turns to page 3 crores something, my lord, that is
4 crore.
Yes.
32 lakhs, 72,280.
Yes. My lord, paragraph 11, my lord, kindly see. The last e-auction, my lord, 30th August was third attempt for sale. My lord, where, my lord, buyer is S. Junjunwala, rupees 3 crores 16 lakhs 25,000. This is the sale price.
Upon receipt the full sale consideration from the above respective buyers. So that is the sale price you received.
Yes, my lord. And my lord, the page, if you notice page 7, my lord.
Yes.
Security bills, my lord, which have been, my lord, submitted before the official liquidator, that has details has been given. And my lord, the fund position, my lord, page 8. I have
So fund lying in 24 lakhs.
No, my lord, kindly see page 50, paragraph 15. That the present fund position of the company in liquidation is 2 crore 76 lakhs 61,000 so and so.
So you have
Which
deposited
comes to the
251.
different, yes, total receipts and total payments of rupees respectively is reflected in the statement of accounts. That is,
So
I have
that's why
I have
so
annexed, my lord, annexed
fund position is 2 crore 76 is the total.
Yes.
So you have fixed 2 crore 51.
Yes.
Now in hand 24,000 is there. 24 lakhs 76 in the current account is lying.
Right, right.
So out of this 24 lakhs, you wanted to pay the 31 lakhs to
Right.
the security guard.
Security guards.
Security charges. So and so offering for the official liquidator. Official liquidator has filed the report wherein it reveals that the latest e-auction on 30 August 2024 was the third attempt for sale of the said flat. Earlier two auctions were not materialized due to low offer price for the flat. By an order dated 12th September 2024, this court
74,
confirmed the sale of the immovable property of the company within bracket in liquidation in favor of the loan offerer and successful buyer, namely Priya S. Junjunwala, for a sum of rupees 3, 16, 25, 000, and upon receipt of the full sale consideration from the said successful buyer, the possession of the immovable property has been delivered on 27th of September 2024 to the successful buyer and also been conveyed. Full stop. Counsel for the petition submit that, official liquidator submit that, the security bill has been submitted for an amount of rupees. Counsel for the petition submit that at present the fund possession of the company in liquidation is rupees 2, 76, 61, 290.75, which comes as a difference of total receipt and total payment within bracket rupees 40, 32, 72, 220.35 minus 37, 56, 10, 929.60 bracket goes, which 9 full stop. As per the report of the official liquidator, an amount in the present fund position, the present fund position is rupees 2, 76, 61, 290.70, out of which an amount of rupees 2, 51, 81, 000 is lying in the fixed deposit in the scheduled bank and an amount of rupees 24,79,290.75 is lying in the current account. Considering the above, the petitioner is granted and the official liquidator is granted liberty to pay the security charges of rupees 31,84,487 to the modern safeguard within bracket MP Private Limited out of the sale proceeds within a period of 2 weeks.
Within 2 weeks.
2 weeks. Full stop. The official liquidator shall file the report within a week thereafter. List the matter on 16th July for filing report.
My lord.
Yes.
Not the same matter, my lord. Due to it.
Report filed.
The report is combined, my lord. Report.
Okay, see. So that is the one order will serve.
One order will be served.
Along with this, both the number may be combined. 74, 75, huh?
Yes, ma'am.
73, 74.
73,
74, 75.
74, 75.
Your Lordship, I appear for the official liquidator. May I file my report? Your Lordship, this is an application wherein, Your Lordship, we have paid for the disbursement of the amount. Prayer A and B was allowed earlier. However, that amount could not be disbursed to the Provident Fund Authority because we had sent them the form as required and they had to fill it up with the bank account and all other requirements, which they have not. So we have not been able to disburse that. Now, prayer C, Your Lordship, and D, Your Lordship, I would be praying for C, D, and E, Your Lordship. In the affidavit, Your Lordship, which we have filed, we have, pursuant to the last orders, Your Lordship, we have given, Your Lordship, the particulars of the claim filed by the workers, which is annexed, Your Lordship, from page 12 onwards.
Rearrange Form 70, Rule 667 Companies Act as annexer. That is over.
Yes.
An order may kindly pass to disburse the admitted amount. That is also passed.
So A and B is already allowed, but we have not been able to disburse that amount.
So?
Because they will need to give us the detail. Till they give us the detail, we cannot disburse this amount.
What?
To the Provident Fund Authority.
Who is appearing for the Provident Fund Authority?
Last function, they did appear, Your Lordship.
Priyanka Das.
But today they are not appearing. Now, as if I was praying for Your Lordship, C, D, and E, Your Lordship. Because after, Your Lordship, the distribution
Unless
of the
disburse is made, how it can be?
No, Lordship. This separate, Your Lordship. If Your Lordship takes the summons for directions. So B is, Your Lordship.
B is over.
Yes,
is there, but it could not be disbursed.
Yes, but that amount is there. If Your Lordship sees the report and Your Lordship sees the application itself, we have given Your Lordship the particulars, Your Lordship, as to how the payments have to be made, which is at page 9. If page 11, if Your Lordship kindly takes.
They will provide the details of the account.
Yes.
So these are the disbursement
So
amount.
the amount available, Your Lordship will find 4 crore 11.
Correct.
Then Your Lordship, amount to be paid to 264. After payment of to the Provident Fund Authority, we will still have 1 crore 46 lakhs. Then Your Lordship, workers 38 lakhs. After payment to workers, then again we will have 1 crore 8. Then to the Assam Power Distribution and Deputy Commissioner, Government of Assam. Then through the ordinary creditors, this amount would be left 93 lakh. Now it will be, Your Lordship, 96 because the interest is added, Your Lordship, for this period. Page 11 of the application, if Your Lordship sees once. Your Lordship will find the detail at page 11. The table is given.
Correct.
So the order which we have received is only for this amount to disburse. Yes.
B
But, yes, that amount is already there, but we have not been able to disburse because they have not given us the details. So the rest of the amount is already there with us. We need to disburse. So that's why I prayed for prayer C, D, and E, Your Lordship. Page number?
Yes.
He's
You are the
he's a liquidator. I appear for the liquidator.
but the provident fund is not there. So appearing for the official liquidator. None appears on behalf of the provident fund organization. Police court. The official liquidator has filed the report. Let the same be cut with the report. It submitted that this court has allowed the official liquidator to disburse the admitted amount of rupees 2,64,77,055 to the ATEPFO as but all the the workers has not come forward for disburse of the said amount and is laying
I'm sorry, so not the workers.
that the ATPO.
Yes.
The organizer, the Provident Fund organization has not come forward for the same, and accordingly the same is lying with the official liquidator. Police counsel for the official liquidator prays for order in terms of prayer C, D, and E. E and D. Consider the submission made by the counsel for the official liquidator peruse the report prayer C, D, and E of the summons for direction is allowed. The official liquidator is directed to submit the report within 4 weeks. In 4 weeks, release the matter.
Your Lordship, would your Lordship be pleasure to keep it on 16th of July because I have other matter also fixed. So sorry.
Then 4 weeks will not be completed. By 16th of submitter is directed to submit the report by 16th of July. Lead the master on 16th July.
I'm extremely grateful.
Next.
Millet 77 has come up at my instance, Millet. I had mentioned, Millet. This is appearing before your lordship, Millet, for the second time. Now, Millet, this has come back after Millet one round, Millet, from the Honorable Apex Court. Millet, I hope Millet the Apex Court order is there, Millet. And Millet, may I hand over a copy? Millet, this is the.
Yes.
Now, Millet, this is Millet pertains to Millet not about Datto Millet properties. Millet the family Millet by the Datto family. Millet the company is Millet a family company. Now Millet there was a Millet the promoter director Millet Judhishthir Datto. Millet the Judhishthir Datto Millet is a Millet and Millet I am the son of Judhishthir Datto. Millet Judhishthir Datto Millet had left a will where Millet the entire property of Judhishthir Datto, his portion has been Millet bequeathed to me. Now Millet that was challenged by the other legal heirs. Now Millet in High Court, Millet probate was initially refused. Then Millet division bench Millet granted Millet the probate. Then Millet in appeal court, Millet in Supreme Court, Millet filed by us Millet. There was a settlement reached Millet by and between the parties. Millet on the basis of the Supreme Court order way back Millet in 2000, Millet this court granted probate in 2001 based on the terms of settlement. Now, Millet, the applicant before a lordship in item 77, that is the old number of CA 157, had filed an application before this court. Millet had filed, taken a point that Millet they were not served a notice before the Honorable Apex Court. Millet wrote back to the Millet official liquidator that Millet whatever portion of the money that is being given to the Millet the contributories that should be also given to them. Now, Millet. Initially, that was refused. They came back to this honorable court. Millet that the honorable company court directed the official liquidator to consider their claim. The learned official liquidator considered their claim and rejected because the learned official liquidator has gone on the will, the probate, that the probate has been passed by this court and this is Millet, my client is Millet is the sole beneficiary. Now Millet they came before this court, filed this application in 2017. Millet challenged the Millet order passed by the official liquidator. Now, Millet, this court Millet passed an order that any meeting being called or there being any relinquishment of any amount, 72 hours notice may be granted. Now, Millet, that was being done and dusted. Matter was not being Millet reached. Millet, it has not gone down. COVID came, everything. Now, Millet, suddenly Millet, one of the meeting was called. Milad, it is the allegation by the Milad, the applicant here, that they have not received notice of 72 hours. Milad, they came back before this honorable court. Milad, with some seeking some direction, this honorable court has restrained my client Milad from being Milad, the official liquidator, to relinquish any money in favor of my client. Now, Milad, many observations were made, Milad, by the earlier company court against my client. And Milad, I took a point that Milad, until and unless the contributorship of Milad, the applicant, is proved, Milad, they are not entitled to any notice. Now, Milad, the sole point which has been raised, that they have filed a recalling application of the Supreme Court order where Milad, terms of settlement or compromise decree was passed. They have sought a recalling. That is the order where the recalling was dismissed. Now, Milad, kindly sees the order. Milad, the Honorable Supreme Court has dismissed the recalling in February of this year. Now, Milad, this matter is before your Lordship. Milad, my submission was that before your Lordship, that the prayers which is now being sought for, kindly takes Milad this item 77 CA 22 of 2017 or the old number 157.
Yes, what do you want?
Kindly sees the prayers in the judge's summon.
Yes.
Milad, prayer A is with regard to that probate. Milad, after Supreme Court order, Milad, that prayer A cannot be passed anywhere. Milad, Justice Bhattacharya has already held in earlier order that prayer A cannot be granted by this company court. Kindly see prayer B. Milad, prayer B is also on, yes, official liquidator be directed to disburse the applicant's proportionate share of 1/5. Milad, this has also now gone by because of the Supreme Court order. Now, Milad, C, D, and E, kindly see injunction restraining the official liquidator from making any further disbursement to Atanu Datta. Now, Milad, after Supreme Court orders, Milad, his claim has gone. D, similarly, Atanu Datta be directed to refund. Milad, this has also, Milad, now become infractions in view of Supreme Court order. E, Atanu Datta be directed to produce before the Honorable Supreme Court all the five pleadings filed before Supreme Court. Milad, Supreme Court has now done with the matter. So, Milad, D, E is on, in my humble submission, is also now become infractions. Now, F, when every prayer is directed against me only. Atanu Datta, the respondent number 2, be directed to file before this Honorable Court copies of interlocutory application filed before the Honorable Supreme Court. Done and dusted by this order. So, Milad, this application.
Now, what you want?
Milad, let it be dismissed because they are also not here to press for this.
I'm on behalf of the applicant number 22 in the case CA number 22. Lordship, I was about to seek a passover. My senior is on his way.
You are appearing for whom?
Respond number 2, Milad, against whom? Atanu Datta.
You are appearing for?
The applicant. The applicant whose application was dismissed by Supreme Court.
Applicant means who? What is the name?
Arundhati Datta and Milad Aniruddha Datta.
Aniruddha Datta.
Datta.
I'm representing only Arundhati.
Aniruddha.
Arundhati.
Where is she? Her name is not here. Atanu Datta Ramad. Applicant number 2 is the.
Yes, applicant number 1 is Aniruddha, 2 is Arundhati. She is representing 2.
Yes.
Applicant number 2.
Yes. So, what is your submission?
Lordship, in this matter, I'm being led by Mr. Oveshek Guha. He is on his way. So I was about to.
No, my lord. This is coming after Supreme Court. Milad, this is the second day. Milad, all the order. Milad, kindly see. Milad, all the Milad prayers has now become infructuous. Kindly see the Supreme Court order.
Okay, let it come. Court has to hear. Court has to hear the all the parties. Yes, what is about you?
Lord, it is the dispute, not with the official liquidator. Official liquidator has already adjudicated their claim.
Milad, difficulty is that Milad money was crores Milad now not being given because of the order passed in these applications. Now, Milad, I am suffering. Milad, since February, Milad, the
how you are suffering?
Milad, because Milad, the official OL has been directed by Justice Kapoor, Milad, not to
order.
Milad, that must be in my lord's file.
Which order?
Passed in Milad. Back to this.
No order need be passed in either way of more census into the protect the interim order. Yes. Okay, let it become on next Wednesday.
15th March, 2020. Yes, yes.
15 March
2023. Milad, I think this is the order if I'm not wrong. দিন না কপি অসুবিধা নেই annexure of an application court can consider.
PLG कितना नंबर में है? PLG 82 Valver आगे है ना?
Okay. So in view of this order, the monies are now being held back. Mr. Guha has come.
I'll just I tender my apology, my lord, for not being there. I'll just seek for a week's time.
Okay, next week you come on.
Yes, my lord. Kindly hear out the matter because my lord has already expressed my lord's view on earlier.
I have not expressed any.
Of hearing this application, my lord.
My lord, may I only, I think,
Any date, my lord may fix.
my lord, may I only prefer one? Kindly, my lord, keeps it in at high up in the list, my lord, at 4:30, my lord, this matter will take some
I
time.
will not join.
See,
I'll not.
now I completed up till 27.
Yes, 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 yes. My lord, only thing, my lord, if it's high up, then my lord, we can come back, my lord, have some, because at 4:30, it's true, this can't go on.
Census and suffering for the.
Or my lord, fixes any time, or my lord, high up, my lord.
Number 2. Census and suffering for the respond number 2. And census and suffering for the officer liquidator. Let the matter appear on 25th June 2025.
At the top, my lord.
ये ना after the buyers case का जो भी है उसके बाद रख देना.
78 and 79 all.
3 matters.
After क्या बोलेंगे उसमें buyers case, home buyers case, after the home buyers case, along with CA number along 26 of 2023 and 27 of 2024.
Yes,
2020.
26 and 27.
Okay, come on that day we'll see to. Okay. 23rd, huh?
Lord,
25th July.
my lord, may I request one matter, my lord, item number 82, my lord. Item number 82, my lord, there was some discrepancy in the valuation report, my lord. This is the order, my lord, passed by. Now, my lord, the valuer has come. In the original valuation, there was some discrepancy. Valuer कहाँ गया?
Explain the discrepancies.
My lord, the valuer, my lord, actually sale is pending only for that reason. We are not in a position to, my lord.
So why you not mention if the person is appear in person today?
Just now I have intimated
Mention
by
the first.
May I have your lordship kindly?
एक मिनट दाঁড়ाओ, এটা হয়ে যাক।
Oh, अच्छा, अच्छा.
Yes, what? Where is the valuation report?
Valuation, where is the valuation report?
I've already submitted.
It is submitted with the records. Not very well, kindly keep it on the next week. I do not know.
Do one thing on common. No matter. Come on 25th. Where you are residing?
Hello?
কোথায় থাকেন?
33 Rani Horsham Road, Paikpara.
In Calcutta only, na? Come on 25th. You mention the matter first.
Yes,
I will take the matter.
I shall mention.
May I have your lordships kindly? For the extension of interim order which is expiring today, my lord.
In which?
I'm mentioning upon notice, my lord.
Give.
Number 4 in this matter, lordship. I am opposing the extension, my lord, because the bank is suffering interim order for more than 2.5 years, my lord. Kindly a date fixed for hearing opposition on the part of the company to reply on the part of the my lord.
Completed.
My lord.
Readings completed.
Kindly fix the date, my lord.
Suffering for the plaintiff, suffering for the
And for the defendant of both.
defendant number 4, and suffering for the defendant 1, 2, and 3. Counsel for the plaintiff prays for extension of the interim order. Police counsel for the defendant number 4 prays raise objection and submit that due to the interim order passed by this court, the defendant number 4 is facing difficulties. Consider the submission made by the counsel for the parties. The interim order is extended till 18th of July 2025 or until further order, whichever is earlier. Release the matter on 16th of July 2025 under the heading adjourn motion.
My lord, may I mention another matter, my lord? It is appearing in your my lordship's list as 81 followed by 80. My lord, in this matter, Mrs. Mithua Shin, she is the special joint office, one of the joint office, and she has a special child at home who needs a special attention every time. So, since the matter could not be taken up today also, my lord, I was praying on her behalf that the matter may be fixed and at the top in any day, my lord, so that she can come and
81,
80 and 81, my lord.
81, company matter. Let
It can be fixed on 9th of July, my lord.
Let both the matters appear on 30th of July 2025 at the top.
With Milord's kind leave. Milord's a similar prayer, Milords.
I will hear all. I will hear all. Suffering for the plaintiff. Counsel for the plaintiff mention the matter and submit that the interim order is going to be expired today and paid for extension of the interim order. In view of the submission made by the counsel for the plaintiff, interim order is extended till 22nd of July 2024 or until further order. It is not in the list.
It is not in the list, my lord. My lord, I would come clean, my lord. I would come clean. But what has happened on 10th of June, I was doing the matter, my lord. Due to my fault, my lord, during the dictation of the order, my lord had directed the matter to go out of the list. That is why.
Let the matter appear on. क्या date बोला? 22nd June.
Milords, a similar prayer, Milords, for extension of the interim order, Milords. It's expiring today, Milords.
Suffering for the plaintiff. As per the prayer made by the counsel for the plaintiff, the interim order granted earlier is extended till 22nd of July 20. It is not in the list.
It's not appearing in the list.
Matter appear on 22nd July.
Lord, one prayer from the official on behalf of the official liquidator. My lordships usually takes Wednesday the company matters. My lord, if the list can be provided to the official at least one day before, then my lord, it will be easier because the office is new town. So my lord, it would be easier for them to arrange all these things. If it is convenient to your lordships, my lord.
ना उस लोग को ऑफिस तो बंद हो जाता है ना. हाँ दे दो. एक काम करो ना तो ना मंगल को ना ड्राफ्ट दे दो. I will give my office will provide draft, but really will become.
My lord,
you will know what the matter will become.
My lord, I am deeply obliged.
Take on Tuesday. My officer will convey the draft list to you by WhatsApp, whatever it.
I am deeply.
You contact my office.
I am deeply.